29762 of 25. GMCP.
ಪೆಂಡಿಂಗ್ ಅಲ್ವಾ ಸರ್ ಅದು? ಇದರ ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ 29762 of 2026 25 29762 of 2025 4ನೇ ತಾರೀಕಿಗೆ ನಾನು ಡೇಟ್ ಬರ್ದು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದರಲ್ಲಿ ಮೆಮೊ ಫಾರ್ ವಿತ್ಡ್ರಾಯಲ್ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ಇವತ್ತು ಎಷ್ಟು ತಾರೀಕು ಹೇಳಿ? ಅದು ತಗೊಂಡು ಬನ್ನಿ, ಫೈಲ್ ಸಮೇತ ಮೆಮೊ ಸಮೇತ ಎರಡು ತಗೊಂಡು ಬನ್ನಿ. ನಾನು ಮೇಡಮ್ ಮುಂದೆ ಪ್ಲೇಸ್ ಮಾಡ್ತೀನಿ ವಿದ್ಯಾ ಅವರೇ, ನೀವು ಬೇಜಾರು ಮಾಡ್ಕೊಂಡು ಚಿಂತೆ ಇಲ್ಲ. ಇದು ಫ್ರೆಶ್ ಮೆಮೊನಾ? ಫ್ರೆಶ್ ಅಲ್ವಾ ಹಳೇದಾ? ನೀವು ಬರೀಬೇಕು ಎಲ್ಲ ಡೀಟೇಲ್ಸ್, ಏನಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಅಲ್ಲಿ ಬರೀರಿ. ಏನಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಡೀಟೇಲ್ ಆಗಿ ಬರೀಬೇಕು. ಅದೆಲ್ಲ ಮೇಡಮ್ ಮುಂದೆ ಪ್ಲೇಸ್ ಆಗುತ್ತೆ. ಹೇಳಿದ್ದೀನಿ ಸರ್, ಅಂದ್ರೆ ನಾಳೆ ಏನಾದರೂ ಲಿಸ್ಟ್ ಮಾಡಿಸೋಣ ಇದು.
for which monitoring of captive status will be done from financial year 2025-2026. And the Commission reserves its right to notify the regulations in the matter of verification of captive status as and when required. Land Council with the petitioner submits that a coordinate bench of discourse in WP number 13316 of 2025, clubbed with WP 14646, 260 of 25 and 26022 of 25, 30238 of 2025. By order dated 12 June 2026, has allowed the writ petitions. The order dated 28/3/2025 passed by the KERC. It's the same order.
Indeed, Your Lordship.
Is quashed and directed the KERC to reconsider the matter and frame an appropriate procedure consistent with Rule 3 of the Electricity Rules 2005 and law declared by the Apex Court in Dakshin, Gujarat's judgment. After following the due consultative process and principles of natural justice, till such consideration, no coercive action shall be taken against the petitioners. Then counsel for the petitioner submits that in the light of the said order, nothing remains to be considered
Indeed.
in this writ petition. As a said order dated 28/3/2025 itself is set aside by the coordinate bench of this court. It's accordingly disposed of.
Then number 6, Nagarajas.
The petitioner, my lords. My lords, the petitioners in this case are the plaintiffs before the trial court. They had filed an suit for partition and separate possession, and in that they had filed an application under Order 1 Rule 10 to include the proposed defendant number 10, my lords. The trial court
Is a suit for?
partition and separate possession, my lords.
Who is he? Who is the plead applicant?
Implead applicant is a necessary party, my lords. They are trying to enter into a document which are produced at Annexure E titled as Family Partition Deed, my lords. So the proposed defendant and the defendant, they are trying to create encumbrance in respect of the suit schedule property.
Trying to create, not it created.
They have created, my lords. The document is.
Because there is a difference between trying to create and creating.
Apologies.
Hmm.
If my lords may come to page number 26.
Come to the order impugn, page number.
36.
Page number.
26, my lords.
Let's read the order.
The counsel for the applicant took contention that the defendants and the proposed defendant number 10 are trying to get the partition over the suit schedule properties in order to defraud the right of the plaintiffs. In order to prove the case of the plaintiffs, they have not produced any relevant documents to show that the defendants and the proposed defendants are trying to get a partition over the
Yes,
suit
yes,
schedule
sir.
properties. If my lords may come to Annexure E, my lords, I have produced a relevant document.
Not here. You should have produced it before the court. We are only looking whether the order is correct or not.
Yes, my lords.
The order is correct because you have not produced anything. What is the document?
It's a family partition deed, my lords.
Where is that?
At Annexure E, my lords, page number 22. In
It's a registered document.
Yes, my lords. In page number 26, at serial number 9, the proposed defendant number 10 is mentioned, my lord, Somashekar.
What is the relationship between the parties?
My lords, they are related, my lords. Somashekar is the son of Govinda, my lords.
What is his response?
Serial number
And
7,
summons. All
My lords, I am for the petitioner. I may be permitted to appear online, my lords. But impugned order is at Annexure A, appointing a court commissioner to measure the suit schedule property, which is not permissible in law, my lord.
what is this? What is the suit for?
Suit for declaration and possession, suit for declaration and injunction. And I got an injunction order that has been challenged in the MA also, it has been confirmed. Evidence of the parties is completed. Now, application is filed by the defendant to measure the suit schedule property. That is not permissible in law. All the evidence on the record, I got an admission during the cross-examination of the DW1.
Why the court felt that it is necessary? What is wrong in it?
No, my lord, there is no finding. I will take a lordship to the finding, my lord. At page 16, para 9, this is the finding recorded by the court, my lord. para 9, my lord.
As per the documents furnished by both parties, it shows that there is a conflict between both pleadings as well as elements of the written statement filed by the defendants. At this juncture, if the court commission is appointed to measure the suit, it will meet the ends of justice and it will be helpful for final adjudication.
My lords, here there is no right vested with the dependents. If they are having their property, they are telling, my lord, that may be seen, my lord, this property according to them reserved for a Harijan colony. Harijan colony is not a party here. They are not having the right in the social property.
Come to the application, what is
Yes,
that they want?
yes, my lord. It's in Kannada, my lord. What they are telling, my lord, the gist of that, lordship, I have not seen that. To appoint a court commissioner to see whether 14 guntas of land falling within 57/2 reserved for the Harijan colony. They are not the parties to it, my lord. They are not having right anything. If there is a list between their property, some of the Harijan colony property reserved, that is their case. It is not the subject matter of the suit. My lord, that pleading, para number 8 may be kindly seen, my lord. Page 15. It's in English, para 8. In the application, defendant number 2 stated that the property bearing survey number 57 measuring 14 guntas out of 24 guntas are reserved for Harijan colony. They are not the parties. Nothing. It's a extraneous. It's not a list between the parties.
No, according to them, the property which you are seeking declaration is reserved for Harijan colony.
My lord,
No, the measurement is of your property.
nothing to do with that. If they are having a claim in the property, they can seek for it, my lord. They are not having any right. If
No,
Harijan,
how can now you, with all these documents in Kannada, how do you expect me to understand the respective contentions of the parties?
my lord, a short accommodation will be given. I will produce
Yes,
a, my lord,
this is
delivery.
what I
That's
said.
commissioner warrant is issued. Well, till then, my lord, status quo, my lord. If it is then it's become
No,
infructuous.
no, no, you do it tomorrow. I'll hear it. Without me understanding anything, I'll not grant stay.
Already they have
Tomorrow,
issued the commissioner warrant, my lord.
if not tomorrow, I can have it in the, I will pass over also, but
No,
I will
no.
not, because on the face of it, I am convinced that
Yes.
the order is correct. If you want me to, take a other view, you have to convince me on by placing the relevant material.
It will be placed
When do you want?
20th, my lord, because translation so many pages. 20th may be posted, my lord.
Yes, yes. Not all the papers. I only want IA number,
Yes,
affidavit, and
yes,
IA affidavit, contain your objections,
object. Yes, madam.
and the written
Tomorrow,
statement.
tomorrow I will.
Yes, tomorrow.
Much of that.
Yes, next.
Cell number 8, Ravindranath. Ravindra Reddy.
No representation in the month of September.
Cell number 9, Radha R.
Yes.
The petitioner is challenging the order wherein he had filed a petition, we had filed a miscellaneous petition for transfer of OS from Madhugiri to Kotagiri, my lord. Initially, the petitioner filed a suit for petition in declaration OS 181 of 2021 in Madhugiri. The relief was suit for declaration, my lord.
189.
181 of 2021, my lord.
Hmm.
Later point of time, the respondent hearing
21 on the file of
Madhugiri, Court of Madhugiri.
seeking,
Senior
what is the
citizen,
relief?
Madhugiri.
Relief.
Relief.
Relief is a declaration suit.
Then
Respondent filed a OS 250 of 2024 before the Kotagiri Civil Judge Kotagiri seeking for the relief of partition, my lord. We had filed a petition for seeking for the transfer of 250 OS 250 of 24 from Kotagiri to Madhugiri, my lord. That has been rejected, my lord.
come to the order.
Page number 11, my lord. Orders. But reasoning is at page number 23 at para number 14, my lord.
Read it. According to the court, both the suit scheduled properties are not one and the same.
Same.
Then in that case, why should it be transferred?
My lord, but survey number 36/5 is, we are seeking for declaration. They are also seeking, when we look into the plaint also there, if the contradiction judgment will come, my lord.
Survey number 36/5, measuring 5 acres, 15 guntas. And the suit for partition is survey number 36/1, measuring 3 acres, 17 guntas.
But when we look into the plaint, my lord, when you look at the plaint,
So what about the pecuniary jurisdiction?
even that, because higher court, because the Madhugiri court is a senior division, my lord, even the senior division can try the suit of the trial civil judge of junior division, my lord, because pecuniary jurisdiction has a control over those, because contradiction judgment has come now. The suit in that suit
And what
property.
is their right of appeal?
Lord,
What about their right of appeal? From junior, a case
we
pending
are-
on the
we
file
are-
of the junior division,
will be.
they will lose their right of appeal.
But contradiction judgment comes now, we have to fight on both ways, my lord.
And you already, one is of 21, other is of 24.
Yes, my lord.
There must have been considerable gap between where the proceedings are standing as on today.
But in both matters, the evidence has not been certain.
Since properties involved in both the suits are different and pecuniary jurisdiction of both the suits are different, both the suits can be tried separately and there is no need to transfer the suit to any one of the court. What is the relationship between both the parties?
Some of the parties are related, means they are reputation, my lord.
You are the plaintiff or the defendant.
I am the plaintiff in OS number 120, 181 of
That's your declaration suit.
that for declaration.
Hmm. And this plaintiff in 250 of 2024 is a party to your suit?
Some of them are parties, my
Not
lord.
some of, plaintiff is one.
Plaintiff, Lakshmama.
Because defendants are parties, you will not ask the plaintiff suit to be transferred to you. Yes, please come. The petition is before this court. Agreed with the orders passed in civil miscellaneous number 19 of 2025, dated 10th March 2026 by the principal district and session judge, Tumkur. The petitioner herein has filed OS number 181 of 2021, seeking a suit for declaration and injunction. And another suit is OS number 250 of 2024, seeking partition. According to the petitioner, some of the parties in his suit and the parties in other suit are one and the same. As such, the OS number 240-50 of 2024 shall be transferred and tried along with OS number 181 of 2021 that came to be dismissed by the court by order impugned. The court has observed that both the properties are having different market value and comes under different pecuniary jurisdiction. Since properties involved in both the suits are different and pecuniary jurisdiction of the both suits are different, both suits can be tried separately and there is no need to transfer the suit to any of the court. The petitioner has not made out any grounds to transfer the suit to anyone of the court and accordingly dismissed. Learned counsel for the petitioner submits that as the parties are common in both the cases. As some of the parties are common in both the cases, to avoid the conflicting judgments, it is necessary to transfer the case. Next para. And in the same way, the court has failed to consider the case of the petitioner and dismiss the application. Next para. Having other counsel for the petitioner, there is a material non-record. One suit is for declaration, the other is for partition. Suits are pending, one on the junior division and other on the senior division. The plaintiff in the partition suit is not a party to the petitioner's suit. In those circumstances, the submission that as one of the properties or one and the same, this has to be transferred to where voice number 181 or 2021 is pending, has no legs to stand, and the courts have rightly considered and dismissed, no reasons to interfere. Yes, next.
Number 10, Sridhar.
I am for the petitioner, Your Lordship. I am for the plaintiff. The suit is for partition and separate possession, Your Lordship. In this one, I have filed the 6 Rule 17 application to amend the 6 Rule 17 application. Your
When was
Lordship.
the suit filed?
Suit filed on 13/5/2015, Your Lordship.
2015. When is the amendment?
28, 2025.
You said the suit is for partition.
Yes, Your Lordship.
What is the amendment you want to seek now?
Your Lordship, in the client, we have sought for the prayer that day to declare that registered sale deeds dated.
Come to your appeal, I mean, the affidavit. Affidavit filed in support of the IA.
Yes, Your Lordship, Annexure C.
Page number.
Sorry, Your Lordship, the papers are missing.
This is the order. Annexure C is the order. I'm asking about your affidavit. Page number 31.
Kindly, few papers are missed, Your Lordship, while complying the objections.
You want to question a sale deed dated 24/6/2013.
Yes,
In
yes, Your Lordship.
2026.
No, Your Lordship, the prayer has been sought earlier itself. Now only they have to add it with the collusion of different number 30. Kindly, Your Lordship.
Where is the original plate? What is the prayer you have sought already?
Kindly, Your Lordship, but Annexure
Where the
A.
registered sale deed dated 15/2/1986, 25/1/1995, 24/6/2013 are not binding. And what is the addition you want now?
We sought for additional after para number 4. 4A has to be added, Your Lordship. That is
The
kindly, Your
plaintiff further
Lordship.
sub defendant, tenant, family member, that is defendant number so and so, have created, concocted, fabricated the alleged sale deed dated 24/6/2013 in respect of the suit property.
And even
Already you have taken the plea. Why do you want it?
actually, council has filed, Your Lordship. Only the context is we have taken plea, pleadings is there, but regarding the collusion of the each other defendants, that has to be come out.
Come to the impugned
And
order.
also defendants has not filed any objection.
Come to the
Im-
impugned order. Page number.
Sorry, Your Lordship. Our orders on IA number 13.
Page number is not there.
Sorry, Your Lordship.
When counsel for the petition submits that when an application is filed under Order 6 Rule 17 seeking amendment of the complaint, only stating that the respondents in collusion, the defendants in collusion with others have brought a document in existence. Except that they're not seeking and they're not introducing any new other facts. Already they have sought the relief that the said document is not binding on them. The defendants have not filed their objections. In spite of that, the court, without considering the same, had dismissed the application. Hence, present petition. Considering the submission, they shall be stay of all further proceedings pursuant to so and so notice and summons. Yes, next.
Channel number 11, Sunil S. Narayan, for petitioner.
Yes.
First defendant's writ petition. Suit for partition and separate position. I have filed at WS after 120 days, same came to be rejected.
With how much delay?
Delay is that summons was served on 1/8. I appeared on 21/8, but WS not filed as was on 10/11. I filed on 12/3.
3 months delay.
3 months.
Please come. Suit of which year?
Suit is of the year 2025.
Before amendment or after amendment?
Suit is filed on 8/7.
Land counsel for the petitioner submits that the court has failed to take the written statement on record as the same is filed beyond 120 days. Land counsel submits that a coordinate bench of this court, considering the amendment to the CPC, has held that the court can consider the delay. Court has a discretion to consider the delay based on the facts and circumstances of the case. Considering the submission, there shall be stay of all further proceedings, notice and summons. Yes, 12.
Number 12, the Prakash for petitioner.
These two petitions emanate from the same proceedings. One is application for rejection,
We'll see page 12 first.
12. 12 is 370, that pertains to the rejection of my application for amendment.
Where is the
Amendment is made, and I produced the certified, the translated copy, my lord. I've given the translated copy of it. Because everything, the proceedings are in Kannada before the trial court.
Yes.
Uh,
Suit is of the year
Suit is
2015.
of 2015, the amendment is sought in February 25, almost 10 years later. Evidence was complete. So, and again, it
What
was,
is the amendment?
amendment was under a misconception, survey number 101 was inserted in the schedule, which is not in existence at all. May I, for a moment, take your lordship's attention to the plaintiff? Of course, the number can be registered. That is at page number 55, my lord. It runs to about 3 pages, the plaint. The last of page 55, the schedule portion.
The present application has been filed after the conclusion of the evidence
Oh, yes,
and the matter has been posted for final arguments.
arguments, yes. Then now I am told that
Interlocutory
it got
application.
reopened. For a moment, my lord, page 55.
No, what is the purpose now? Basing on that survey number, the entire evidence is let in. Everything is over. Now, why should it be reopened now?
I can understand the difficult, my lord, because I know it's at a belated stage, but it may support my case in the sense 101, survey number 101. For that reason only, I request your lordships to page 55 just for a
No,
moment.
what I'm saying is survey number, basing on survey number so and so, you have let in evidence, everything is heard, matter is posted for
And
judgment.
a totally misconception throughout. So that is why I also made an application for seeking for an appointment of a commissioner, which is the writ petition, second writ petition. Whether it is, where does
So
101
inconsistently, you can't take it now.
I know the difficulty. Since there was some confusion among the records itself, whether it is my survey, my property lies within survey number 85 or P10, or it is in the plaint, it is said resurvey number 101, which accordingly doesn't exist at all after the reading of the evidence. So I just wanted this survey number 101, resurvey number 101 to be deleted at all. That was the limited scope for amendment. Anyway, the court rejects it, of course.
Rightly. Please come. Agreed with the order passed in I number 22, invoice number 583 of 2015, dated 5th June 2026. By the first edition Civil Judge and JMFC Chandai Patna, the petitioner plaintiff is before this court. The petitioner had filed the suit seeking relief of declaration and permanent injunction in respect of the suit scheduled property. The suit is filed in the year 2015. In 2025, an IA is filed seeking amendment of pleadings. It is the space that In original survey number 85/B1, the property covered under the sale deed was originally granted to Hanume Gowda, son of Javari Gowda, in original survey number 85/B-1. Subsequently, owing to an erroneous correction in the revenue record, the survey number came to be shown as survey number 101. The said property was thereafter sold by Hanume Gowda to the first defendant, Chenna Boregowda. In the boundary, the northern boundary has been mentioned as survey number 102. The said survey number 102 was originally granted as survey number 85/B2, which was also subsequently and erroneously corrected as survey number 102. As per P34, in case number 305/2021-2022, on the file of the Joint Director of Land Records, Mysore Division, Mysore, survey number 102 has been cancelled by a specific order. In the same manner, survey number 102 is also liable to be cancelled. Both survey number 85/B/1 and at 85/B-2 were wrongly corrected and renumbered as survey number 101 and 102 respectively. They are situated at a distance of 300 to 500 meters from the sue scheduled property and are in possession of different persons. Since survey number 101 has been shown as being in existence, it has become necessary to carry out the amendment that came to be dismissed by order impugn. While dismissing the application, the court had observed that the present application is filed after the conclusion of the evidence on behalf of both the plaintiff and the defendant, after the suit has been posted for final arguments. At that stage, the plaintiff filed interlocutory applications, produced certain additional documents during the further examination of the plaintiff's evidence, and got the documents marked as exhibits. Thereafter, when the matter was posted for further examination of the plaintiff, the present interlocutory application came to be filed. The present application has been filed only after the conclusion of the evidence on behalf of both the plaintiff and defendant. Upon consideration of the proposed amendment sought in the application, it is evident that application is filed with the object of rectifying the deficiencies in the plaintiff's case and the shortcomings that emerged from the evidence adduced on behalf of the defendant. Therefore, the court is of the opinion that the application has been filed with the intention of curing the defects, omissions, or infirmities in the plaintiff's case by way of amendment. If the proposed amendment is allowed, it would alter the nature and character of the suit. Further, the same would cause irreparable prejudice to the defendants. Moreover, the contention of the defendants that the present application has been filed only with the intention of delaying the proceedings cannot be brushed aside, and accordingly, court had dismissed the application. When counsel appearing for the petitioner submits that, basing on the survey and the resurvey, the petitioner is only seeking correction of the survey number. It would not prejudice the defendants, and the court ought to have allowed the said application. The court had dismissed the application more on technicalities. Next part, having heard the counsel for the petitioner, peruse the material on record. The suit is of the year 2015. Suit is for declaration and injunction. The entire evidence is adduced. Matter is posted for arguments. At that time, this application is filed. Basing on the survey numbers as mentioned in the plaint, the parties have latent evidence, and at this point of time, seeking amendment of the said pleadings is nothing but, as rightly observed by the court, to fill up the latches or introducing altogether a new case which is not permissible, and the court had rightly dismissed the application. This court finds no reason to interfere. Next.
Number 13.
What about 13?
This is about appointment of a commissioner, just to.
In respect of, consequent to that.
Yeah, subsequently,
If that
earlier to the amendment application, they had made an application. The appointment of commissioner only sought where does this survey number 85 and 101 exist, just to demarcate it. That's all the limited question.
What will happen is that whether 101 or 89, the court has, your amendment itself is not dismissed.
That's right.
In the same order, two petitions were filed. One is that. Then this order also. This is arising out of IA number 22. No, not IA number 22. What is this, I number 15?
I number 15.
Dated 12th August 2025, whereby the court has, where the petitioner has sought for an appointment of advocate commissioner, whether the property falls under survey number 88 or 101.
85 bar P10 or and 101. Just to measure both the existence of.
Then after that, after this, the earlier case order, in the light of the fact that the amendment itself, the court has dismissed that, no further orders required to be passed in this, accordingly dismissed.
Then number 14, Yashwant Sajjan Gowda.
For petitions.
Yes.
My lords, just I have filed section 28 of specifically fact before an execution petition, my lords, for not complying the orders passed by the court to deposit the amount within a prescribed period of time, my lords. My lords, the case, the decree holder filed a suit for specific performance, my lords, in the 1993, next subsequently renumbered as 2000, my lords, and it was dismissed, my lord. Subsequently, they filed an appeal in RA, and it was allowed. Challenging that the judgment, the father of the judgment debtor has filed an appeal before this honorable court, and this honorable court partly allowed the appeal and directed the judgment decree holder to deposit additional amount of 1 lakh along with the remaining amount what he is supposed to pay before the trial court. And they have given a 6 weeks time was given, my lords.
When was the order in the RSA?
2011, my lords.
Dated?
17/6/2011, my lords.
How much time was granted?
6 weeks, my lords.
Thereafter, what
Thereafter,
happened?
once again, they filed an application for 6 weeks, extension of 6 weeks. And they, once again, they failed to make a payment, and then once again, they filed application for extension of deposit of 1 week. Then 1 week time was granted. And subsequently, they claimed that, my lords, they have deposited the amount in the year 2011. On 13/9/2011, in RO number 0,
Deposited, yes.
before the trial court, my lords. But, my lords, it was not at all available at that point of time, my lord, on that date of deposit. Subsequently, my lord, my father, the defendant, and then my sister was died, my lord. Then we come on record, my lords. Then we filed an objection to the this application in the year 2023. Then after that, my lord, it was observed that, my lord, the trial court.
Right from 2011 till now, the sale deed is not executed.
No, my lord, they are in possession of the property. The agreement holder is in possession of the property. They are enjoying the property, my lords.
So the fact remains is they have deposited the amount. Whether you are aware of it or not, but it is deposited.
They claim that that was deposited on 13/9, my lord.
Like claiming it will be, the record will speak.
Yes, my lord, that 13/9, but 13/9 it is not deposited, my lord.
Order, come to the order.
Section 28, my lord, system I permitted to read section 28.
No, first let's understand the reasoning given by the court before going into section 28. Come to para 11, page number 32.
Yes, ma'am. Yes, ma'am. Page number 22, my lords, the impugn order, my lord, just. My lord, just in this case, the observation made in para 37. The trial court's observation as page number 37, internal page number 16, my lords. It commences from page number 36, para 16. The court, I may permit it to read, my lords.
Come to para number 18, from that you can read.
My lords.
Para number 18.
18.
Yes.
18, yes, my lord. And this application under section 28 of Specific Relief Act is filed on 29/2023, which is nearly 12 years from the date of deposit. If the notices produced by the judgment debtors themselves are appreciated, a notice was issued them by the decree holder on 8/11/2011, intimating about the deposit and calling upon the original judgment debtor to execute a sale deed. In the said notice, the RO number was mentioned as 080142, which is the same as stated in the letter received from the office of the principal senior civil judge and CJM Davangere. Therefore, when the original judgment debtor was aware in the year 2011 itself about the deposit, he kept quiet without questioning the said deposit in nearly 12 years. And now this application is filed for rescission of contract. In the statement of objection filed by the judgment debtor to the execution of petition, which is stated in dated 24/3/2018. It is contended that the decree holder is issued a notice on 8/11/2011 about deposit of the amount, and also on 10/3/2011 and 26/3/2012. The judgment debtor, due to old age, was unable to meet the advocate and take proper steps in respect of the legal notices. It is also contended that the decree holder failed to pay the amount of 1,85,000 within 6 weeks from the date of order, which is dated 17/6/2011. I have gone through the judgments relied upon by the learned counsel for the judgment debtors, and also through the principles lied on in those judgments. It is held that these judgments under section 28 of the CPC
I
is
think this petition shall be dismissed with cause. What
Pillar-
is this petition? Why did you file? You file execution, this application itself, after 12 years.
My lords, just
This section 28.
my lords, when it is found that matter, it is not they were not deposited on the date of hearing, my lords. The date of what
2012.
they have mentioned, my lord.
2011.
But my lord, just I may permit it to page number 16, para number 16. The court ascertained that whether the deposit was made in the court of the principal civil judge and CJM, the Davangere had written letter on 22/11/2024 to ascertain the RO number 080142 dated 13/9/2011. The reply was received on the said date, said court on 29/11/2024, wherein there was a mention that with the reference to OS number 227 of 2000, the CCD register in CCD serial number 591 of 2002, RO number 0801421 dated 23/9/2011. There is a deposit of 1,85,000.
What else you want?
Because my lord, the amount was deposited in the on 23, my lord, and the RO number is also different, my lord. When we verified that, my lord, we were not aware of the things, my lord, that was deposited, my lord. When they deposit the, my lord, as per the law, my lord, they supposed to intimate us, my lord. When they have intimated through notices, my lord, the RO number and date was completely different, my lords. And at that point of time, my lord, they have filed an application before this honorable court for
Cannot
extension.
be a ground for signing the contract under section 28. The court was right. 2011 money is deposited. Now you come in 2025 and say that now you file an application under 28.
My lord, the intimation they were supposed to make, my lord, they have not done, my lord, properly in the proper manner, my lord.
Now,
That
in
is
my
one.
opinion, the original judgment debtor, having knowledge about the deposit, which is evident from the notices issued to him after the deposit, cannot contend that there was no notice on the application to him.
Yes, my lord, as per the notice, my
When
lord,
was the notice to you?
2011, my lords.
So
But the notice-
2011, you have notice about the deposit of money. You don't withdraw that amount.
But the thing is, my lord, the date what they have mentioned on the date of hearing, on the said date, my lord, the amount was not deposited, my lord. They mentioned the date of 13/9/2011, my lords. But as per the contention, as per the records, my lord, it is 23/9/2011. And RO number is entirely different.
From 2011 to till now, without withdrawing that money.
My lord, the date is, it was not available, my lord, in the records because the date was completely different and the RO number was different, my lord.
Yes.
That was, that is the humble submission, my lord. That is the reason, my lord, just challenging that, my lord, just I filed this.
Please come. Read with the orders passed in. Execution number 7 of, in I number 7, in execution number 7 of 2017, dated 19th February 2026. The judgment debtor is before this court. The judgment debtor, the petition herein, has filed a petition seeking rescission of the contract of sale dated 3/6/1992 that came to be dismissed by order impugned. While dismissing the application, the court observed that the application under Section 28 of the Specific Relief Act is filed on 29/20/23, which is after 12 years from the date of the deposit. If the notices produced by the judgment debtors themselves are appreciated, a notice was issued to them by decree holder on 8/11/2011, intimating about the deposit and calling upon the original judgment debtor to execute the sale deed. In the said notice, the RO number is mentioned as 080142, which is the same as stated in the letter received from the office of the Principal Senior Civil Judge and CJM Davangere. Therefore, when the original judgment debtor was aware in the year 2011 itself about the deposit, he kept quiet without questioning the said deposit for nearly 12 years. And now this application is filed for rescission of contract. The court observed that even under Section 28 of the Specific Relief Act, under Section 28(1), when a decree for specific performance of contract for sale or lease of immovable property has been made, and the purchaser does not within the period allowed by the decree or such further period as the court may allow, pay the purchase money within which the court had ordered him to pay, on such application by order resign the contract. But in the case on hand, it has to be appreciated that a sum of rupees 1,50,000 was ordered to be paid as additional amount to the vendor in RS number 99 of 2005. The consideration which was balanced as per the agreement was rupees 35,000. Though this is 35,000 was not deposited by the decree holder after passing of the decree in RA number 15 of 2001, but the High Court granted 6 weeks time from the date of the order in RSA to deposit a sum of rupees 1,50,000 plus 835,000. The judgment debtor has not objected to said order made for deposit on 17/6/2011. In the affidavit sworn to in support of this application, that the copy of the application which was filed on 3/8/2011 was served. Therefore, it appears there was no objection to the said application on the said date also. According to them, there was no notice to the judgment debtor. The court has observed that the original judgment debtor, having knowledge about the deposit, which is evident from the notices issued to him after the deposit, cannot contend that there was no notice of the application to him. Therefore, the deposit having been made by the decree holder within the permitted time before the court, the judgment debtor now cannot contend that the deposit is not made within time and they had no notice of the same. In this petition also, the judgment debtor appeared in the year 2018, but till filing of the present application, no objection was raised by the judgment debtor about deposit of the consideration amount. The judgment debtor has kept quiet after deposit of the amount in the year 2011 for more than 7 years. Still, his appearance in this execution petition with knowledge about the deposit. Therefore, the petitioner judgment debtor has not made out a ground for allowing an application under Section 28 of the Specific Relief Act and accordingly dismiss the application. Next paragraph. When counsel appearing for the petitioner submits that the court has failed to consider the fact that the amount is not deposited as per the orders of the court and the petitioner has no knowledge about the same. As such, they have sought for signing the contract under Section 28 of the Specific Relief Act, which was not considered by the court, and dismiss the same. Next paragraph. Having heard the counsels on either side, there is a material on record. Admittedly, this amount is paid in the year, amount is deposited in the year 2011. And before that, the decree holder has sought for extension of time, which was granted by the court, and the petitioner has not filed any, has not taken any objection. The court has also recorded about the notices that were exchanged and the notice of the same to the judgment debtor way back in the year 2011. And the execution is filed in the year 2017, and the present application under section 28 of the Specific Relief Act is filed in the year 2023. Considering all these aspects, the court had rightly considered and observed that the amount is deposited long back, and now the present application is not, and there are no grounds to entertain the application. The considered opinion of the court has rightly considered and passed orders. No interference is called for dismissal.
Till number 15, Sudesh Kumar Acharya for petitioner.
My lord,
Yes.
this is the Friday I concluded the argument, my lord, with
Yes,
regard
yes.
to which why this matter was posted for judgment, and your lordship wanted to know the online, my lord. But the fact reveals that, my lord, on 5/2/2026, my lord, the notice was ordered to the respondent. And on 7/2/2000, on 13/2/2026, they filed the wakalatnama on behalf of the respondent. And on that day, I pressed into service the application. They took time for filing the objection to my application, my lord. On 3 occasions, my lord, on 3 dates, it has been adjourned for filing objections to the IA. And my lord, on the 2/3/2026, my lord, both of us argued the matter. And my lord, 18/3/2026, now the present impaired orders before your lordship. By passing the order, my lord, the learned appellate just said, please call for the LCR. So admittedly, my lord, at the time of passing the interim order for rejecting the application, the learned judge was not having the assistance of LCR at all. After passing the order, learned appellate judges call for the LCR. Now, after passing for the LCR, my lord, 3 dates, my lord, the case has been posted for awaiting the LCR. And surprisingly, my lord, on 9/4/2026, the no LCR received, argument to be heard on merits. And after that, 16/4/21/4, the case has been posted for arguments. And my lord, after vacation, the matter has been posted. I am before this honorable court. I submitted to the court that my writ petition is filed challenging the said order. And my lord, the argument notes has been received from the respondent counsel. Now matter is posted for judgment. Well, it is nice. Section 96, does it speak in this way, my lord? Passing the appellate jurisdiction judgment passing this way, without the assistance of the LCR, arguments on merits, as if, my lord, this honorable court dealing with the subject like that, argue on merits. The learned appellate judge has to exercise his mind well on the, now your lordship, on the merits of the application, I convince your lordship on the reason that, my lord, the application is not.
I want you to argue on the matter is whatever right, wrong, the matter is posted for judgment.
It's not
So these are
delivered.
all
It's not delivered, my lord.
delivered.
And that is why I want to bring to the your lordship notice about this, my lord, this way of the dealing with the subject.
That is,
No LCR,
we will look
no
at it on-
arguments, written arguments from the other side.
it on the administrative side, on a judicial side. So the matter is
Hello.
posted for judgment.
Well, when the parties wants to demonstrate their case in a proper manner with the assistance of the record, my lord, would the appellate court justified in proceeding this way, my lord?
But those are
That
all
is
the-
why, my lord, I am calling for your lordship supervisory jurisdiction, but to
Those are
stop all
the-
this.
Those are all the grounds which are available to you when you assign the order of the appellate court.
Well, why should I again come to the appellate court, man, in the regular second appeal urging all
Understand,
these,
I can
when I am
only-
before your lordship?
I can only pass orders in the light of the settled law. I
Well,
can't-
your lordship may set aside this order, man, by remanding the matter afresh to hear the application on
I asked
merits
you-
with the assistance of the LCR.
To look at the judgment and assist the court.
Well, when the court finds that, well, the way in which the matter has been dealt in by the lower courts, well, your lordship hands is very vast with exercising the supervisory jurisdiction.
That is the only submission.
No, well, I will produce the entire order sheet for your lordship perusal if not. I have to note down the entire dates. So this is the way the matter has been dealt with, my lord. I know, my lord, with regards to judgment is concerned, my lord, I know. But in this specific case, my lord, specifically this case, well, this is what happened. Well, denying the defense, denying the arguments. And my application is passed, my lord, in the improper manner, in a premeditated manner, as if, my lord, I know the result. Well, now the learned appellate judge, my lord, has came to the jumps to the conclusion without there being assistance of the LCR that, my lord, I am in permissive occupation. No records. No evidence has been dealt with. No evidence is before the court. I will argue, hear the argument on merits. Whether that could be done, it is for your lordship's conscience to, my lord, whether to interfere in the present matter. I want is, my lord, let there be a remand order, my lord, let the judge consider this. I will cooperate with the court, your lordship to fix a time-bound manner.
Heard is heard.
Till number
The
15.
judgment, is posted for judgment.
Because you want me to pass an order, I'll pass. But
Well,
I'm
if your lordship
indicating that
reserve,
what
well,
I'm
if
going-
your
I'll
lordship
consider all the, that's why I'll
if
consider
your
all
lordship
those.
reserving the matter means it gives another meaning, my lord, that my lord, the judgment will be pronounced. Your lordship has assist the my lord, the parties in this way, because I am bringing to the notice of your lordship about the impropriety done in the proceedings.
Yes, dismissed.
Chair number 16, Bhuvan KP.
Yes.
My lord, defendant's 10th writ petition. So defendant 10 died during the pendency of the suit, my lord. Lellars has come on record. They filed additional written statement by way of counterclaim to amend the Order 6 Rule 70.
Suit is of the year 2017.
Yes, my lord.
What is the suit for?
Suit for declaration and position. My lord, declaration and position. The plaintiff's father sold the property in favor of my uncle in the year 1968. Survey number 14/2. By oversight, it has been typed as 14/1. That is the only typable error. And remaining 14/1, already defendant number 9. Yes.
All that not necessary. Come to the present application.
Yes, my lord. Kindly see that page number 19, my lord. Of my application, I'm seeking only to declare we are the absolute owner of the property by way of counterclaim. The nature of chief.
Already written statement is filed.
Yes,
All
my
the
lord.
defenses are taken.
My father filed.
By the original defendant.
Yes, my lord.
No, what is this case after these many years filing a counterclaim because you have come on record now?
No, I came on record as a legal representative of my father.
That's what.
So I have stepped in the shoes of my father. I have right to file a written statement, additional written statement. In my additional written statement, I sought by way of amendment counterclaim.
Yes, please come to the order.
Yes, my lord. Kindly see that I already addressed arguments. This honorable court expressed regarding judgment on this point. On this point regarding judgment. Kindly look.
Take that.
There is no changing of nature of the property, my lord.
Seeking a counterclaim, according to you, there is no change in the cause of action.
My lord, my father filed a written statement stating that we are the absolute owner of the property. Only it has been mentioned, and the suit is not maintainable. As avoid entire facts. Only I am seeking amendment by way of counter.
That is good. That doesn't mean only. It's not only an amendment. You are seeking a. You are in a way you are filing a suit like you're seeking a separate prayer.
Yes, my kindly page number 19, my lord. That is the contention of my.
This judgment. What is that you are relying on? They have relied on a judgment of the Apex Court.
Yes, my lord. Not Apex Court, my lord. Bombay.
That is Ashok Kumar so and so 2020 through 2 SCC 394. That is what is extracted by the court. Supreme Court judgment.
Yes, ma'am.
And now you rely on a Bombay High Court judgment.
Yes. My lord, the facts.
Say how the judgment doesn't apply to you. You can't rely on some other court. You have to rely on the Supreme Court judgment.
Supreme Court judgment regarding a limitation, my lord. This is a point.
Yes.
There is no limit. There is no limitation, my lord, because I came and recorded.
It is extensively dealt with. Why can't you place the judgment before me?
Yes, my lord. Tomorrow, day after tomorrow.
It can't keep on. I can't keep on posting the matters. Same matter again and again.
Yes, yes.
This is matter in the month of September. Yes, next.
Cell number 17.
Tomorrow or day after tomorrow. Or in the trial next week, any date, my lord. Next week date.
There are so many matters.
Yes, yes,
for this purpose. There is a Supreme Court judgment discussed and relied on by the court without.
No, my lord. The Supreme Court judgment referred in this case, my lord.
It is correct or not? It applies to that or not? I have to see.
Yes,
for
yes,
that you have to place it. This is matter in the month of September. No,
next week.
Yes.
Next week, my lord.
Not possible. Yes, next.
My lord. Otherwise, the trial court matter is going on.
Pass over. Get the judgment.
Manu Prabhakar Kulkarni, 17.
To the petitioner in this matter, my lords.
Yes.
My lords, this is that petition with respect to where the plaintiff, which is the petitioner, is a landlord. The tenant is a foreign national who has been deported from the country. My lords, therefore, it filed an application for recovery of possession. My lords, if I may request for a short accommodation to Thursday, I have just received instructions with additional documents which I want to place before your lordships with a memo.
No, what is the prayer? I didn't get it.
My lords, I had filed an application before the trial court asking for recovery of possession, my lords. My lords, what has happened is now on the last date of hearing, they were to file their objections. They have not filed their objections and the matter is now adjourned again to 8th of September. My lords, there is urgency in the matter because firstly, respondent who is the tenant has been deported from the country and the flat is locked. Secondly, my lords, the lease has expired. So today,
Come to the order impugned. Where is what is questioned before this court?
my
Page
lords,
number.
at page 30.
Page 30.
Please, my lords, of the writ petition at page 30. It's just the daily order, my lords. Annexure A, my lords.
Case advanced at the instance of the counsel for the plaintiff.
Yes,
Defendant absent, counsel absent, counsel filed application
please.
under order 12 rule 6 of CPC for objection.
Please. My
Where
lords,
is the order?
My lords, what had happened on that day, my lords, is I had filed an application.
Oh, where is the order?
My lords, this is the order that I have, on the basis of which I filed my writ petition, my lords. My grievance is that there is grave urgency in the matter because my flat.
What is an appeal of, what is an order under 227? Is it an order? Does it qualify to be an order?
My lords, I understand, but the grievance because of which I have come before your lordships is that my application, which is pending before the trial court, is not being taken up with urgency, my lords. My lords, the matter was adjourned to 25th of July. On 25th of July,
What application is not being taken?
my lords, I have filed two applications. One, I have filed for judgment on admissions because they admit that I am the
When did
landlord.
you file that application?
My lords, I filed that on 29th of June, my lords.
29th June you file and August you are here.
Please, my lords.
Why the court, the trial court or this court has no work?
My lords, the difficulty that I'm facing, my lords, is that the flat is
This is
remaining blocked.
unreasonable. This is unreasonable because one can engage an advocate for everything. You can't come to the High Court like this. 29th June, you file an application and by this time you want the court to be a court to hear everything.
My lords, the only difficulty I'm facing is that the defendant, who is the tenant, has been deported from the country.
Whatever
The
it
flat
is, court requires time to adjudicate it. It requires to take the objections of the other side.
My lords, the difficulty that I face is that one, there is a leakage that is happening in the apartment, which is damaging my neighbor's property. I'm unable to even enter the apartment to fix that. On top of that, my lords, the defendant has not paid me
Then
rent.
for that, you have to file an application which the court can pass orders.
Please.
Pass a judgment on admissions and all,
My
just
lords,
like that the court can do.
I have also filed an application under section 151 for recovery of possession to enable me to go because the lease has also expired. So as of today.
And now, what is that you sought? Please come to the prayer.
Please.
What is the prayer you are seeking before this court? To set aside the order. What is that to set aside there?
My lords,
To set aside the order dated 29/6/2026.
My lords, it was the time frame, my lords. Because while I have expressed the urgency before the learned trial court,
It
unfortunately,
should be a mandamus writ petition. What is this setting aside the order and all?
my lords, I have sought for also that to allow my application, my lords. Because of the urgency, my lords, I understand that this is not a regular situation. This is an extraordinary
Oh,
situation.
no extraordinary. In CPC, there won't be any extraordinary. This is not a writ under 226, extraordinary jurisdiction. It is not. Please come.
My lords, if the matter may be on Thursday, my lords, I
Not
have some
required.
documents
The
or if
present
I may be
petition is filed,
permitted.
seek the following prayer.
My lords, if a time frame may be fixed, my lords.
The reliefs, the relief number 2, to set aside the order dated 29/6/2026. This court is not inclined to pass any order, and that is not an order in the eye of law which can be set aside and on which a writ petition can be filed before this court under 227. Then the relief number 3, to issue a writ permitting the petitioner to immediately enter the property and record the physical portion of the property by break open the lock if required. That also cannot be passed by this court. Then 4, directing the expeditious consideration and disposal of I number 7 filed under section 151 CPC. And also I number 8 filed under Order 12, Rule 6 of the CPC is concerned, it is submitted that unless the property, there are some leakages in the apartment, and it is damaging the property of the neighbor also, unless and until the petitioner is permitted to unless a position is given and he is permitted to effect the repairs that would damage the flat as well as the building. If as far as that aspect is concerned, with regard to getting the repairs done, if any application only dealing with that is filed, the same shall be considered within a period of 15 days from the date of receipt of the copy of the order.
Much obliged.
Case number 18, Bhuvan KP.
Yes.
Respondent's petition, my
Yes.
lord. My lord, the petitioners are the owners of the property. The respondent filed a suit for injunction stating that they are the flat
What
owners.
is IA?
Why IA?
IA.
No, my lord, IA, they obtained interim order in miscellaneous petition. My lord, what happened in this case? The
Come
respondent
to the prayer.
impugned. Yes.
Come to the prayer. What is the prayer? To quash the order dated 15/6/2026.
Yes, my lord. Kindly see that page number impugned order. Page number 15, my lord.
Page number?
1515. Respondent counsel present that in spite of specific direction issued by this honorable court agrees with the response of the petition number 7 has filed an sworn affidavit stating that he and other petitioners have filed this petition 39-2A complying the willful and disobedience of the interim injunction order dated 5/12/2025 passed by this honorable court, which is alleged that the respondent locked the lift and hereby caused the inconvenience to the
You
petitioner.
are not present before the court.
Pardon?
You were not present before the court.
I was present, my lord. in the-
Respondent counsel present.
Yes.
You are respondent before in the miscellaneous.
In the yes, miscellaneous. What happened, my lord? Intentionally at purpose, kindly see
Despite of
that.
specific direction issued by this court for occurrence of respondent, for appearance of respondent, he remained absent.
Yes.
The petitioner has filed his sworn affidavit that lift and and he and other petitioners have filed so and so.
And jurisdiction of police, Girinagar to police here.
Respondent locked the lift and thereby caused inconvenience to the petitioner for use and occupation of the residential apartment building. In order to know the said fact, this court has issued specific direction for appearance of the respondent, in spite of which he remained absent, which shows that the respondent is disobeying the orders of the court. Hence, this court has no other option except to pass necessary orders, and accordingly, the jurisdiction police is directed to render necessary assistance for reopening, removing the lock on the lift. Yes.
Yes, my lord, kindly see
Why
that.
you didn't appear before the court?
No, my lord, they are given a wrong address. Kindly see that how they obtained the interim order. I have not received.
Why you didn't appear before the court? When the court asked you to appear before the court, why you didn't appear?
No, my lord, there was no service of notice to me. I have not received the notice. Kindly see that, my lord, in page number 18.
Advocate is there, and you say that I am not served with the notice.
No, my lord, our counsel has
Respondent counsel present.
for objection, yes, my lord, counsel present on 24/3/2026 filed
I think you're not got the proper instructions. So what you're submitting is contrary to the order.
No, my lord, kindly see that.
Respondent present.
Yes,
You are
ma'am.
asked the respondent to be present. He is not present. You say that no notices are to me.
No, respondent, because of his aged about, he was not feeling well, he could not present before the trial court. Only counsel was present.
Court asked the party to be
Yes, ma'am.
to appear. Why he didn't appear?
Because he
Having
was-
disobeyed the orders of the court.
No, he was not, he was not feeling well. Due to that, he has not
But
appeared.
who said that? Where from you get it? When the court passes an order, if you're not feeling well, won't you file a memo or won't you file an affidavit?
Orally submitted, my lord, kindly see that on the day 15th, only respondent counsel, in spite of specific direction.
You can assume so many things, but the court can't assume anything. Court can only look at the record.
Only that is, my lord, on 11/6/2026, petitioner counsel submit, respondent locked the lift and thereby causing for appearance of the respondent, call on 15/6 within 4 days. So the counsel was present on that day, 15/6/2026. This on the trial court passed the orders in the absence of respondent because of respondent not present. My lord, why, how they'll, this is the order, my lord, kindly see that, how they obtained interim order. Kindly see that, my lord, page number 18.
You should have gone to the court and submitted all this. And what were you doing with that order, impugned order? When is it questioned? Where is that order? When was it passed? Order of injunction.
Late, next day you filed, no, my lord. Next day they filed a memo for recall of the order. Only that is on the day because the party is not able to present.
When was the injunction order granted? I've asked for a date.
Injunction order was granted in the year 2025.
What did you do? Did you question it?
No, my lord, no notice has been received in that injunction suit. Kindly see that how they are given address. That is the main crux of the matter.
Your counsel is present. You are aware of the order.
No, my lord, my counsel, I was present only in that miscellaneous petition.
Then you are aware of this order, that injunction order. It would have been questioned.
My lord, on 24/3/2026, my lord filed wakalat and we pray for time.
From March till now, you have not questioned that order, injunction order.
Contempt will not applicable, my lord. When they obtained interim order by giving a wrong address.
Please don't, when you have a remedy, you don't question it and don't say that the order is bad. Somebody has to question it. Without questioning, I will not be looking at that order passed earlier was right or wrong.
Because no notice has been received, my lord. I have not, only in this, I appeared in this contempt petition. I pray for time to file objection. So the court has been passed, the director appeared to the respondent party. So the party was not appeared. So the honorable court has been granted this order. So kindly, page number 18, my lord.
I will not go into that. I am only concerned with what is before me. Before me is a miscellaneous order. Absolutely, there is nothing wrong with the order. If something is wrong with the injunction order, that's for you to question. You have not questioned. You can't expect the court to do something, some order, I'll look at and pass orders in this. In this, what did the court say?
My lord,
open the lock of the lift. That's only the order.
Order.
What is the prejudice to you?
Prejudice means they have not invested anything. That is the entire amount borne by me. There is no residential, they are not registered.
The petitioner is before this court. Agreed with the order dated 15/6/2026. Passed in miscellaneous 332 of 26.
My lord, I'll find out because of the interim order obtained in the export interim order. I'll make it out. Kindly look into that. Kindly look into the page number, my lord. Page number 18. My lord, their given address belongs to me, number 16 AGS layout, 14 Main, Subramaniapuram. In the miscellaneous petition, they state away they're given present address, my present address. They obtained a export interim order.
Oh.
Yes.
This order, in the month of March, we are in August.
Yes, my lord.
You have not questioned
No,
it.
this order has been only party came to know in the month of March, my lord. But we filed an objection and in that in the OS suit, objection and return statement that is still pending regarding vacating of interim order. But
right.
Immediately they filed the application contempt.
What will happen? You are only asked to open the lift door.
My lord, they are not invested.
That is not. If somebody is not, please come. Agreed with the order dated so and so.
I'll withdraw that.
Yes, dismissed as withdrawn.
Then number 19, Sidnur Vishwanath for petitioner.
For petitioner in this case, my lord. In this case, my lord, the petitioner is the JDR number 1. The
What is the
Respondent
order
here.
impugned?
Impugned order, my lord, that is on page number 69 in annexure F. In this case, without given opportunity, the execution court issued the delivery warrant, my lord. My lord, that is
What
on
is,
28
what is the
to,
suit for?
it is suit for partition. After the FDP, my lord, they have filed the execution for taking possession. So
When was
that,
the FTP?
that is date of FDP, March 27 of 2025, my lord. Later, my lord, they filed the execution for taking possession. In fact, there is no OD of the scheduled property, my lord. Even though it is,
So all those objections were available to you during the pendency of the final decree proceedings.
what,
Go on, it
whatever
can't
may
go
be-
on forever.
It's okay, my lord. But now, my lord, the question before the court, it is that, my lord, without given the opportunity, the show cause.
Why is it notice required now? When the execution is filed within 2 years?
My lord, even though it is very clear that, my lord, the rule 23, minimum opportunity for it's a natural justice. Even though it's a violation of rule,
No, not at all. If it is filed within 2
it is
years.
a rule 23, rule 23
What is that?
subclass
What
2.
should be
It is very
given?
clear that, my lord,
Final decree proceedings are concluded already.
issue the show cause notice. May kindly go through
No,
that. May
why
kindly
should
go
you?
through that
No,
impugned
what is the
order.
prejudice to you now?
My lord,
Ultimately, you have to give the
whatever may
portion
be
of the
what-
property.
At least here, it is a natural justice. Even rule also, it's very clear that 23 rule, it's clearly held. Given opportunity to hear the other side. May kindly go
It's
through that.
not necessary, not necessary. Within,
No,
there
you,
is
you
within
can,
2
my
years.
lord, it's rule, it's 23, it's clearly held. Rule 23.
Give that.
Procedure after issue of notice, where a person to whom notice is issued under does not appear or does not show cause to satisfaction of the court why the decree should not be executed, the court shall order the decree to be executed. Where such person offer any objection to the execution of decree, the court shall consider such objection and make such order as it think fit. Rule 23, subclass 2.
Yes.
Order 21, rule
Procedure
23.
after issuance of notice.
Yes, this is the notice issued. May kindly go through that order sheet, my lord. That is on 6/6/26 in page number 30. Cause notice issued on 15/4/26. That is unreturned. On next 6/6/26, case is
Page
called.
number, I'm not able to find.
My lord.
Page number, I'm not able to see here.
Page number 16, annexure F, my lord. Last.
Page number.
Page number 69/70, my lord.
Oh. Yes.
15/4/26, my lord.
Oh.
That day JDR 1 and 2 not served with notice. Reissue notice to JDR on 6/6. The 6/6 case called out, SDV advocate filed wakalat for JDR number 1. KHS advocate filed wakalat for JDR number 2 along with memo
After the final decree proceedings, what will happen now?
My lord, have some issues related to the.
Have you questioned it? Have you questioned those proceedings?
That's why I will file the objection related to the petition. Even as per rule also, they have given minimum opportunity.
Now you tell the court what is the objection.
My lord,
not formality. You can't defeat the valid judgment and decree like this. Tell me what is your objection.
My lord, scheduled properties are not coded. It means not subdivided. Even though it is not subdivided, how to decided that to deliver the possession? That kind of objection I have. So that reason.
Where is the final decree?
So that reason, this is the criteria to consider by the execution court. Even though not given the opportunity, the same day issue the delivery warrant, it is against the rule of law.
I'm not convinced.
It is very clear that order 21 rule 23 sub rule 2.
Yes.
It's clearly violated.
Notice to the respondents.
Well, and in the meanwhile, at least status quo may be granted. May kindly hear the other side and it's a RD autumn pattern. It at least minimum to consider. It's a violation of the execution code.
What is your objection? Have you said so at least one line in this entire petition?
Well, my objection, it is that to hear my side of the.
What is your side? That's what I am asking.
It is not subdivided. It is a scheduled properties or revenue, that is an agriculture land. As per.
What is the property allotted to you?
That property allotted, it is that is 1/3 share. 1/3 share, now it is not coded. How do the execution court decided on without code the language?
In the final degree proceedings, what all is decided?
That objection also raised before the court.
What is decided in the final degree proceedings?
Court, it is itself, it is 1/3 share. How the 1/3 share it is decided? So that's why I request the court for hear my side of the argument. That reason, it is clearly violation of 21 rule 23.
Forget about 21 rule 3. You have been fighting this preliminary decree, final decree proceedings concluded. And the parties' rights are already crystallized.
Malad, it is a clear violation of the execution code. As per CPC. Minimum opportunity, what is show cause notice?
Except that you show me one line. Don't bank upon order 23 rule 1. Apart from that, what is that? What is your what is that you want to say? Please.
That is the major defects on part of the execution court to violate the 23 rule 2.
If I again, if permissible next this final degree, the 2014 suit, that will see only the people will enjoy the fruits of it in 2055. That's what you want ultimately.
Date may be fixed on the next date of hearing.
You only come up with your memo, then we'll see. Come up, take out hand summons. I'm not inclined to.
In the meanwhile, at least status quo may be granted. My request, please. If the order, if it is
matter, once the memo is filed, notice hand summons on the counsel appearing for the respondent. Yes.
20 R. Gurudatta, petitioner. 20.
Yes. Give the file. No representation in the month of October. Next.
Cell number 21.
Paying for petitioner.
Then
My 1 rule 10 application came to be rejected in FDP. 1 rule 10 application
Who are
rejected
you?
in FDP proceeding.
Who are
I
you?
just brief. Proposed defendant, proposed respondent. Man. I am the agreement holder, my lord. The court has been decreed my suit. Man. I'll just brief the fact, my lord.
Come to the implement order. I can understand from the order.
2008 partition has been effected between the family members, my lord. Every entries have been mutated. And during the pendency, and suit has been instituted by other daughters in the year 2009, my lord. It came to be decreed in the year, ex parte decree in the year 2013. Revenue entries have mutated in favor of the husband of R3 because he is died, my lord. So she has executed the registered agreement in favor of me in the 2018, my lord. And that suit came to be, and she failed to execute the revenue, said it, and I filed the suit. It came to be decreed in the year 2020-22, my lord. FDB has been initiated in the year 2016, and I filed the application, my lord. That came to be rejected, my. Objection is also not filed, my lord.
Please come. When counsel appearing for the petition submits that an application filed under order 1 rule 10(2) came to be dismissed. It is the case that in respect of the very same property, the petitioner has filed a suit and the suit came to be decreed and then execution is pending. Now is pending, and as such the presence of the petition is very much necessary for adjudicating the dispute, or else it would cause a lot of hardship to the petitioner, impleading applicant. This aspect was not considered by the court. Considering the same, there shall be stay of all further proceedings. pursuant to the order dated so and so notice and summons.
My lord, dispensation, my lord, dispensation.
Huh?
I'll take the dispensation. My lord. It is.
What is dispensation?
I thought it is a notice.
Huh?
Notice.
Notice is ordered and summons.
I'll take trial court notice to trial court counsel for R1, R2 to 10 dispensation. My lord.
R2 to, a
10
memo is filed seeking
dispensation, because no-
dispensation of notice, 2 to 10 dispensed with.
R1 for
R1, yes, next.
trial court counsel, my lord. My lord, stay, my lord. It is posted for R.
But I appear for the petitioners. But petitioner number 1, my lord, is mother-in-law. Petitioner 2 is the husband.
What is the suit for? What is the IA?
Please, my lords, the suit was filed by the wife, my lords, for maintenance and partition, my lords, of suit scheduled properties. Lords, during that interregnum, my lords, defendant number 1, my lords, is the mother-in-law. Defendant number 2, my lords, is the husband. Lords, an application is filed under section 151 of the CPC, my lords, seeking interim maintenance of 5,000, my lords, to 10,000 seeking against defendant number 1 and 2. Now, my lords, the trial court, my lords, passes an award, my lords, granting 5,000 of my lords monthly maintenance insofar as the plaintiff is concerned. Lords, there are 2 grounds, my lords, which are before this court. My lords, petitioner number 2, who is the husband, is, my lords, a person who is blind born, my lords, since, my lords, his birth itself. Defendant number 1, my lords, is the mother-in-law. Lords, there is a partition suit that was filed by the plaintiff through her daughter, my lords, and she has got properties, my lords, through that compromise petition earlier in 2015. Now, my lords, the after partition, my lords, where husband, my lords, has not got any shares. The property was of the father-in-law, my lords, of the plaintiff. Husband being born blind, my lords, has not sought for any partition suit, my lords, in that 2015 compromise petition, because mother is taking care of the son. Now, my lords, the plaintiff comes and files a suit, my lords, seeking interim maintenance and for final relief of maintenance and partition of the suit scheduled properties which the defendant number 1 has got through the earlier partition suit property. Now, my lords, if my lords see the annexure A, my lords, at page 25, my lords, the order that is passed by the trial court. Lords, page 35, my lords, the order reasons starts. Now, my lords, the trial court goes on to say that, my lords, even the husband has got property through succession of the father in the 2015. Hence, the defendant number 1, plaintiff, who is the wife, has to be given at least 5,000 rupees insofar as the monthly maintenance is concerned. Lords, first, the court has no jurisdiction, lords, insofar as granting lords maintenance by the civil court. Because, my lords, she had earlier filed a DV Act, my lords, which is also withdrawn. She has not filed any case.
What is the suit for?
Suit for, my lords, partition against the mother-in-law and husband of the properties of father-in-law. Lords, she has admittedly no claim, my lords, insofar as the class 1 heirs is concerned, my lords, because there is an earlier partition which has taken place and suit scheduled properties are already divided. She has, my lords, the husband has no properties that is derived out of from that compromise.
We shouldn't go into all that. According to you, this application is not maintainable. You submit only on
Please, that, my lords, because the civil court, the dispute is between, my lords, daughter-in-law against the mother-in-law and husband. Lord, the civil court, lords, has no jurisdiction.
She sought for maintenance.
Please, my lords.
She sought for maintenance in that suit.
Please, but, my lords, insofar as the maintenance is concerned, my lord, it should be before the family court under section 24 or, my lords, either under the DV Act. Lords, filing a suit.
Oh, you said the main suit itself is that is also one of the relief.
Please, that is also one of the
But that
relief.
you should say that the court has no jurisdiction to decide it.
Lords, that is filed, 7 Rule 11 is filed, my lords, that is also
decided.
dismissed.
In that it will be decided.
That is also dismissed on the
No.
same day.
What happened?
That is also dismissed on the same day. My lords, I have also annexed that petition here.
No,
That is also dismissed on the
court
same day.
must not dismiss it because there are 2 reliefs.
No, lords, the court goes on to say that there is no res judicata insofar as the properties are concerned and suit is maintainable in this case. That is the
maintenance. You say that the civil court, the suit cannot be filed seeking maintenance.
My lords, court goes on to say partition is also there, hence
that's what.
But, my lords, when you see the plaint relief, my lords, person who is born blind, lords, she has got properties, my lords, through her daughter.
5,000 rupees to the wife. Why do you fight
Lords,
for
but,
that?
lords, I am not having any employment. I am, lords, a person.
Having properties, that's what.
Lords, I don't have the property. That is why, my lords, this compromise petition also.
Why your mother and both of you together came to the court?
Please.
I can understand you have come alone.
Lords, now, my lords, under the Family Act, my lords, claiming maintenance from mother-in-law is barred. My lord, Supreme Court have held in various other
This
cases.
is not claiming maintenance.
Please, my lord,
because holding
my
the
lord, which
property
cannot
is-
be done directly is now being done indirectly by filing a suit for partition and maintenance. Lord,
5,000 rupees.
Lords, at least, my lords, insofar as some maintenance, my lord, some relaxation, my lords.
Let her come. Once she comes, then we'll decide. Notice and summons.
At least, my lords, 2,500, my lords.
Bill
Because,
number
Let her
23.
come.
lords, because I'm not, my lords, otherwise, if I didn't have a case, my lords, I wouldn't have pressed. At least, my lords, now what they're doing is they're going to file execution in my lords against the order. That is why, my lords, I'm pressing on.
For 5,000 rupees.
For 5,000. Because, my lord, she is saying that she has no amount that.
5,000 they will pay.
Lord, 5,000
file-
which is passed in the month of March now, my lord, she is claiming it.
How much it will be now?
Lords, around 30,000, 40,000. But, my lords, at least insofar as petition.
Unreasonable. No. Notice and summons.
Bill number 23.
Lords, I'll take hand summons, my lord.
Yes,
Please.
Venkatesh R. Bhagat.
Mills, I may be permitted to appear online, my lord. Annexure
Yes.
A, page 18 is the impugned order, my lord.
Page?
18, Annexure A. It's an order passed under Order 21, Rule 29. But the respondents are the decree holders filed this execution petition to implement the decree, which is not executable at all, my lords. I will take your lordship to the decree terms, my lord. I will take your lordship, page 48.
Yes.
The suit of the plaintiff is hereby decreed. Hereby declared that the plaintiff are the owners of the suit schedule property. For the defendants, anyone acting under them are hereby restrained, permanently restrained by causing interference to peaceful person enjoyment of the suit schedule property, my lord. Without anything, they filed an execution petition saying that they have violated. Without any interference, filed execution petition.
That will be decided by the executing court whether there is interference or not.
No, my lord. Thereafter, my lord, we filed a suit for partition on the very same subject matter, which is pending, where the decree holder is participating. Decree holder filed a suit for declaration. Very same property. I will take your lordship to the. It is in Kannada, but issues may be kindly seen. But one of the issues framed is the ownership. Page 105.
So what will happen to the judgment and decree already there?
Yes, my lord. That is regarding interference. What I am telling regarding possession itself, there is a dispute. He filed a suit. We have filed a suit for partition. Both suits are pending. Pending disposal of the suit. I just take.
This OS number 140 of 2005 is for declaration and injunction.
Yes, my lord. Yes, my lord.
His right to the property is declared by the court, which has attained finality. This order is dated 30th June 2008.
Yes, my lord. Now, what I'm telling
Why
you,
it can't be executed independently? That I'm not able to understand.
No, what I'm telling, he again filed very suit on the very same subject, seeking for declaration. Page 105 may be kindly seen, my lord. This is the issue frame.
Why a person will seek declaration of the same property again after a judgment and decree?
Yes, my lord. Regarding 2 guntas, which has disputed, he says, and he sought for that declaration. And parallelly, for entire subject matter, there's a suit for partition filed. That's also pending. Therefore, I filed the application saying that till the disposal of these two suits.
No. Let me understand. Please come to the plaint in this. Where is a decree in this? In this 2008 decree?
Yes, my lord. That decree is in page 50, annexure D. The schedule at page 51. '55 or 4B measuring 38 kuntas is the subject matter of Lakkuru village. Very same subject matter in OS number 206 of 2022. Page 86. page 86 bottom, it is in English word, but it's a schedule in Kannada, but 54 4B 1 acre, it's there. Very same subject matter. 86.
This is only with respect to 38 guntas of land.
It is 1 acre, the same subject matter, my lord. Then I will tell you, this is 38, entire 1 next it is challenged, and he filed a suit regarding another 2 guntas for declaration. And that declaration.
I'm not able to understand. Please come to the order. I'll understand from the order.
Yes, madam. Let's just tell you, 3 suits here, madam. 1 suit is decreed in favor of the decree holder regarding 38.
In respect of 38 guntas. He may be having a claim with respect to the others. Where is the difficulty in executing that?
Very same 1 acre is in dispute. And he again filed a suit for remaining 2 guntas.
We'll read the order. Please come to the order.
Yes, madam.
Para 8, please come to the order at para 8.
Yes, madam. In the case on hand, it is assertion of the applicant that since suits in OS number 206 of 2022 and 210 of 2023, which have been filed against himself and others by the DHR, are pending consideration. This proceedings has to be stayed. The applicant has produced the copy of the plaintiff in OS number 206 of 2022. The same disclosed that DHRs herein are the defendant number 8 and 9, and the applicants herein is the defendant number 13 in the suit. The JDR number 4 to 7 are the plaintiffs in plaintiffs number 1, 3, and 9 in OS number 206 of 2022. The suit in OS number 210 of 2023 has been instituted by DHRs herein against JDR number 1, 3, 6, and 8 herein. But the subject matter of the property in the case of case on hand is 38 guntas in survey number 55 or 4B in Lakkur village. But the subject matter of the property in OS number 210 is 2 guntas of land out of 1 acre is 55 or 4B of the Lakkur village. Hence, properties in the both matters are different. This is wrong, my lord. It's only one property, 1 acre of land. This finding is wrong. They tell already 38 guntas I got declaration. Remaining 2 guntas I am seeking for.
No, he will be entitled only for 38. Remaining, if the other suit is decreed, he will get it. Otherwise, he will not get it. Why should 38 be stopped?
No, here it is not an executable decree, and possession is in dispute again.
No, please come. The petition is
multiple sides of the proceedings, my lord. There is an armed restraint tax adopted by the plaintiffs, my lord.
The petition
regarding the possession, there is a dispute according to them only, my lord.
Why have you not your appeal? Everything has attained finality.
Yes,
by saying that he is the owner of 38 guntas. Whatever has attained finality, let the court decide. Remaining things, if they are question of the other suits,
interference has to be decided. Now, regarding our right as a joint owner, possession, everything is pending, my lord.
Everything need not be decided with respect to 38 guntas because the judgment and decree.
Entire 1 acre is in the
First of all, 38 judgment and decree has attained finality. That argument cannot be agreed with the orders passed in. Execution number 1 of 2022. Dated 15th April 2026 by the Principal Civil Judge and JMFC at the petitioner judgment debtor is before this court. The respondent herein has filed OS number 140 of OS number 140 of 2005, which came to be decreed on 30/6/2008, seeking declaring the respondent's right or the suit scheduled property. The judgment debtor, the decree holder, has filed this execution 1 of 2022. In that, the JDR number 3 has filed the application seeking to stay the execution proceedings till the disposal of the suit in OS number 206 of 2022 and OS number 210 of 2023. It is the case that the OS number 206 of 2022 is filed against the applicant, that is a petition hearing, and one Purushottam seeking the relief of partition and separate portion. And the decree holders have filed OS number 210 of 2023 against the petitioner herein and others seeking the relief of declaration and permanent injunction. Both the suits are pending consideration. In those circumstances, as they are all pertaining to the same property, the execution proceedings cannot go on until and unless the said suits are decided. That came to be dismissed by order impugned. While dismissing the application, the court has observed that the applicant has produced a copy of the plaint in OS number 206 of 2002. The same discloses that the decree holders herein are the defendant numbers 8 and 9, and the applicant herein is defendant number 13 in the suit. The JDR numbers 4 to 7 are plaintiff number 1, 3, 4, and 9 in OS number 206 of 2022. The suit in OS number 210 of 2023 has been instituted by the decree holders against JDR numbers 1, 3, 6, and 8. But the subject matter of the property in the case on hand is 38 guntas in survey number 55/4B of Lakkuru village. But the subject matter of property in OS number 210/2023 is 0.2 guntas out of 1 acre in survey number 55/4B of Lakkuru village. Hence, the properties in both the matters are different. The subject matter of the property in OS number 206 of 2022 is 1 acre in survey number 55/4B of Lakkuru village, and accordingly, and there cannot be any impediment for the court to proceed with the execution, and accordingly dismiss the application. Land counsel appearing for the petitioner submits that petitioner judgment debtor that the entire property is in survey number 55/4B. Two suits are pertaining to one for 2 guntas of land, and the other is in respect of 1 acre. And this property, which is already decreed, is about 38 guntas of land. It is submitted that there cannot be any execution of this decree until the other two suits are decreed and rights of the parties are crystallized. And at this stage, the court ought not to have, the court ought to have considered the application filed with the petitioner seeking stay of the execution proceedings, as the execution cannot be independently proceeded. All these aspects were not considered by the court, and the court had dismissed the application. Next, having heard the counsel for the petitioner, peruse the material on record. This suit, OS number 140 of 2005, is decreed on 30/6/2008. This is pertaining to 38 guntas. In that regard, the litigation has attained finality. In the very same survey number, the other two suits are pertaining to 1 acre and 2 guntas. The submission of the land counsel for the petitioner that in respect of the very same suit, very same property which is decreed in his favor on 30/6/2008, another suit is filed by the decree holder, that submission this court is not able to appreciate. If in the same survey number there are other properties which are in dispute and the dispute is pending before the court, that would be eventually decided by the court in due process. As far as this is concerned, the rights of the parties in respect of 38 guntas is already crystallized. There is no impediment for the court to proceed with the matter, and the court has rightly passed an order, and this court finds no reason to interfere. Dismissed.
So number 24.
My lords, liberty is both suits, my lords, it will not come in the way of proceeding both suits pending.
This court has not expressed anything on the merits of the matter. Yes.
Petition, the plaintiff's petition, application and for order 26 rule 9 of appointment of commissioner at the stage of argument has been rejected. Suit is
Has been dismissed.
Yes, suit is for
Please
declaration and mandate injunction.
Come to the order.
Please. The order is at number 13.
You sought for review of the order.
Yes, I filed a separate writ petition for that also. Because initially it has filed clubbing both the orders. Then your lordship held that they should be separately filed. Then I filed this petition. So for that petition is filed, I filed a memo restricting the prayer to the single order. You are kindly see
Where is the finding?
32 Millard, page number Annex D. You are kindly turn to para number 9, page 36.
No, which order you have assigned? Review order or the original order?
Original order. This is 9, IA number 9.
Read the reasoning part.
Please. The plaintiff has filed the suit against defendant for mandatory injunction to declare that he is the owner of A schedule property and B schedule property is the part of A schedule property. The plaintiff filed instant application and the case posted for arguments on merits. The plaintiff in his address he has stated that the defendant put up alleged construction over B schedule property. During the course of cross-examination, he has admitted that he has no objection to appoint court commissioner. The suit schedule property is part and parcel of A schedule property. The defendant in his objection, he has stated that father of the plaintiff, late so and so, has sold the property in favor of Sri Abdul Razak to an extent of 2 guntas of land under registered sale deed, and in turn he has made a registered gift deed in favor of Prithvi Karman measuring 100 plus 100 so and same has been purchased by him. The father of the plaintiff farmed 82 revenue sites and sold to different persons. The property of the plaintiff is not in existence as he claimed. He has not encroached as alleged by the plaintiff. The plaintiff in his plaint has pleaded that he is the owner of the land measuring.
No, why you want the commission to be appointed?
Millard, what has happened is the learned trial judge said that since the defendant has admitted that he is in possession of the enclosure.
No, forget about what the learned judge said. What is that you want?
Millard, because there are several.
There are two scheduled properties, A and B. According to the defendant, he purchased B.
Yes.
Millard, suit for bare injunction.
No. Declaration and mandatory injunction.
So what is
Millard,
this
what has
application?
happened is, my prayer is that this B schedule property is part of a largest extent that is A schedule property. Kindly see the A schedule property is measured separate 4 acre 24 guntas. Whether this forms in the part of the A schedule property or it is an independent property is to be ascertained, because even the defendant also say that I have no property left in there and it cannot be identified. Everything he has said.
Where is your application? Let's.
Kindly see me at page number 27, Annexure C. Kindly turn to affidavit, Millard. In the cross-examination, the defendant has clearly admitted that he has no objection for appointment of court commissioner. It will be clear that what he has said in the cross-exam. I have narrated in my affidavit also about that. That is, Millard, the second paragraph, 5th line. I submit, Millard, I submit that I have been examined as PW1. I submit that defendant has been examined as DW1. I must not submit that here that defendant has been.
The petition submits that an application is filed seeking appointment of the court commissioner, court without considering the reasons, and also that the defendant has no objection to appoint the court commissioner, and appointment of the court commissioner will be helpful for the court in deciding the dispute between the parties. So dismiss the application considering the same stay.
Please.
Notice and summons.
It may be tagged on with another writ petition. May be tagged with another writ petition.
List along with so and so.
13145.
Cell number 25, Krishnamurthy KR, petitioner.
Yes.
The petitioner is the defendant before the trial court, Millard. An application on Order 6, Rule 17 has been filed by the plaintiff, which has been allowed, against which this petition is filed.
What is the suit for?
The suit for permanent injunction, stating that plaintiff is in possession of the property. And he obtained a temporary injunction also. Then the defendant appeared and contested on the ground that the plain schedule property, what he has shown is unidentifiable, whereas he is trying to encroach upon his property on the basis of the documents in respect of unidentifiable property. After appreciating the pleadings and documents of both the parties, the trial court vacated the interim order. And after that, now he filed an amendment application saying that after vacating the interim order, I have encroached upon the property and therefore a mandatory injunction, which will change the nature of the suit itself. The reason is, now if this application order, it goes back to the date of the suit. kindly see his pleading as on the date of the suit is, I am trying to encroach upon the property. It is not encroached upon the property. Now he says, by including this prayer, I have already encroached upon. But he says in the pleading, in fact, he do not say when I have encroached, on which day, nothing is stated. He simply said after the interim order is vacated, the defendant have removed the fencing.
Filed?
Beg your pardon?
When was the IA filed?
IA filed is in 14/3/25.
Suit is of the year 2022.
Suit is of the year 2022. After 3 years, now he says, I have encroached upon. In fact, I am in possession of the property which
Ultimately, it's for him to, show that there is an encroachment by you
Kindly
during
see
the
the-
pendency of the suit.
True, my lord. In a normal circumstances, I know amendment application will liberally allowed. Kindly see the amendment is now already carried out. Though I have reported that I've already filed the challenge the order, but anyway it is carried out. But cast is deposited in the court. I have not accepted the cast. Plaint I have produced at page 59. Sorry,
Yes.
not page 59. Plaint is at annexure B, page 32. Ma'am. Lordship may kindly see para 15. After that amendment is carried, para 15A to G. I'll read only 2 paragraphs in that. I'll not bother your lordship to read
The
entire.
plaintiff submits that after
Plaintiff
rejection of the
submits that suit
application.
shadow property at the time of filing the suit was vacant site. And the plaintiff had also produced the photographs to establish the situation of suit shadow property. It is submitted that the suit shadow property was fenced at stone pillars and barbed wires, and taking into consideration the said aspect of the matter, this honorable court was pleased to grant an order of temporary injunction against the defendants. I will just skip that and then kindly come to para 15 email. The plaintiff submits that the defendants 1 to 3 having illegally removed the fencing put up across the suit shadow property and having illegally encroached upon the suit shadow property have acted high-handedly, and the defendant 1 to 3 have no manner of right, title or interest over either to remove the fencing or to remove the pillars and barbed wires or to encroach upon the property. The plaintiff then in 15G, the plaintiff submits that the encroachment made by the defendant number 1 to 3 is not ordered to be removed, and the plaintiff is not ordered to be delivered possession of the suit shadow property. The plaintiff would be put to great hardship and inconvenience. And para 17, it is amended actually. Earlier, it was not specifically shows as amended here, but it is amended. The plaintiff submits that the cause of action for the plaintiff to file the above suit arose on 37/22, when the defendant caused the unlawful interference in respect of social property, and subsequently when the defendant 1 to 3 encroached upon the social property by removing the fencing, stone pillars and barbed wires and encroached upon the social property. Nowhere said when I have encroached. It is my property on which he filed this suit. When the injunction is vacated, kindly see one observation, one paragraph observation in the interim order by the trial court. The lordship may kindly see only one paragraph in the order. I am not.
Yes.
Para 20, my lord, while vacating the interim order. In my opinion, the principle laid down in the aforesaid citation are aptly applicable to the case in hand. The plaintiff must be clear prima facie case, but in this case, the plaintiff has nowhere stated that where exactly his property is situated. The plaintiff has not mentioned any survey number in the plaint or in her affidavit. She has not produced layout plan. It is pertinent to note that here herself that as per registered GPA dated 15/7/91, there is a layout plan. That layout is formed by Narsappa, vendor of the plaintiff. The layout plan is not produced even though there is a serious dispute about the identification of the property. Apart from the plaintiff has not produced any materials before the court to show the original this property was belonged to Channamma and others. On the other hand, the report produced by the plaintiff himself reveals that 88.3 for Jekkur is acquired by the government. There are 2 documents supports the contention of the defendants. Voluminous documents produced by the defendants prima facie reveals that they are in possession of their property. As per the plain schedule, east of the property there is a road, but the photograph produced by the plaintiff themselves reveals otherwise. This is the situation. Now, your lordship may kindly see. Suppose if he established on the basis of suit for injunction, if I removed him from possession during the pendency of the suit, he is all, if he establishes possession as on the date of the suit, he is entitled for restitution under 143. That is the proper remedy, not the amendment, because any amendment carried out now with this kind of an amendment will goes back to the date of the suit, which will create an anomalous situation where the plaintiff prays one is permanent injunction not to interfere. The second prayer is mandatory injunction directing the defendant to hand over possession, which is contradictory prayer now. Now, prayer is also amended.
Mandatory injunction is not in the respect of entire property. He was only saying that in a part of the property you raise some construction.
No, his site, 3040 site, according to him, that fence I have removed and encroached upon during the pendency. His claim is only in respect of one site, not the entire, it is not a bigger property, 3040 site.
According to him, the entire property you have you constructed. Only speaking about a small.
No, it is actually the land which was acquired by the BDA. And the BDA has, I am the land loser. For me, that land was allotted to me. And in that land, I am putting up construction. That is in my property, which is allotted by the BDA. I have produced all the sale deeds executed by BDA, possession certificate handed over, layout plan of the BDA, I have handed over.
Notice to the respondents and summons. Anyhow, he has filed the amended plaint also. We'll see, let him come. Next.
Trial may start, that's why limited period.
Let him come, let him come. We'll
Some date may be fixed so that.
Yes, the list this matter on 7th of September. And summons.
Cell number
I'm
626.
sorry, my lord, the notice may be dispensed to respond number 2 to 5 at
2
my
to
risk.
5, dispensed with notice to 1.
Respond number 2 to 5. 1 is the plaintiff.
Cell number 26, Subbareddy KN.
Appearing for the petitioner. This petitioner is filed by the plaintiff, my lords. In an identical matter, your ladyship had passed an order on 28th July with respect to IA number 3.
What is this writ petition?
The writ petition is.
Where is the order? Let's look at it. 16:7. Where is the
16:7.
order? Page number?
It is at Annexure A, page 22, my lords.
What is this? I didn't understand.
My
Like
lords,
that?
in an identical matter, your ladyship had passed an order.
How is how this matter and this is identical?
It is identical, my lords.
No.
Both
He
IAs.
filed common objections to IA number 2 and 3. Same is taken on. Advocate for defendant filed application under section 148 of the CPC and prays to extend time to file written statement. Heard, satisfied with the grounds. Application is allowed. Avoid suit summons and notice of 4 to 6 for written statement of defendant number 3. To hear IA number 2 and 3 by 48. Where is IA number 2 and 3? What is IA number 2 and 3?
IA number 2 is Annexure F1, my lords. It is at 63, page 60. IA number 2 is at Annexure F1, page 67.
IA number 2, when is it filed?
6th July 2026.
6th July
2026.
2026
this year, my lords.
IA number 3 is filed?
Same date, same date.
Please come. The petition is agreed with the order passed by the court, whereby without considering IA number 2 and 3, the court has issued suit summons. It is submitted that an application is filed seeking ad interim injunction The court has to consider the same in accordance with law relied on so and so. Accordingly, I number 2 and 3 shall be decided within a period of 1 week from the date of all the judgments, from the date of receipt of the copy of the order. Yes.
Cell number 27, Vidya M.
Petitioner, my lord. Petitioner is a plaintiff and a decree holder and a specific performance contract suit, my lord. The suit was filed in the year 2016, my lord. Later, the decree was passed.
What is IA? What is the present impugned order?
I am seeking for a speedy disposal of a miscellaneous case, my lord.
When was it filed?
It was filed in the year 2023, my lord. The suit is decreed in the year 2018, my lord. An execution proceedings has been stated.
The present petition is filed seeking the following prayer. The registrar judicially is directed to call for a report from the concern. How much time it is required to dispose of the miscellaneous list this matter on Thursday? In the first list.
Much obliged.
Cell number 28,
Appear for petitioner.
E.C. Venkatesh.
Lord, I'm the petitioner. Representing the petitioner. Lord, the suit for recovery, my lord, filed by the plaintiff before the commercial court, my lord, on 25/7/2024. Lord, thereafter, my lord, the defendant entered appearance and he filed, my lord, return statement on 8/11/2024. And also, my lord, he filed another application to frame preliminary issue regarding, my lord, since there is an arbitration clause in the agreement. Then, my lord, my lord, the court to frame an issue on, my lord, 19/2/2025. Thereafter, my lord, it is posted for plaintiff evidence, defendant evidence on preliminary issue on, my lord, 13/10/2025. Thereafter, my lord, the defendant remained absent on 13/1/2026, 13/2/2026, 10/3, 16/4, and 36 now. My lord, urgent to 11. It was earlier, my lord, 11/8/2026. Now it is posted on 17/11/2026. Lord, in the absence of defendant, my lord, keep on, my lord, adjourning. It is only, my lord, deciding an application IA number 2 regarding, my lord, preliminary issue, because preliminary issue
filed by him.
Please, my lord.
Filed by him.
Filed by him, my lord. Lord, he filed an application along with return statement saying that there is an arbitration clause. Kindly decide as a preliminary issue. Now it has been urgent to, my lord, 17/11/2026. Lord, one difficulty is, my lord, the regular court number 19, my lord, now is vacant. Now the in charge court is, my lord, 83. Lord, he is not, my lord, allowing to, my lord, make my submission in the court. Whenever the case reaches, my lord, simply it is, my lord, the matters got urgent. Even on the last
A date is given for this court in the month of November.
Please, November.
Please take out notice on the council.
Please, I will take notice.
Then once he comes, we'll fix a date for that.
Please.
Yes, notice and summons.
Lord,
Yes.
date, so that will not intimate the date.
9th of September.
9th of September.
Yes.
Please.
Cell number 29.
Lord, I appear for petitioner. Appear for petitioner, Lord.
Yes.
Lord, on challenging the order passed at Annexure D. Lord, I am the appellant before the appellate court. Lord, the suit is originally, the application came to be dismissed in our application seeking for amendment of client under order 6 rule 17. Lord, the impugned order at page number 24. Let's see. The proposed amendment with included the additional property, the property which has to be joint family and ancestor property. I have filed a suit in the year 2011. Thereafter, my lord, suit came to be dismissed. Thereafter, I preferred an appeal in RA. In this said RA, my lord, a bona fide impression, the trial judge during the course of the trial cannot be implemented in the proposed property. The proposed property to be and ancestral and joint family property. The objection was filed by the other side, stating that only for delay and latches. And thereafter, the impugned order at Annexure D may lord kindly peruse on the ground, dismiss on the ground of the application itself is a belated stage. Therefore, the original proceedings is continuation of the appeal.
What is
Please,
the amendment you are seeking?
That amendment by application, may lord kindly see page number 18. There are 3 property which was included to the proposed amendment, additional properties. Page number 18.
Why it was not added earlier?
Added earlier because a bona fide impression, those property which is the joint family properties. The respondent is taken a contention that the item number 1 of the proposed amendment property, which is the self-accord property, in other remaining 2 and 3 property, which is we are in possession, is not a clear title of the property. Therefore, I sought for amendment of pleadings below.
Please, the respondents and summons.
Cell number
But kind of interim order may be given, my lord, at the stage of argument, my lord, limited point of time. Otherwise, my lord, the appeal court has to proceed it further. I would suffer damage, my lord. They are the multiple process.
Next.
For the petitioner's matter, lots of recollect. I made my submissions on this matter on the last date of hearing. It's a short point for consideration. Regarding the execution proceedings were filed by the alleged legal representatives of the deceased. That initially the death was before the filing of the execution petition, and 3 individuals claiming to be legal representatives filed. And I filed an objection to that, disputing that they are not the legal representatives. And I've taken my lords to the impugned order on this aspect. My lords directed me what would be the case also would rely upon. Now the trial court has rejected as a bottom kind notice that if there are 2 rival contentions between people saying that we are the legal representative, then only an inquiry will be required under 22 Rule 5. My submission was that any question that arises involving a dispute who is the legal representative, an inquiry would be required in the matter. Was my submission. Now only those judgments I submitted.
This judgment, I know the judgment of Justice R.V. Ravindran.
Sorry, please.
The judgment of R.V. Ravindran, yes.
Yes.
Order 22, Rule 5 is dealt with.
Yes. Paragraph 10 and 11 covers the said aspect of the
So
matter.
please come to the facts again. I don't remember the facts.
No, the facts, what happened is
I'll let me read the order. Come to the order. Come to the reasoning part. We'll
Yes,
read
please.
the reasoning part.
Now, ink page 39, my lords. Ink page. Present execution petition filed by virtue of the judgment in decree in 2459 of 99. It's made clear that the LRs of the defendant number 1 and defendant number 2 filed RFA so and so with the Honorable High Court of Karnataka on 29. This was dismissed on 29/11/2022. At the earliest point in time, defendant number 2 and LRs of the defendant have narrated that the plaintiff Vaishali is dead and represented by her legal representative M.A. Roy. Therefore, at this stage, legal representative of JDR are stopped from contending and as not the legal representative of the deceased plaintiff. The materials placed on record would show that since because appeal in RFA 891 was dismissed, a review petition was filed on 21 of 23. Since because RP is pending, an application was filed by the present JDRs to stay the further proceedings pending consideration of the review petition in 21 of 23. Now it's made clear that the application in RP number so and so under Order 1 Rule 10.2 was dismissed on 28/6/2022.
I think in respect to this suit, another order I have passed.
No. No other proceedings are pending. This is another one. The last judgment is my lord's judgment, but it's another FDP matter. My lords considered the last judgment which I relied upon. It was order passed by this honorable court, but it was in a final decree proceedings where the trial court refused to hold an inquiry. This honorable court was pleased to direct. Now the question is, I did not dispute regarding the M.A. Roy. M.A. Vaishali was the original plaintiff. She deceased and one M.A. Roy came as legal. It is not that the present, I have disputed the relationship of the present decree holders who have approached the trial court, who are the respondents 1 to 3 before this honorable court. It is not about M.A. Roy I have questioned. Trial court went on to assume that M.A. Roy had come on record, and I cannot question that in the present proceedings. And in paragraph 14 of the impugned order, it is a submission of Sri I.S. advocate for decree holder that in absence of any rival contention between the legal representative of the decree holder, JDA has no locus standi to contend. Present petitioners are not legal heirs of the deceased decree holder.
According to you, how you are the LR?
No, not me. I am not a rival contender. I am a JDR.
Mm.
I am a JDR. I am questioning the people who filed the execution petition on behalf of the decree holder. Individuals claiming to be legal representative of decree holder, so they also don't come before the court. Some power of attorney holder comes before the court.
So IA filed under Order 22 Rule 5 is dismissed.
Yes.
Who has filed it?
I have filed the application.
To bring whom on record?
No, not on record, to hold an inquiry under Order 22 Rule 5. Order 22 Rule 5 would mandate holding of an inquiry, the reading of Order 22 Rule
At the
5.
instance of the judgment debtor.
Any person
Who
who
is this?
disputes.
No, there should be some, you should make out a factual basis for that. No, the decree holder dies, somebody comes on record as their LRs.
Not on record, they straight away filed a EP itself in their name. Execution petition itself is filed in their name.
You say that they are not the judgment, they are not the legal heads. There should be something, where is the inquiry on
No,
that?
that's what I submitted, my lords, to show a positive proof of the fact of a relationship between A and B.
Forget about
I
the
would have
positive-
material.
Forget about the positive proof. Please show from your averments, where, according to you, what is the basis for it? You should have, there should be
Now,
some.
what has happened, my lord, after this petition has come into being, the judgment debtor has verified. There is no such addresses, there is no such persons who are named in this execution
No, let's see
petition.
your application. What is
No,
the?
my lord, in fact, took me through that, and I also read over the
That's what, let me look at
objection
it.
statement, also affidavit in support of the application. At
Or
paragraph 2.
To evade the execution, just like that, your judgment debtor starts denying whether they are the legal heirs or not, then there is no end to the execution proceedings.
Oh, in fact,
Let's see your affidavit. What did
affidavit,
you
my
say?
lords, made me read paragraph 2, last occasion.
Page number?
24. Says that the original plaintiff in so and so deceased, subsequently MRI came on record claiming to the legal representative of the plaintiff.
So just you say that.
Currently, execution petition is filed by certain individuals who are claiming to be legal representatives of the deceased decree holder. So it is not the MRIs is not the issue. Now the respondents 1 to 3
Come
who
to
claim
the
to be the
Come to this judgment, how it applies to you, please show.
Allah kindly consider paragraph 10 and 11 of the judgment, first judgment
Yes.
that I relied upon. May I please read? Filing of the application to bring legal representative does not amount to bringing legal representatives on record. When the LR application is filed, the court should consider and decide whether the persons named therein as legal representatives should be brought on record to represent the estate of the deceased. Until such decision by the court, the persons claiming to be legal representatives have no right to represent the estate of the deceased. No, nor prosecute or defend the case. If there is a dispute, who are the legal representatives? A decision should be rendered on such dispute. Only when the question of legal representative is determined by the court and such legal representative is brought on record, it can be said that the estate of such deceased is represented. So it is quite mandatory under Order 22 Rule 5 to hold an inquiry. Similar observation, my lord should also kindly appreciate the judgment it begins at ink page 6. This is also Apex Court judgment I have relied upon. I would read only paragraph 14. May I please? Paragraph 14, ink page 8. Order 22 Rule 5, determination of the question as to legal representative. Where a question arises as to whether a person is or not legal representative of deceased plaintiff or the deceased defendant, such a question shall be determined. The language shall be determined by the court. Provided when such a question arises before the appellate court, the court may before
All
determine.
these applications are only, if you look at all these judgments, they were deciding about the rival claimants of the.
That's precisely the trial court has observed. My lords would kindly read the statute. Let us not, when the statute is clear, where a question arises as to whether any person is legal representative or not. It is not where a question arises between the rival claimants to be legal representative. Any question on that fact, it arises. That's what the law itself reads, Order 22 Rule 5.
Yes, I pass orders. Dismiss.
And also last judgment rendered by my lords itself.
I have seen that.
On one aspect, I will clarify on that. In that case, what had happened was the court initially observed inquiry is required. Later, did not hold on. I will stand corrected on that fact because the facts of that case was that my lords observed that also, saying that Order 22 said it's an inquiry. Again, you have overlooked it. So I will not be wrong on the facts.
Yes.
Number 31, Interanush Chavan, for petitioner.
Hearing for petitioners. This petition is filed for direction, seeking direction to dispose of the IA 1 of 2025 matters. Brief facts of the case is.
When was it filed?
It was filed last year, July minutes, 24th July 2025.
Injunction petition.
Injunction petition minutes, along with the
present
declaration to
is
set
filed.
aside compromise.
In the following prayer. Then counsel for the petition submits that the said application is filed in the year 2025 date.
24/7/2025.
24/7/2025, and so far the court has failed to consider the application. He has relied on the judgment of the coordinate bench of this court and so, considering the fact that an IA is filed in the year 2025, that petition is disposed of same 1 week, notwithstanding the fact that the summons are not served on the defendants. Yes.
My lords, humble submission. Can I be permitted to prepone the date, my lords? It is on 22 September.
It will be there. The advocate in all these matters, that will be there. Like the petition is at liberty to seek for advancement of the case. Yes.
Much obliged.
32, K. Chandranath Tariga.
Petitioner, was plaintiff's application seeking amendment in a suit for declaration and injunction came to be rejected. The amendment sought was in respect of.
Suit is of which year?
The suit is of the year 2021. All the defendants have been placed ex parte. And with respect to my application, of course, there is no objection filed. And the amendment that I've sought.
What is the suit for?
A suit for permanent injunction and declaration and permanent injunction that the sale deed so executed by my GP holder is not binding on me.
And what is the amendment now?
It was amendment with respect to me elaborating my pleadings with respect to my possession, albeit have pleaded that I'm in possession, but I want to plead further that to elaborate my position. At page number 23 is the application. Annexure B, page 23. It is.
What is this clarification? What clarification it is posted?
It is that the court indeed has certain burden. So whenever the trial court indeed has some certain burden with respect to passing of orders, day-to-day course. So if there was any judgment to be passed on that day, and if the court was not in a position to pass it for that day, they would have posted it for clarification on the next date of hearing. On when the matter was posted for clarification, this amendment application.
Clarification of passing which order?
The final judgment. The matter is heard. Sorry, the matter is the trial is completed. The matter is set down for judgment.
Then where is the question of IA?
Lords, the IA is only with respect to me elaborating my stance.
So why at that stage?
Lords, because what happens is if the court were to go against me on the point of declaration, injunction cannot be granted. So what happens is my prayer is that consequential relief is sought. What I seek to amend is alternative prayer to take away the word of consequential. Then insert as a alternative prayer.
You can't do after the matter is posted for judgment.
Lords, what happens is if at all the suit were to be dismissed, again the second suit has to be filed. This would lead to multiplicity of proceedings.
That you have chosen to do so by keeping quiet.
Lords, I am in possession. That can be either however decided.
No, not amendment, not when the matter is posted for judgment.
My lords, I stand covered by a coordinate bench judgment. It says that even, of course, at any stage in this suit, considering my
after pronouncement of judgment.
Please, of course not. Considering my stance, my lords, please kindly see this, my lords. What happens is, if at all the declaration prayer is now rejected.
Why should the court see what will happen? You should have thought about it when the matter is pending.
Lords, now, even at this stage, my lords, even at the stage of appeal, plaints are permitted to be amended, of course, due to their own set of circumstances.
So many things are permitted at so many stages.
My lord, kindly appreciate this, my lords. The defendants have been placed ex parte, and this is a suit for declaration and injunction. If at all the declaration is not granted, my injunction goes. All I seek is for amendment to that effect, where I'm changing from the prayer of consequential to alternative. That's it. Nothing else. Otherwise, I may end up in second proceedings by filing a suit. The sale deed is of the year 2010. Suit is of the year 2020. The vendor who purchased the property is no more. His LR is on record. My brother who was a GP holder, he's no more. His LR is on record. There is no end to this, my lord. Considering this,
you should have been thought by you.
As a one-time measure, I may request.
When the matter was posted for clarification, that is after the judgment, matter is posted for judgment.
Please, of course, during the course of.
Matter is posted for judgment. Where is the question of IAS? That's what I'm asking you.
Even at any point of time in the suit.
I don't think so. In the light of the division bench judgment, dismiss.
In the coordinate bench judgment.
I've seen that. I've seen the coordinate bench judgment. I've seen the division bench judgment. In the light of the division bench judgment, once a matter is posted for judgment, question of amendment will not arise. Yes.
If I may, please, my lords, if
Yes.
I may request, this will lead again to multiplicity of proceedings, my lords. All
You
I,
have to get over the division bench judgment that after matter is posted for judgment,
lords,
can any application be allowed?
my lords, this I'm not changing the nature of the suit also. Already have pleaded regarding my position.
You should understand what is my question.
Please, I bow down, my
said
lords.
after the matter is posted for judgment, can you make any application? I am very, that is a judgment of the division bench.
Please.
That you can't get over that. Yes,
Very
the presented petition
Obliged.
filed questioning an order passed under order 6/2/17. The land counsel for the petition submits that the court, though there was no substantial, the nature of the suit is not altered. No prejudice is caused as the defendants are all set ex parte. In those circumstances, the court ought not to have dismissed the application. Next, having other counsel for the petitioner present material on record. When the matter is posted for judgment, at that point of time, this application came to be filed in the light of the judgment passed by a division bench of this court in so and so, so and so. Once a matter is posted for a judgment, the court, no further applications can be allowed. And in that view of the mind, the light of the said judgment, this court is not going into the merits of the matter, accordingly dismissed.
Obliged.
33, or Madhusudan Reddy.
May I please, your lordship? I'm the petitioner. I'm the plaintiff. I filed an application under Order 1 Rule 10(2). Lords, the first petition is the company. The second and third petitions are the directors, the present directors, my lords. For the defendant, the first one I filed, only one defendant I filed. He was the finance director, my lords. After his resignation, we came to know that there is a huge amount of misappropriation of money. And there are a lot of cases, counter cases and by me and by against them as well, my lords. Then what happens? The proposed defendant now is also a director legal. So we were under the impression that he was not even involved in it. And as there were a lot of cases were going against them during the mediations, it came up that he was also having in possession of the top property, some documents, and we sought for the documents to be given to us. He said that he has to be exonerated, and we did not agree to it. Hence, my lords is holding. My lords, my application is at page number 27.
Yes.
My lords, at para 5 and 6, my lords, is my submission.
Who is this, the proposed?
Yeah, he is the director legal. He is also one of the directors.
Suit for?
Suit is for mandatory injunction, not to misuse the documents and the documents to be returned back to the company. Why
is a party, why is a necessary party to the suit?
My lord, he also is in possession of the documents, which we were not earlier aware of it. And subsequently, when we came to know in the other cases that there are some documents.
Once it is against the company, each and every person connected with the company need not be a party to the proceedings.
Not necessarily, my lords, but they are the directors who are resigned. But however, the company documents are there with them. They are not giving it back to us.
He is with the company.
He is no more with the company. He also resigned. While resigning, my lord, they would have given. That's what exactly is my case is also.
Please come. Please read.
My lord, page number, my para 5 and 6 of at page number 29 is my application starts at 27. Page 29, para 5, please, we submit that the defendant number 1, the proposed defendant, were taking care of the financial aspects and legal aspects of the plaintiff company, respectively. This suit was filed when we got to know about the misappropriation, misrepresentation, and the misusing of the documents, signed blank checks, signed blank letterheads, internet banking details, etc. by the first defendant. We further came to know that the first defendant has done the above stated misdeeds with the help of and support of the proposed defendant, the legal director of the plaintiff company. We also came to know that the proposed defendant is also having the custody of various documents, signed blank letterheads, signed blank checks, signed documents pertaining to the plaintiff company, and further the proposed defendant also is misusing the same post his resignation. And to determine the actual dispute, including the proposed.
Notice hand summons.
Grateful.
33, 34, serial number 34, Muralidhar HM.
Appear for the petitioner.
Yes.
The impugned order is at annexure
Next, page 91 is the interim order. Application filed under order 28 rule 1 has been allowed.
What is the suit for?
Suit was filed under section 276 of the Succession Act for probate.
Hmm.
The will is of the year 1996. Suit was filed in 2018. I filed appearance and the executor of the will withdrew himself. Thereafter, suit has been registered. The suit is pending. We have filed our written statement. The evidence of PW1 is recorded and cross-examination is also over.
Hmm.
PW2 is the attesting witness.
Oh.
The PW1 filed an application requesting the court to appoint a commission to record his evidence.
Oh.
Lords may kindly say that he is an attesting witness to the bill. He has to come to the court and depose. That application was filed on the ground of ill health. We opposed the
age of this PW2?
75. Ill health. That application was opposed by all the defendants. He withdrew the application. He produced the witness to the box. His evidence was recorded. Thereafter, he files this application seeking appointment of commission to record the cross-examination at his residence. Lord, he is an attesting witness, and the trial court allowed his application on the ground that I have not stated in the statement of objection what is the hardship that is going to cause. That is not the law. If the application is supported by any certificate of sickness signed by the medical practitioner, yes. No such certificate is produced. Earlier application, second application is a replica of the first application. Same set of documents are filed. All that they have filed along with the application is the blood sample reports. No certificate. The application is not supported by any medical certificate. If he were to be a witness to the sale deed or he is a witness to a testamentary document and his presence
Court
before
commission shall record the cross-examination under the vigilance of video and audio. Plaintiff only shall bear all costs incurred in towards cross-examination of the PW2 at the vigilance of video and audio. That rupees 5,000.
No reason, acceptable reason.
No, what happens if he is examined?
No, he wants him to be examined at his residence. If he comes to the court, it is the examination seriousness would be different, and court will also better understand because they are.
Where did the court record about the reasons why it is passing this order?
My lords may kindly turn to ink page 103. The reason starts from that. Kindly turn to ink page 104 or 103, paragraph 7. It starts. The plaintiff sought appointment of the court commissioner for cross-examination of PW2 according to this is application amendments. Kindly straight away come to paragraph page 106. It starts from the mid line. If the applicant, it starts, if applied the ratio of the law to the case on hand, admittedly Mr. Philip David have already examined before the Sambal court as the PW2 is not in dispute. One more attested witness is Mr. So-and-so as already dead. On the other hand, though PW2 examined before this court as could be able to attend, he is not able to attend the court physically due to his physical health and health issue basis. To support the same, such of the core application, admittedly, number of pages of medical documents and photographs are produced before the court. Next, my lords. My lords may kindly turn to the next page, page 6, internal page 16, ink page 107. Second line. On the contrary, if the application is allowed, the present application, what would be the loss cost to the defendant have not been stated by the defendant despite their lengthy page number of objections. This is the reason stated by the court. Now, kindly see, let us see the document produced by them along with the application. which my lords would get at ink page. Ink page 71, my lords. This is the document along with the typed copy also I have filed. Typed copy is at ink page 77. Kindly see the date of this certificate. This is 5/1/2024 blood test report. Other than that, there is nothing. The court simply records that voluminous number of pages of documents are produced. Kindly see the date of this application. This date is 25/11/24. The blood sample report enclosed to that is dated 5/1/2024. This very report was enclosed along with the earlier application also. No new documents, no new plea. The ones he withdrew, he produces the PW2, and for cross-examination, he comes out with another application. Therefore, my respectful submission is, if he is present before the court, the cross-examination will be more effective than if it is recorded, number one. Number two, there is no merit in the application. The purpose of application is something different.
Please come. I'll pass orders. Dismissed. Yes.
Procedural number 104, my lord, at 2:30, my lord. Petitioner is a contestant defendant before the trial court, my lord, except examination in chief. He has, he have to produce 8 documents, my lord, to prove his evidence. So at the time of arguments, my lord, he has filed a recall application, and along with the documents, said application came to be rejected, my lord. Matter is posted for tomorrow for final arguments of the present petitioner is concerned, my lord. He is a contestant defendant before the trial court.
What's the impugned order passed?
My lord, on 6/8, my lord. 6/8, my lord.
Yes, 2:30.
Great.
Which was heard in part on Thursday, it was online, it was posted today at the top of the list for giving continuation of that admission matter, CRP. They may file execution petition, but still they have not.
It's
filed
2:30.
Lordships,
List to
withdrawal,
Silema-
my lordships.
List to Silema 28, my lords. Lords, list to Silema 28, my lords. Agreement of the sale of the year 2002. After 22 years,
CRP.
suit for specific performance filed. I am for respond, my lords. Both the courts below had rejected the temporary injunction application. This honorable court in the month of February has passed a one-line interim order. I'm a developer. The plaintiff has filed the suit for specific performance after a delay of 22 years, my lords. There is a one-line interim order. I'm a developer. With each passing day, I'm suffering losses. My lords, the suit itself is not meant to.
That mark the day after tomorrow in the first list. Yes.
Withdrawal, my lordships.
24.
If all of you at a time you start, I will raise. So all of you will be doing it at your own risk. Yes.
Serial
This order was passed on 12th August. The serious threat of disposition and alienation. Bystanders day in, day out, coming to the property and trying to interfere. Have been in possession for over 50 to 60 years, which was central Bangalore. Maybe listed tomorrow.
What is that writ petition?
The writ petition is for seeking impugned interim order for alienation.
When is it filed?
It was filed last week, on Friday, on last Thursday.
Where is it listed?
I'm mentioning the matter for listing today.
Is it numbered? Is it, have you complied with the office objections?
I'll comply it.
First do it. First do and then come. Yes.
Serial number 84, Your Honor.
Huh? When is the impugned order passed?
Last week.
Huh.
Now we filed the petition challenging the order passed by the executive court, where I filed an application saying that there is no privity of contract between me and the first respondent. In spite of it, there is an order to injunction against the respondent not to interfere with my possession. Ignoring the injunction order, executive court has issued this delivery warrant with 47. I'm challenging that order. It's a dwelling house. My family is inside the house. If they come and execute the
It is not filed till now. It is not filed till now.
It is filed. It is filed, and there is already an order by the civil court not to interfere with my possession.
I'm saying writ petition is not yet filed. When is it filed?
It was filed long back, about 1 month back. It was posted before your lordship. There is a direction to post this matter in August 2026. Now it has to be listed for hearing. Last week there is an order with police help to deliver the possession. There is an order of injunction by the.
The matter itself is directed to be listed in the month of August, means you were not there, or court heard it, no point, it is adjourned.
It was heard by your lordship.
And then why no interim order is not granted then?
At that time, there was no interim order directing the delivery warrant. Which police cell?
We'll see. Take that.
Serial number 84.
Yes.
Withdrawal, my lordships. Withdrawal.
Yes, take that.
Seal number 92, my lordships. I am filing a memo for withdrawal, my lordships.
Give that.
92.
Serial number
Liberty to file
112.
application appropriate before the appropriate forum, my lordships.
A memo is seeking to withdraw the petition. Memo is filed seeking to withdraw the petition. As it is stated that there is a remedy of appeal, accordingly the memo is taken on record and dismissed as withdrawn with the liberty to file an appropriate application within 2 weeks. The registry is directed to return all the documents.
Serial number 84 withdraw ಮಾಡ್ಕೊತೀನಿ. Serial number 84.
You have given the memo. Yes. Yes.
My lord, it's a
What is
fresh
this?
matter, my lord.
80?
The trial
80,
court-
84. Sir. 84. We will petitioners.
Submitted, the matter is settled outside the court. Hence, I want to withdraw. Memo is taken on record and dismissed as withdrawn.
My lord, the trial court, right from the March till now, it is getting postponed, my lord. He is saying it's busy, and it's for an IA. The order is yet to be pronounced, my lord, and it's going on, my lord, from past 5-6 months. It's a case of an eviction, my lord. So and already I have filed the case on 5th, my lord, and complied with all the.
If office objections complied, then it will come. Yes.
Serial number 114.
My lord, once again, the date is on the 19th, my lord, day after tomorrow. Request your lordship to kindly take this and give us.
If it is complied, it will come.
My lord, serial number
Case
one.
number 112, Mira. The case was trial court posted on the 19th for judgment. Kindly take up it and.
Once it is posted for judgment, I will not pass any. Take up that
230.
matter.
My lord, serial number
Take
one.
up at 2:30 and dismiss it because after matter is posted for judgment, no other orders.
My ladyship, serial number.
Fresh posting for either tomorrow or.
Fresh matters don't make.
Ladyship, the bank has put up for sale the property on 20th. It's an agricultural land.
If you comply with the objections, immediately it will come.
My
Then
ladyship.
why should the memo be given? Not
My
necessary.
lord, serial number 114. My lord, it is amount withdrawal, my lord. I am for the respondent. The petitioner has deposited the amount before.
Huh?
Order, he has posted it for, reserved the orders for 19th, my lord, day after tomorrow. Right from, for 6 months, my lord. Request your lordship to kindly.
He might post or pass orders. What is urgency for that? If he doesn't, then you can come.
My
memo
lord,
may
my
kindly
lord.
be posted day after tomorrow, madam. Day after tomorrow, please.
My lord, serial number one.
Argue the case, I'll convince your lordship. There is already an order last week with the police help.
I heard you. I asked her to take the memo. I will
Day after
assign that.
tomorrow. Day after tomorrow, please.
That is my convenience. I will look into it.
My lord,
Yes.
serial number 114, my lord, I am for the respondent. The petitioner has deposited the amount before this honorable court. I have filed the application to withdraw the same. Kindly, my lord, the respondent.
Serial number 50, my lords. There is an IA for stay, my lord. 50. There's an application for stay of proceedings. Evidence is proceeding there, my lords, and limitation is
50
decided
of
against.
which list?
List 2, my lords. List 2, serial number 50. Any date convenient to my lords, it may be taken up. Only
serial
because
number-
there's an IA for stay, my lords.
Serial number 115, please.
My lord, serial number 55.
Court officer.
Court officer,
ಹೇಳಿ ಸರ್
ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ವಾ ಮೇಡಮ್?
ಇದೆ
ಮೇಡಮ್ ಇದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಲಿಸ್ಟ್?
ಹೌದು
ಮೇಡಮ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಹೌದು ಸರ್
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
Court officer, serial number 20.
ಸರ್
Serial number 20, list number 1.
ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
List 1.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ತಗೊಂಡಿಲ್ಲಲ್ಲ?
ಸರ್
List
ಅದು
number 2
ಅರ್ಜೆಂಟ್ ಆಗಿದೆ
ತಗೊಂಡಿಲ್ಲ?
ಅಲ್ಲಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿಲ್ಲ
ಅದೇ ಅದು ಪ್ರಾಬ್ಲಮ್ ಆಯ್ತು, ಡೇಟ್ ಇಲ್ವಾ?
ಡೇಟ್ ಇಲ್ಲ ಸರ್ ಹೋಗಿದೆ ಮಂತ್ ಆಫ್ ಅಕ್ಟೋಬರ್. ಸರ್ ಹೇಳಿ.
Madam,
ಹೋಗುತ್ತೆ ಚೇಂಬರ್ಗೆ ಹೋಗುತ್ತೆ ಈಗ.
Madam.
ಮೆಮೊ ಇಲ್ಲ ಅದು ಸರ್ ಇವ್ರು ಕೊಟ್ಟಿದ್ದು ಅದು
Ma-
ಕೇಸ್ ಕಳ್ಸಿ.
Madam, serial,
ಮೇಲ್ ಬನ್ನಿ.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫಿಫ್ತ್ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಆಗಿದೆ ಮೇಡಮ್.
ಹೇಳಿ ಸರ್ ಅವ್ರಿಗೆ.
Madam,
ಯಾವ್ರ ಹತ್ರ ಹೇಳ್ಬೇಕಾ?
ಸರ್ ಹೇಳಿ ಒಂದ್ ನಿಮಿಷ ಸರ್
Madam,
ಹೇಳಿ ಸರ್.
list 2 serial number 7.
ಲಿಸ್ಟ್ ಒಂದೇ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ, ಲಿಸ್ಟ್ ಕರ್ದಿಲ್ಲ ಸರ್. ಮಧ್ಯಾಹ್ನ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ನಾವ್ ಇಲ್ಲೇ ಇದೀರಿ ಮೇಡಮ್, ನಿಮ್ಮ
ಸಿಟ್ಟಿಂಗ್ ಇದೆ.
ಇಲ್ಲೇ ಇದ್ದಾರೆ ಮೇಡಮ್ ಅವರು. ಇಲ್ಲೇ ಇದೀವಿ.
ಸಿಟ್ಟಿಂಗ್ ಏನ್ ಸರ್ ನಿಮ್ಗೆ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 7, ಲಿಸ್ಟ್ ನಂಬರ್ 2.
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 7.
7 ಅದು ಡೇಟ್ ಬೇಕು, ಅದು ಕಮರ್ಷಿಯಲ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅದು.
ಅದೆಲ್ಲ ಏನು ಹೇಳಿಲ್ಲ ಮೇಡಮ್, ದೇರ್ ಇಸ್ ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಫಾರ್ ದಟ್. 7 ಗೆಲ್ಲ ಏನು ಹೇಳಿಲ್ಲ. ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ 21 ಏನೋ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ನೋಡಿ ಮ್ಯಾಮ್.
ಏನ್ ಬೇಕು ಹೇಳಿ. 67 ಇಲ್ಲ ಯಾವುದು ಕೊಟ್ಟಿಲ್ಲ
ಮ್ಯಾಮ್. ಲಿಸ್ಟ್ ಅಲ್ಲಿ 21 ಏನೋ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ನೋಡ್ಬೇಕು. 1 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ 3.
ಇಲ್ಲ ಅದೇನು ಯಾರು ಸಬ್ಮಿಟ್ ಮಾಡಿಲ್ಲ. ಕಾಲ್ ಔಟೇ ಆಗಿಲ್ಲ ಇವ್ರೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇಸ್ ನಾಟ್ ಕಾಲ್ಡ್ ಔಟ್. ಇವಾಗ ಬರೀ ಸ್ಪೆಸಿಫಿಕ್ ಸಬ್ಮಿಷನ್ಸ್ ಇರೋದು ಮಾತ್ರನೇ ಆರ್ಡರ್ ಆಗಿರೋದು. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅದೆಲ್ಲ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ. ಅದೇನ ನೆಕ್ಸ್ಟ್ ಇವಾಗಲ್ಲ, ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಏನ್ ಬರುತ್ತೆ ಸಂಜೆವರೆಗೂ. ಸಂಜೆಗೆಲ್ಲ ಕಾಯ್ಬೇಕು, ಸಂಜೆವರೆಗೂ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
Court officer. Court officer.
Okay.
This is a defendant's writ petition, my lord. The plaintiff has filed the suit for permanent injunction against me. The plaintiffs are none other than the father of the defendant. Prior to that, there was a suit filed by the sons against him for partition and separate possession, challenging the partition deed. That suit, my lord, came to be decreed in favor of the defendants herein. That is OS 33 of 2006. Annex C, I have produced the plaintiff copy, and preliminary decree I have produced at Annex D, my lord. Having knowledge of this fact, my lord, he has challenged the decree passed by in OS 33 of 2016. That came to be allowed by the first appellate court. Against which I have filed the RSA. Second appeal is pending, admitted, and the matter is pending.
What is the suit number? Suit is filed for?
OS 33 of 2016, the earlier suit. Now present suit was
No,
filed by him
33 of 2016 is filed for the relief of?
for partition and separate possession.
What happened
And
to that?
cancelling the partition deed, which
What happened to that?
sir, decreed in the trial court decreed the suit. He filed appeal where it was reversed, against which, my lord, the plaintiffs before the Sambal court in regular second appeal, it is admitted, matter is pending before the Sambal court, and interim order also granted.
What is the present suit?
Now, my lord, he has filed the suit for permanent injunction, restraining us from interfering with the possession of the property, which is the subject matter of the suit in the earlier. That is the joint family property. Both are enjoying it. And therefore, I filed an application under section 10 of the CPC, staying the subsequent suit, because same issues have been involved in the earlier suit, and it is now to be considered by the Sambal court. That application came to
Come to the order.
Impugned order, your lordship, at Annex G, my lord. Page 48. Relevant paragraph, my lord. Para 10. It is only a permanent injunction, therefore, the section 10 is not applicable. That is the view taken by the trial court. That is incorrect according to me, because a permanent injunction suit against the same suited property, and if the decree is granted, I have been restrained from enjoying the property. Though it is a joint family property, all are having, your lordship, right to enjoy it. So therefore, it is directly affected. There it is that property is involved.
Court has extracted section 10. Please read it.
That is section 10.
Read it. That's what is the application filed.
No court shall proceed with that of any suit in which the matter is in issue is also directly and substantially in issue in the previous suit, instituted suit between the same parties or between the parties under whom they are or any of them claim or litigating under the same title, where such suit is pending in the same or any other court in India have jurisdiction to grant the relief claimed by or any court beyond the limits of India established continued in central government and having the jurisdiction before the Supreme Court. Here, my lord, your lordship is aware, it is a continuation of suit. The RSA is a continuation of the suit, earlier suit. So therefore, the findings recorded therein is also pending before the Sambal court. Whether the plaintiff in the present suit is entitled for entire extent or is entitled for 1/3 share in the, as decided by the earlier suit. That is the Malad issue. Now, under the guise of this permanent injunction suit, if the decree is to be passed, then Malad the findings recorded.
Where is the plaint?
Plaint, your lordship, get it, the present plaint, your lordship, get it, annexure A. Annexure A is the present plaint, Malad, in OS number 155 of 2023, Malad. Between the same parties, Malad. And subject matter of the Malad suit is the same property.
No, that's what I want to see.
Page 16,
Where is the
Malad.
present suit?
Page 16, schedule. That is the plaint schedule.
No, this is, one suit is in respect of 25 acres. One suit is in
Here,
respect
what
of
he has
15
done is,
acres.
your lordship can see, eastern boundary, western boundary shown as that property allotted to me. That is shown. Therefore, he got 15 acres out of 25 acres that has been shown. That is the schedule given. Wherein in my property, your lordship kindly see OS 133, but 33 of 2016, annexure C.
I have seen that. That is 25 acres.
Same 25 acres total extent. I have shown total extent. He has shown 15 acres. That's all. Different. Same property. He claims that partition in the year 95. On that basis, he claims that was nullified by the trial court, and appellate court is reversed it. Now the matter is pending before with regard to partition is concerned. He mentioned the schedule as per the partition deed. That has been challenged in the earlier suit, and the trial court holds that the partition deed is illegal. Appellate court reversed it, against which I am before the sample court. It is RSA is pending, my lord. He also admit that RSA is pending. RSA at 1246 of 2022. Month.
Please come. The present writ petition is filed. Agreed with the orders passed in I number 4. It's number 155 of 2023 by the Principal Civil Judge and JMSC, Chelikare, dated 24 September 2025. The defendants are now defendant number 2226 are before this court. They filed an application under section 10 of CPC with a prayer to stay the further proceedings of the present suit till disposal of RSA number 1246 of 2022. It is a case that earlier, in respect of the very same property, OS number 33 of 2016 is filed seeking partition that came to be decreed. Against that, an appeal is filed, and the appeal, the court has reversed the judgment and decree passed by the trial court. Against that, an RSA is filed. RSA is pending consideration. After that, in the meantime, the respondent herein has filed a suit, that is OS number 155 of 2023, seeking injunction. It is a case that the properties are one and the same. In those circumstances, unless and until the RSA is decided, the rights of the parties are not crystallized, and the court cannot deal with the suit for injunction that came to be dismissed by the court by order impugned. While dismissing the application, the court observed that the parties to the suit have admitted that the RSA is pending between the plaintiff and defendant number 2 and 3, whereas in the present suit, the plaintiff has sought relief against the defendant number 1 to 6. The parties to the present suit are not the parties to the RSA number 1246 of 2022. Further, in the present case, plaintiff has sought for permanent injunction against the defendants to restrain them from interfering with the plaintiff's position and enjoyment of suit scheduled property. But the RSA is pending in respect of partition and separate portion of the suit scheduled property. Hence, the matters in issue are different. It is not in dispute. The plaintiff has filed the suit after initiation of RSA by the defendants and is not in dispute that said RSA is pending. However, an appeal is a separate and distinct legal proceedings from a suit, and that it cannot be considered as a previously instituted suit. And the court is of the opinion that none of the conditions are fulfilled for application of section 10 of the CPC and accordingly dismissed. Land counsel appearing for the petitioner submits that the appeal is nothing but continuation of the suit proceedings. And the court has failed to appreciate the scope of section 10 of the CPC. And if the RSA and if the suit proceeds pending disposal of the RSA, it would cause a lot of prejudice to the petitioners, and there is every likelihood of conflicting orders from two courts, and all these aspects were not appreciated by the court. Next paragraph. Having heard the counsels on either side, peruse the material on record. There is no dispute about the pending proceedings. When the RSA was pending, this present petition, the present suit OS number 155 of 2023 is filed. In 155/2023, they have narrated about what all the earlier litigation and all. It is a grievance of the petitioner plaintiff in OS number 155/2023 that during the pendency of the said proceedings, the respondents are trying to interfere with the peaceful portion and enjoyment of the plaintiff therein, and is sought for an injunction. In the considered opinion of the court, both the RSA and the suit are two different and distinct prayers, and there cannot be any difficulty that both the suit as well as the RSA can be proceeded with by the court in that view of the matter. This court do not find any reasons. Dismissed.
I appear for the petitioner in this matter.
Yes.
My lords, this petition has been filed for consideration and disposal of IA number 17, my lords. That is application under audit 22 rule 10, my lords.
When it was filed?
My lords, it was filed in the year 2024, my lords. And the expeditious disposal of the suit, my lords. The suit is of the year 2014, my lords. Objections have been filed. It has been.
Which court is this?
My lords, it is in Magdi, my lords.
Huh?
Magdi.
Magdi.
Yes.
The writ petition is
Senior
filed.
judge.
Sing the following prayer. Yeah, main prayer is to dispose of IA.
IA and.
No, interim prayer is to grant stay of all further proceeding.
My lords, in case.
This is how these writ petitions are filed, and so many cases in a mandamus proceedings are stayed. How can you ask for this kind of a relief?
Apologies. May be kindly disposed of, my lords, with the directions to the court.
The writ petition is filed. Sing the following prayer. Land counsel for the petitioner submits that the suit is filed in the year 2014, and an IA is filed on Order 22 Rule 10 CPC. That's IA number 17 on 28/6/2024, and so far the court has failed to consider the same. Next paragraph. And it is land counsel submits that there may be a direction to dispose of the IA as well as the suit as expeditiously as possible, as it is a suit of the year 2014. Next paragraph. Concerning though in every matter, in every case of mandamus, this court is not passing orders. A court is not passing orders in the light of the judgment of the Honorable Apex Court and so and so. However, coming to the facts of this case, this is a suit of 2014. That's already 12 years have elapsed, and also this is for pending before Additional Senior Civil Judge and JMFC at Magadi. This court deems it appropriate to pass the following order. The writ petition is disposed of, directing the court to dispose of the suit itself. What is the present stage?
My lords, they have sought for amendment of the written statement, my lords. Without this application being allowed, that application cannot be considered, my lords. It's for objections.
No,
to
you're
the
seeking expeditious disposal of the suit.
Yes, ma'am.
What is the stage of the suit? That I should under, no.
My lords, it is for the objections, my lords. For the subsequent IA filed by the defendants, my lords.
Don't do that. Just this is the following prayer. Then counsel for the registrar judicial is directed to call for a report from the concern. How much time it requires to dispose of this matter? Thursday, the first is.
In this matter, my lord, I am appealing for the petitioner. My lord, the petitioner challenging the impugned order, my lord, annexure J, impugn number 81. The fact of this case is this, my lord. The petitioner
What is
in-
that IA?
my lord, IA number 151 of CPC filed an application for stay the all further proceedings in FDP. He has filed a miscellaneous petition before the same court. A miscellaneous petition was pending. My lord, the suit for partition and separate possession and declaration and declaring that the sale
Why
deed-
you should have sought the further proceedings in the miscellaneous?
miscellaneous, my lord, I have filed a miscellaneous, very same court, my lord. This matter was pending before the very same court for
What I'm
objection.
asking, in the miscellaneous, you should have sought for stay of FD
I have filed
proceedings.
an application till now, my lord, they are not considered the pending consideration. The petitioner is a purchaser, he are purchaser,
So we'll ask the court to consider that IA.
please.
This I'll confirm.
My lord, my request, matter may be disposed of, my lord, directing the
The present writ petition is filed questioning the following, seeking the following prayer. Then consider the petition submits that the suit is an ex parte judgment and decree passed, and the petitioner has filed a miscellaneous and also filed an IA seeking stay of the execution proceedings. The court has not considered the same. Hence, the petitioner has moved the FDP court seeking under 151, seeking to stay all further proceedings that came to be dismissed by order impugned. It is submitted that unless and until the proceedings are stayed, the miscellaneous itself will become infructuous, and all these aspects were not considered by the court. Considering the submission of the counsel for the petitioner, this court is passing the following, before that, as far as the order impugned is concerned, this court is not inclined to go into the merits of the matter. However, considering the submission of the counsel of the petitioner, this court is passing the following order: the writ petition is disposed of, directing which court?
very same court, my lord, and third additional senior civil judge and
Third
CJM.
District Senior Civil Judge and CJM Mysore to dispose of IA number
1 and 2, my lord, before the, in miscellaneous petition.
IA number 1 and 2 in miscellaneous number. When did you file that?
My lord, miscellaneous petition filed on 3/12/2025.
IA number 2
One, my lord, one is the limitation, 2 is, my lord, the stay application. Both, my
have
lord,
to be heard.
please.
Notices are served.
Notice, sir, madam, matter was posted for
IA
objection.
number 1 and 2 within a period of 4 weeks from the date of receipt of the copy of the order.
Obliged.
Here for the petitioner, my lord. My lord, the petitioners are the judgment debtors, my lord. My lord, the execution petition, my lord, it's ordered to order directing the jurisdictional police to give the protection, my lord. My lord, the suit is for the permanent injunction, my lord. I am the defendant before the trial court, my lord. The suit is declared, my lord. My lord, survey number 1 is the government Gomala land, my lord, wherein, my lord, the plaintiff has granted the 3 acre.
Happened to the appeal.
My lord, appeal is also dismissed, a regular appeal, my lord.
No, we will not go into all those aspects.
My lord, the second appeal is pending, my lord.
Any stay?
No, my lord, stay has not been granted, my lord. But
Then
my
in
lord,
that case, where is the question of going into the merits of the matter?
my lord,
Gomala land or not?
but my lord, here the police protection has been ordered, my lord. I am in the possession of the property, my lord.
That's what is execution.
My lord, here, my lord, there is a dispute with regarding to the identification of the property, my lord. That has been observed by the trial court, my lord. Kindly see, my lord, page number 28, my lord. Page number 28, para 11, my lord, of the trial court judgment, my lord. It's a government Gomala land, my
No,
lord.
I'm not sitting on appeal on this.
Yes, my lord. But my lord, the police protection has been ordered in their favor, my
There
lord.
is an injunction. It
Yes,
has to
ma'am.
be implemented.
But my
They
lord,
are
I am the.
entitled for police protection.
Yes, my lord. Kindly see one paragraph, my lord, in the trial court judgment.
I
my lord.
can't
And-
look into it because I'm not considering that order. Come to the present order.
My lord, the present order, my lord, page number 53, my lord.
Yes.
My lord, initially, my lord, the order written in the handwriting, my lord, no representation, issue notice to the JDR if PF paid, my lord. And it is posted to 27,
For under Secretary 5 days, highway or the rural police from Patna.
without notice to me, my lord, they advanced the matter and this order has been passed, my lord. Because, my lord, kindly see on the first order, my lord, it's colon 27/2/2016, 26, my lord.
How can you resist this? How can you resist this? judgment and decree has become final.
Yes, my lord.
Or
But,
you have
but
filed
here,
a
my lord,
second
the second appeal
there
is
is no
pending, my lord.
stay. You are supposed to have stay of the execution.
Yes.
You don't have a stay. Now, whatever is the judgment and decree that has to be implemented, they're seeking police protection for that.
My lord, I am in the possession of the property, my lord, because my lord, it's a
You are
my
in
lord,
possession
one
of the
submission, my lord.
property.
My
How
lord,
can
it's a government land, my lord. It's around 100 acres of land, my lord. There is a dispute with this,
injunction order granted against you me itself says that you are not in possession?
my lord.
You can't contend.
My lord, kindly
Injunction is
kindly
against
see
you.
para 11 of the trial court judgment, my lord. Here, my lord, 3 lines, my lord. May I read, my lord? On perusal of the records, it appears that there is a dispute between the plaintiff and defendants
After that
in
appeal.
regard to identification of their property.
After
Therefore,
that appeal, second appeal, why
is
are you
pending.
reading trial court order, which is affirmed by the appellate court?
Yes, my lord. And my lord, they are directed both the parties to file a joint application for the demarcation of the property, my lord. It's a pending, my lord. The applications has been filed, my lord, before the Tahsildar.
where?
It's a vast land, around 100 plus acres of land is there, my lord, in survey number 1. They are granted the 3
Why
acres
you
of
don't have
land.
a, why you have not obtained any interim order in the appeal?
My lord, there is a delay in filing the appeal, my lord.
How many years?
My lord, 7 years delay is there. Now, my lord, the execution also filed in the year 2026 only, my lord.
You can't stop it.
Limited period, my lord, the protection may be given, my lord, till appearance. Because, my lord, the trial court itself, my lord,
Granting an interim order in undeserving case is doing injustice to the respondent.
but my lord, the
That
trial,
is what I feel.
Lord, the trial court is observed that there is a dispute with regard
Forget
to
about
the
trial court,
identification.
appellate court, RSA, and RSA filed after 7 years.
Yes,
When will they have enjoy the fruits of the decree?
my lord, they are
Notice.
much obliged.
Yes.
Lord, I filed a suit for permanent injunction before the trial court. I also filed an application for interim protection without restricting the respondent's herein for not to interfere with peaceful management. The trial court has refused my prayer and it is at annexure, page number 23, annexure A, my lord.
Page number?
23, my lord.
Petitioner is agreed with the order dated 16/7/2026, whereby the court, without passing orders on his application, that's an interim injunction, had issued suit summons, the same order, 1 week, and in all those cases, they can advance the matter, that clause also. Yes.
Here for the petitioner, my lord. My lord, the petitioner is before this honorable court challenging the order dated, my lord, 4/7/2026, my lord. The trial court, the executing court has passed an order, my lord, to issue a warrant executing the sale deed in favor of the decree holder, my lord. My lord, the property is not at all available to attach and also to register in the name of the JDR, my lord, because the property was already mortgaged to State Bank of India, my lord, on 30th/8/2021, prior to the compromise decree has been entered, my lord. And I had paid this some amount, my lord, before the trial executing court. And I have brought to the notice of the executing court that there is a DRT proceedings pending against the same property. In spite of that, my lord, this honorable court has, the executing court has passed an order that will lead to multiplicity of proceedings, my lord. And
don't worry.
My lord, the reason is that
whoever the bank will take care. Why are you bothered about the
my
bank?
lord, the reason is that, my lord, I am residing in that property and I am paying.
That's the point.
And I am paying the monthly installments to the bank, my lord, as per the orders of the DRT, my lord. And I have paid approximately 3 lakh rupees, my lord. The total outstanding is 14 lakh rupees, my lord. And I have paid 3 lakhs during the proceedings, my lord. And this amount is substantially reduced, my lord. The property worth more than 30 lakhs, my lord. And the half of the value, the entire property is actually is ordered to register the sale deed in favor of the decree holder. It will virtually affect the financial condition of the JDR, my lord. That's why I will make the payment, substantial payment to the decree holder, my lord. That's my only submission is that, my lord, if this property is actually given to the JDR, my lord, even for that That is the amount, pending amount is only 10 lakh 50,000, my lord.
Deposited.
My lord, my only submission is that, my lord,
Deposited.
my lord, as of now,
You can't have the cake and eat it too.
my lord, my only submission, some amount I'll deposit initially.
No sum. If
There
you
is-
deposit,
there is, my lord,
first of all, that kind of indulgence is also not required. If you say whatever is outstanding, you're ready to pay and your property should not be auctioned or sale deed to be executed, you pay
my
the
lord, the
amount.
trial court has erred while attaching the property without looking into the encumbrance, my lord. The trial court has attached the property without making any observation, my lord. And there is no speaking order in the entire proceedings, my lord. And
That we will see. First of all, you show your bona fides.
my lord, she's a housewife, my lord, and the property stands in her name. That is all, because husband is working in a police department. He will make some effort. He has a health issues, my lord. The petitioner's mother is also suffering from cancer, my lord. That's why I have produced this document, my lord. She is actually trying to arrange the funds, my lord. She had made substantial amount of 3,50,000, my lord.
According to you, 3 lakh is substantial amount.
My lord,
When the amount outstanding is 13 lakhs.
my lord, the outstanding, even though, my lord, she has made an effort and she has actually deposited, and some amount she will make, my lord.
No
She will-
some amount.
My lord,
Some
the
amount I will
entire,
not interfere.
my lord, the entire 10 lakhs will be, it is very difficult for her.
Then on what basis this court should interfere?
My lord, the one, otherwise multiplicity proceedings will happen, my lord. And ultimately,
Don't worry. Why are you worried about multiplicity? Bank will take care of it.
my lord, there is a procedure irregularity, my lord, as per the order, my lord.
You don't deny the fact that you have taken the money.
My lord, no, my lord, it is obtained, my lord. Initially, the agreement was entered for 7 lakh rupees, my lord, and subsequently it was compromised for 14 lakh, my lord, agreeing to pay that amount, my lord. It is more than the
When was the
twice of
compromise?
my lord, compromise had entered as per the
Date.
my lord,
Compromise.
it was compromised on my lord, compromise was entered on 19/12/2023, my lord.
And you don't pay the amount from the last 3 years.
My lord, I had made substantial payment, my lord, some amount I have paid, because at the same point of time,
No, what is the dictionary meaning of substantial?
my lord, the reason is that, my lord, I was not able
No,
to
I'm
pay.
thinking that I'm not able to understand the meaning of substantial.
No, my lord.
14 lakhs, you pay 3 lakhs, and so substantial amount is paid.
My lord, she has to pay the other amounts to due to the SBI
Please,
also, my lord.
I'm not inclined to interfere. If you come up with some time, whatever it is, but without that, I will not interfere with this order.
My lord, kindly have it on next week, I'll see that.
Next week.
But till then, my lord, at least.
No.
My lord,
No,
if they
no
register
interim
the
order.
sale, my lord, if they
Interim
register the
order
sale,
only on condition.
my lord, if the registered sale deed is executed, nothing remains, my lord. My petition becomes infructuous because they have already issued the attachment warrant, and next date is on 28, my lord. 28/8, they have to report the sale deed.
There's long way. You can come within 2 days.
My lord,
Come
20
within 2 days. 28th is when? 28th is? It's
28th of
almost
this-
2 weeks. Another 2 weeks.
Please, my lord,
Oh, when do you want?
kindly have it on 25th.
20?
25th,
This on 25th.
please, public.
In this case, I'm appearing for petitioner, ma'am.
What is that?
Petitioner, my lord, I'm appearing for. The suit is filed by the plaintiff for partition and separate possession of the scheduled property against his brothers and the purchasers, my lord.
What is IA?
IA for amendment of pleadings and prayer.
What is the prayer now you want to insert?
That sale deeds already we have stated. The details of the sale deed we have not mentioned in the schedule, prayer column.
2008 suit. Now you will see cancellation of the sale deeds now.
No, it is already prayer is there, my lord.
Uh,
Only the reference, that sale deed reference document.
Let's see that.
IA filed by the plaintiff under order 6 rule 17 of CPC that for the reasons shown to in the accompanying affidavit, the plaintiff most respectfully prays that this honorable court be pleased to permit the plaintiff to amend the plaint and prayer as follows in the interest of justice and equity. To be added as 8A, the plaintiff submits that suit schedule D property bearing 25/1 of Chaknalli village, Jala Hubli, Bangalore North Taluk, measuring 1 acre 1 gunta, originally belongs to plaintiff's ancestral and joint family property. The same was sold by father of the defendant number 1 and 2 in favor of SP Rajanna on 8/12/1969, and subsequently the said property was purchased in the name of the father of the defendants 1 and 2 on 5/10/1970. The said property bounded east by so and so property detail mentioned. And B, 8B to be added, the plaintiff submit that sale deed with respect to suit schedule item number A registered in the name of defendant number 4, while sale deed registered in the sub-register office at Yelahanka. With respect to sale deed in respect of B and C scheduled properties, while register number mentioning and with respect to D scheduled property also the reference has been made. Volume so and so of the sub-register Devanali, and the sale deed executed by father of the defendant 1 and 2 by name Narsimaya. Prayer is already there, not binding on the share and the only thing is the reference of the document not mentioned.
But you're asking to delete boundaries also.
Because boundary is wrong, I have to ask to delete that boundary.
Evidence is completed.
Same boundaries, nothing is changed. Recent boundaries, none is made.
Same boundaries, then don't change it. When counsel for the petitioner submits that.
And the defendant has not taken any contention in the written statement.
Already there is a prayer with regard to that, with regard to the sale deeds that are executed. They are not binding on him. However, the number of the documents could not be mentioned. As such, he has come up with the present application, and the court has failed to consider the same. Considering the submission, they shall be stay of all further proceedings. Yes. And someone say, yes.
Defendant's writ petition, my lords. Defendant is challenging the order passed by the trial court, commercial court in order 6 rule 17 amendment. Plaintiff sought for amendment to include the properties which are nothing to do with the suit claim. My lords, plaintiff is the developer. The petitioner herein who are defendants are the owners of the land, or that is the suit schedule property. They had entered into a JDA, my lords. The joint development agreement envisages that the same shall restrict alone to the suit schedule property and development of the suit schedule property. And furthermore, my lords, the JDA also envisages that if any differences or if any indemnification ought to be required, the same shall be adjusted among the shares as has been derived between the parties in terms of the said JDA. Now, my lords, by virtue of this amendment, my lords, the plaintiff is totally jumping the ship and including my property, which has nothing to do with the subject claim, the cause of action or the suit claim. Suit is for damages and arrears, my lords. Subsequently, he sought for partition to the extent of JD. To the extent of JD, where he sought for partition of 53% of his share and 47% of my share. Thereafter, my lords, he sought amendment after institution of the suit recently in the year 2025. The commercial court allowed the same. I did not challenge the said amendment. I filed my written statement because the said partition was part of the JD.
That was affirmed by the Honorable Supreme Court.
No, my lords. That is the reason, the finding given by the court. Yes, my lords. That is the reason I said I obliged to the orders of the commercial court. I did not challenge. On record, I did not challenge. What the trial court, commercial court says, my lord, says, it says that it traversed up to Supreme Court, which is totally false. Which is totally false, my lords. I have produced amended plaint as well as I have produced additional written statement, which is filed within time, and I have not challenged it. This is one of the grounds, my lords, I have raised before this court.
Similar application was earlier filed by the plaintiff seeking
Yes, ma'am.
permission to add the relief of partition. The matter went before the Honorable Supreme Court of India to test the order of this court rejecting the said application.
No, my lords.
Which was confirmed by the so.
No, my lords. This is totally false. I am on record. It is one of my ground. in the writ petition memorandum, I have openly asserted this is not the condition. I oblige to the orders passed by the commercial court.
Whatever it is, then how is he going to change it? Well, earlier amendment is ordered.
Earlier amendment is
That
ordered.
is gone to Supreme Court or
No.
otherwise, it is ordered.
Yes, earlier amendment is ordered.
Yes.
That pertains only to suit schedule property.
Yes.
That pertains only to suit schedule property. Now what has happened, my lords? Kindly peruse the IA, my lords.
Please come to the IA. Please come to the
Yes,
IA.
my lords. My lords, IA is forthcoming at page number 159, my lords. Sorry, my lords. Page number 161, annexure K. Page 162 is the amendment sought for. May I read, my lords? It is sought for amendment at para 14. It is relevant to note that the suit schedule property, a common cannot be explicitly partitioned without depriving the plaintiff of his legitimate commercial interest in upcoming from the JDA.
Yes.
He adds other property, my lords.
Increase the time. Little bit. Increase. Yes.
Therefore, it is imperative to include the include for partition the adjacent developed property owned by the defendants. My lords, this is an adjacent developed property. This is my individual property. It has nothing to do with the JDA or the suit claim or the cause of action. My lords, the cause of action arises out of the JDA. The JDA pertains only suit schedule property.
Where are your objections?
My lords, my WS is at I have filed additional WS as well as the original WS which I have filed. My lords.
Objections to this.
Objection is after the IA, my lords. At page number 166, annexure L. May I read, my lords? Para 3, my lords, at page 167. It may be pertinent to note that the suit emanates out of the contract, that is the joint development agreement as entered between the plaintiff and the defendants dated 16/12/2015, and with regard to the suit schedule property alone, that under the JDA wherein it is agreed that the developer shall be entitled for 51% of land and proportional construction warehouse therein approximately so and so, and likely the owner shall be retain the remaining 43% of land so and so. That as the dispute allegedly arose with regard to the implementation of the JDA, under which the subject property therein was the suit property herein, plaintiff has instituted this suit. It may be pertinent to note that the plaintiff on earlier occasion, that is prior to institution of admitted, acknowledged and raised the claim and asserting that the same pertains to suit schedule property which is admitted subject property of the
Then comes to the petitioner, submits that petitioner defendant submits that an application is filed under order 6 rule 17 seeking amendment to the pleadings by introducing altogether a different case. The plaintiff has, the defendant has filed his objections in the court without considering any of the objections in a mechanical manner allowed the application. Considering the same, there should be stay of all further proceedings.
My lords, apologies to the indulgence, my lords. I am appearing for the state of the stay may not be granted, my lords. I will take notice on behalf of the respondent. I may be heard before any stay is granted.
Yes.
For the petitioner, my lords. My lords, the petitioner is the defendant in the suit filed by the respondent. My lords, the respondent had filed a suit seeking for declaration that the gift deed executed by the defendant number 1, who is the father, in favor of the petitioner as null and void, and for injunction, my lords. Thereafterwards, my lords, after the closure of the evidence of the plaintiff side, my lords, the respondent plaintiff had filed an application under order 6 rule 17 contending that to insert the prayer of partition in the suit for declaration. In the plaint, he had contended that in the oral partition between the plaintiff and defendants, the defendant number 1 being the father of the plaintiff and defendant number 2 had given allocated the property, making it half, and the northern side fell to the share of plaintiff and the southern side fell to the share of defendant number 2. But now, my lords, when after the closure of the evidence, later he filed an application seeking to amend the plaint, including the relief of partition and the separate position of his share in the suit schedule property. For that, the petitioner filed an objections, wherein, my lords, the Honorable Trial Court, by the order annexure at E, allowed the application seeking for amendment hence this writ petition action. My lords, the page number 40 may be kindly looked into. That is the impugned order, my lords. Para number 14. On going through the proviso of Order 6 Rule 17 of, it is very much clear that no application for amendment shall be allowed after the trial has commenced. In the instant suit evidence just commenced, it is noticed that the plaintiff intending to amend the plaint and adding new prayer, and he contended that the present amendment mentioned.
The counsel for the petitioner submits that earlier suit is filed. Questioning the gift deed.
Pardon?
Questioning the gift deed. What is the suit for? Declaration that the
To declare that the gift deed executed by the defendant number 1 in favor of the defendant number 2 is null and void.
questioning the gift deed executed by defendant number 1 in favor of defendant number 2 as null and void. The suit is filed. Now the petition is, now the IA is filed, seeking amendment of the pleadings by inserting a new period that is entitled for partition, which is contrary to the earlier case of the plaintiff. By virtue of this amendment, the plaintiff is introducing altogether a new case which is not permissible. Consider the submission, they should be stayed.
May I?
Yes.
The plaintiff filed a suit, my lord, seeking for partition concerning 2 scheduled properties, my lord, seeking for 1/5 share. Lord, I filed an application to Order 13 Rule 1 and 2, restraining the defendant number 4 from putting up construction in item number 2 property.
Where is that?
My application is allowed before the trial court. Lord, MA came to be filed. In MA, my lord, they seek for a stay. Without any reasoning, my lord, the injunction order of the trial court is stayed by the first appellate court. Annexure H is the impugned order. In fact, my lord, the reasoning given by the first appellate court is in my favor. The final order, my
What
lord,
is the impugned order?
impugned order Annexure H at page 76. Para 8, my lord, at page 79.
What is the injunction granted?
Lord, injunction before the trial court is restraining the defendant number 4 from putting up construction in the schedule item number 2 property till the pendency of the suit.
Where is this appellate court's order?
Page 80, my lord.
Page?
80. In fact, my lord, the reasoning is in my favor. The final order is against me.
Then counsel for the petitioner submits that the court has granted injunction, interim injunction, restraining the defendants from making further construction. The defendant has carried the matter in appeal, and the appellate court, without giving any reasons, and just like that, has stayed the order of the trial court. Now, by virtue of which, if the defendant proceeds with the matter, it would cause a lot of hardship to the plaintiff, and the reasons and the order impugned is bereft of reason considering the same. There shall be stay of operation of the order dated so and so.
But may I seek for dispensation of notice?
And this will not preclude the court from hearing the matter. Yes.
The dispensation of notice with respect to all respondents except respondent number 4.
Notice to respondent number 4. Give the memo.
Please.
Remaining respondents dispensed with. Yes, next.
Great.
Other 39 2A proceedings are pending for more than 9 years more. The 39 2A proceedings are pending for more than 9 years. What is meant to be summary adjudication, Lord, while the main proceedings have also completed. Please see the order, Lord, at page 63. The order in respect of against which contempt proceedings were initiated. Please see 63. Lordships are there, Lord?
Yes.
Prima facie case has been made out. If TI is not granted, purpose of filing the suit may be infructuous. Hence, issue ad interim TI restraining the respondent from taking any action against the petitioner pursuant to the show cause notice dated 24/5/2017. Now, this was a notice asking why the partner must not have been expelled. It's a partnership dispute between 3 partners within the family.
After that, what happened?
Ultimately, my lord, there is a reference to the arbitral tribunal. Arbitral tribunal, after hearing the dispute for about 8 years, has reserved judgment. In the arbitration, it was a claim for dissolution in accounts. Ultimately, his grievance was that he should not be expelled. He's filed a claim before the arbitrator, which I have produced now, in which his claim is for dissolution. If he was expelled, he could not have filed a claim for dissolution itself. So, frivolous proceedings under Order 39-2A continue even today.
Please come.
Yes.
The petitioner is seeking the following prayers. Call for a report from the concerned court. How much time it requires to dispose of those matters. This is matter on Thursday.
Briefly.
For representation in the month of October.
Petitioner, my lord. It's a petition filed seeking mandamus, my lord, against respondent number 1 to take necessary disciplinary action as against respondent number 5. GMKB matter, my lord. Lord, at Annexure A, my lord, page number 13, Supreme Court in Civil Appeal number 14604 of 24 issued general direction at page number 44, my lord. All the necessary service, page number 44, point number 4, my lord. All the necessary service connections such as electricity, water supply, sewerage connection, etc. shall be given by the service provider / board to the buildings only after production of completion / occupation certificate, my lord. My lord, it came to the notice of the petitioner that in one such case in Mysuru, the connection was given without OC and CC in violation of.
Who are you?
I'm the complainant, my lord. Complainant who complained against the irregularity or illegality, which was actually.
Why are you concerned?
We are not concerned, my lord. We are just public, my lord. We just raised our complaint.
Not public interest litigation.
My lord, but I've already made a complaint.
So
Based on my complaint, internal inquiry reports are already made. Based on that, they have to take action.
In that case also, go before the first court. Public interest litigation, you can't file a petition of this nature. Why should this court interfere?
My lord,
Don't have
I'm
any
seeking
personal-
simple mandamus, my lord.
Mandamus will not be given for the sake of asking it.
My lord, necessary discipline.
First of all, how are you concerned?
My lord, I am also an electrical contractor, my lord. I'm also an electrical contractor who's a public, and noticing this illegality, I filed a complaint.
Or you're in the public spirited individual. Should file a public interest litigation.
My lord, but the thing is, my lord, there is necessary action already taken, my lord. Inquiry reports are already made.
Why are you after them?
My lord, we are not against them or anything, my lord. They have actually done the illegality, my lord, and they have violated the Supreme Court's order and KR 6 circular, my lord. It came to our notice, we filed the necessary complaint as against them. The managing director issued a.
You are under what capacity? Why you are concerned about what the electricity department is doing?
My lord, if the Supreme Court has passed such an order, will it not be applicable to all the boards across the nation?
The present petition is filed, seeking the following prayer. When counsel for the petition submits that he is a public spirited individual, and in the light of the judgment of the Honorable Apex Court, he is pursuing the irregularities, illegalities committed by the
Respondent number 5.
Respondent Electricity Department. If petitioner is really interested, if the petitioner has a public interest in that regard, he has to go before the
necessary notice may be given, my lord.
Appropriate court having a roster to hear this public interest litigation, and this court is not inclined to pass any order. Accordingly, this petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
My lords, the petitioner enters into an agreement of sale with respondent number 1 to 3. And
Where is the impugned order?
impugned orders produced at Annexure A, page number 12, my lords, with the operative portion being in page number 14. a suit for specific performance was filed along with an IA for seeking injunction not to alienate the scheduled property.
Yes. Petition is agreed with the order dated 4/7/2026, wherein he has filed the IA number 1 under Order 32, Rule 1 and 2 CPC, requesting the court to grant an ad interim ex parte temporary injunction. Say, the judgment 1 week. Yes, next.
Great.
It's appearing for the petitioners.
Yes.
Unless the case in hand is that there existed a lease deed between Savita Subbaya and one person called Ramesh Mulia.
Petition is permitted to take out the notice on, to serve the papers on Mr. B.S. Karthikeyan for respondent number 2 and 3. And 1, HCGP takes notice. Will,
Malod's interim order is requiring this case, Malod.
tomorrow I'll take up, serve the papers only.
Much
Yes.
obliged, Malod.
Print the name of counsel, print list in the first list. Yes,
My lord, chief, the respondent number 1 Descom has disconnected my power connections, my lord, to my building.
Mr. Devraju.
My lord, chief, similar matter already order for restoration, W number 21871.
Anyhow, let them take notice tomorrow. Tomorrow in the first list, print the name of Devraju in this. Yes, HD Devraju.
I appear, Malaj, for the petitioner. Malaj, the present petition is filed against Malaj, the order passed by the trial court against the IA number 20, Malaj, which was filed by the petitioner for amendment of plaint, Malaj. The impugned order is at Malaj, page number 16. If I may take Malaj to page number 16, Malaj.
What is the suit for?
Malaj, suit is for partition and separate possession, Malaj. I am defendant number 5. I am the agreement holder from the members of the family, Malaj. In this, Malaj, there was an earlier suit, Malaj, which was filed by me.
Who filed this order, order 6 rule 17?
Malaj, this was filed by me, Malaj. This came to be rejected. Malaj, this came to be rejected
When were you
on.
impleaded?
Malaj,
When were you impleaded?
Malaj was there from the very beginning of the suit, Malaj.
Now,
However,
what is this, this amendment you're seeking?
Malaj, the amendment that I've sought, Malaj, is at page number 17, Malaj.
17.
17. The impugned order extracts the amendment that is sought. If I may read, Malaj. The fifth defendant submits that in the earlier suit filed by the fifth defendant for specific performance in OS number so and so on the file of so and so, it has been held as per the judgment and decree dated 25/11/2017 that the suit item number 1 property is self-acquired property of the first defendant. In the said suit, the plaintiffs were parties and the findings given on additional issue number 2 in the said suit have become final. Hence, the plaintiffs are legally stopped from continuing the suit in respect of suit item number 1 property. The defendant number 5 submits that he has filed RFA number 2164 of 2017 restricted to the challenge against the refusal to grant specific performance. Hence, the suit cannot be continued by the plaintiffs in respect of item number 1 of the suit property and the findings given in OS number.
Submits that by way of an amendment. He wants to bring it to the notice of the court, the earlier proceedings, and also sought a relief of rejudicata. The court went into the merits of the matter and dismissed the application. Considering the submission, stay.
Malaj, there may be stay of the order, Malaj. Malaj, there may seek for dispensation. Notice to respondents 4 to 7, they're not contesting, Malaj.
4 to 7, discuss with at the risk of appellant. Other respondents, same hand summons. Yes.
And for the petitioner, not the respondent number 1 filed a suit for declaration against the respondent number 2 to 5, who are my close relatives. As per the partition of the year 1984, the land in question was allotted to my share of my father.
What is the IA?
IA filed impleading application filed by the petitioner claiming that he is want to implead it as one of the defendant because the suit scheduled property is a property allotted to the share of my father. The existing defendants are the brothers of my father. There was a oral partition in the year 1984. Subsequently, that partition was reduced in the year 2000 in writing. The learned trial judge, without considering the partition deed, rejected my application on the sole ground that that partition deed is not a registered one. Therefore, the same cannot be looked into. Lord, my respectful submission that even I filed a suit.
An application is filed under Order 1, Rule 10 to implead him as a party defendant in the suit. It is a case that property fell to the share of the petitioner's father. But the court, without considering all this and going on to the merits of the matter, that there is not a registered partition deed, had dismissed the application. It is submitted that when the rights of the parties are involved, the court ought to have allowed the application, as his presence is very much necessary. Considering the same, there shall be stay, notice, and summons. Yes.
My lord, I pray the interim. Please.
Yes.
My lords, I have challenged the order where the learned commercial court has rejected my application for production of additional documents, my lords. The suit is an eviction suit filed, my lords. But the reason for eviction is not that I have not been paying rent or anything, my lords. They have got.
Whatever it is,
We-
the protection of documents, the
Reasonable.
powers of the court.
Yes, my lords.
What do you say on that?
Yes, my lords. My lords, just to throw light on the facts, my lords, this is a case where the eviction suit has been filed on the reason that BBMP has issued them notices saying that the last portion of their, it's a diagnostic center, my lords. I've spent more than 5 crores in getting the equipment. So the only reason for eviction is the BBMP notices are there for deviation. So during the time of cross-examination, my lords, we put questions to the witness saying that if at all we are ready to cooperate, we will cooperate. Only the deviated part, let the demolition be done. The rest of it we will carry on. Are you okay with that? They said, no, we just want eviction. So to bring that in that light, my lords, we want to produce certain additional documents. Plus the application, the impugned order, my lords, the reasoning of the learned court is that reasonable cause has not been made out why we should have not produced, we did not produce these documents at the time of filing the written statement. My lords,
Apart from that, you have to file all the documents.
we filed, my lords. We've produced the list mentioned documents, but the only reason, my lords, the learned commercial court has not granted us is that reasonable cause was not made out, my lords. My lords, I'll just show the daily order, my lords, how this came about. It is after, my lords, at page 95, my lords, I've produced the entire order sheet of the learned trial before the trial court, my lords. My lords may see at page 95, I've cross-examined the plaintiff witness, my lords. Thereafter, I've also adduced on the same day, the learned commercial court keeps 2 stages, my lords. I've also led my own document evidence, my evidence as well, my lords. On the very next day, my lords, I file an application to produce these list mentioned documents, my lords. The IA, my lords, is at page Annexure G.
What is it you want to produce now?
My lords, certain notices issued by the BBMP to them, because the only reason what my grievance is, I cannot stand in the way of the BBMP demolishing, because that is between, but they had given an undertaking to us that they have obtained all licenses and the property is valid. Today I've taken a commercial property that is located in it's located in central of Indranagar, my lords. I've invested 5 crores and beyond. So my only grievance is, and I'm paying the rent regardless of all these notices, all the suits being filed against me. I have not defaulted in anything. And the plaintiff has agreed and admitted that the only reason for eviction is the BBMP notices. If the BBMP notices are for deviations in a particular part, the last floor of the property, I will cooperate, my lords.
For eviction.
Yes, my lords. My lords, there is a 10-year lock-in period, my lords, while I executed this. The reason for 10 years is because I'm spending substantial amount of money in getting the diagnostic equipment for the purpose of this.
Come to your application, let me understand.
My lords, the application IA, my lords, is at Annexure G, page 69, my lords. My lords, I have these. Yes, my lords.
What is the present stage?
My lords, now it's reached final hearing, my lords. The stage, my lords, I filed wakalat only in February, my lords. Already the trial is over, now it's for final hearing.
What you say is, you simply say,
My lords.
I couldn't file it, I couldn't file it along with the written statement, I am filing it now.
That's
the only
precisely what
thing.
I've said, my lords. In my application also, I've said the same, my
That is
lords.
sufficient.
I have, my lords, but the learned commercial court has not considered my application. My lords, my only request is that these documents be permitted, and I want to bring it to the notice of the court that
The final arguments at this stage, what is the
my lords,
next stage?
my lords, it's just the trial judge, the cross examination just got over, my lords. I've challenged the order which is of July, my lords, of 27th of July. My lords, the commercial court is granting just 1 week's time, and that's how it's reached final hearing stage, my lords. My lords, maybe please, if my lords is pleased to issue notice to the other side, and my lords, a direction be issued to me that I will take no time. In 1 day, I'll produce these documents, everything. I'll keep my witness present in case the plaintiff wants to cross-examine. My only request is my right to produce these documents may not be, because today I am at no fault, my lords. The plaintiff.
There are 2023 documents.
Yes, my lords, that's precisely why I did not file it at the time of written statement. My lords, because they were, my lords,
But particularly before the commercial courts, you will not get just casually whenever you feel like you can't find the documents.
I understand. I bow down to this court, my lords. But the reason these were documents sent, my lords, these eviction notices have been going since 2023, my lords. The suit was filed in 25. My lords, there was a lot that transpired where the plaintiff kept assuring the defendant that there will be no prejudice, and all these whatever is the issue with the BBMP, the same will be sorted out. My lords, my only request is, my lords, let my right, today I'm not at any fault, my lords. I've been paying the rent. I have a 10-year lock-in period. Great prejudice will be caused if they evict me for the entire property, because it's a.
I'm not convinced. I want to dismiss. If you want, I can issue notice, but no interim order.
My lords, but it's already at final hearing stage, my lords.
Dismissed. Dictate the order. Yes.
Challenging the Annexure H notice issued by the respondent authority.
What is this memo?
Posting memo. Urgency.
Do that.
The petitioner, the respondent authority issued a notice stating that withdrawing the
No, but we didn't give any memos for the fresh matters. You don't know what is happening. Yes.
The respondent authority issued a notice on 3/8/2020 stating that they are withdrawing the
What notice?
temporary connection. My lord. Now they are without obtaining.
Chennai Gowda is directed to take notice.
Stay the proceedings, my lord.
Tomorrow, I'll serve the papers on it.
Already I served the copy the board, my lord.
Mr. Chennai Gowda. Print his name tomorrow. First list. All these KEB matters in the first list. Yes. No representation in the month of October.
The plaintiff's petition. Suit is for partition. Initially, suit was filed as against the defendant number 1.
What is IA?
Well, at IA under order 6 rule 17 is concerned. Well, at impugned order is at page 34. Well, the trial court, my lord, has rejected my application only on the ground that the pleadings has already been incorporated in the plaintiff is concerned, and that the plaintiff is not tendering for the cross-examination is concerned. My lord, what my submission would be, if your lordship would peruse the my lord, synopsis for a moment, the dates. My lord, initially, please, my lord, cross-examination was taken as nil. Subsequently, at the instance of the defendants, my lord, the stage was recalled. Subsequently, my lord, an application was filed by the defendant number 2 to seeking, my lord, stay the present suit is concerned by filing section 10 application. That application came to be rejected, and subsequently the matter was posted for cross-examination. I filed an amendment application. My lord, in my amendment application, my lord, I have incorporated, my lord, Annexure G, page 60. Earlier suit, my lord, filed by my father's sisters. That suit, my lord, I have incorporated in the plaint is concerned. No doubt, please, my lord, in respect of survey number 41, there is a repetition is concerned. But in respect of this particular OS is concerned, please, my lord, there is no pleadings in the entire plaint is concerned. There is a decree.
Why are you not, you're coming up with one application after the other?
My lord,
Why you are not rendering yourself for the
my lord,
cross-examination?
I was not the one who filed the application. It is the defendant number 2 who filed an application under order
We're
section
talking
10.
about the cross-examination.
My lord, cross-examination, I was present on subsequently, my lord, after dismissal of the section 10 application. On 2 dates, please, my lord, I was absent. But subsequently, the immediate next date, I was present and section 10 application was filed by the defendant number 10 on the very same day.
Then calls for the petitioner submits that an application is filed under order 6/70 that came to be dismissed on 2 grounds. One is that already the amendment, already the said pleadings are present in para number 3 of the plaint, and further petitioner has not tendered himself for the cross-examination. It is submitted that the amendment with regard to the earlier suits and all is not part of para number 3, and these aspects are not considered by the court. Considering the submission, this shall be stay of all but the proceedings, notice, and summons. Yes, next.
Please.
Yes.
Lord, the petitioner, Lord, filed a suit for recovery of the amount by the defendants for rupees 1,44 lakhs. Then, Lord, that suit is supported by the simple mortgage deed. Then, after filing the suit, they entered appearance. They did not disputed the borrowing of the money because it is a registered document. Then, Lord, after filing the evidence in examination in chief, Lord, immediately on the same day, we filed an application for production of additional document. In addition to the document which has already filed before the suit along with the suit, the learned commercial court to technically, Lord, allowed the application in part by permitting me to mark the document serial number 1 to 8. The other document that, my Lord, the bank statement and TDS, they did not allow it. That
Come to the order. Page number.
Lord, annexure K,
Page number.
page 245, the impugned order. The only reason, my Lord, while filing the application for production of additional document, the plaintiff,
240.
my Lord, the impugned order at page 254, annexure K, the reason starts, my Lord, 259. The reasoning, my Lord, the main reasoning of the commercial court is that, Lord, at the time of filing the application, without there being any proper explanation, the documents came to be filed. However, my Lord, document number 1 to 8 permitted me to mark the document, and also the INM.
Let's read the word. What is the reasoning given by the court?
Pardon?
Let us read the reasoning given by the court.
Please, my Lord. From point number 1, reasons. After filing the affidavit by way of evidence on one of the plaintiffs seeking deferring the further examining the present application or filed under order under IN number 3, the plaintiff is seeking production of 18 documents. Among them, the document described at serial number 1 to 8 are the original and certified copies of the documents of the photocopies.
So this is a precise reason.
Please.
Why 1 to 8 are permitted?
1 to 8, my Lord, that is the original document which
already copies are there.
Originally, my Lord, at the time of filing the suit, the document produced, the original documents is produced.
You are saying why the court has permitted only 1 to 8.
1 to 8 because, my Lord, they are the original.
That is what
originals. Therefore, that documents are allowed. The other documents, my Lord, the bank statement showing that they have credited the interest in favor of the plaintiffs and also the.
Come to para 8 as regards 9 to 17.
Yes, my Lord. As regards the document described in serial number 9 to 17, IN number 3, it is averred in the affidavit filed in support of the application that the documents would be secured from the bank at the time of filing the suit. Among these documents, document number 9 to 12 pertains to statement of account maintained by at Kotak Mahindra Bank for a period of 2017 to 2024, 1/4/2017 to 1/6/2025, and 1/5/2017 to 31/5/2000. All these transactions pertaining to the period much prior to the filing of the suit. These statements pertaining to the bank account of the plaintiff itself, and those documents could have been easily secured from the bank, and
Yes, you could not make out a reasonable cause. All these documents are pertaining, they are much prior to the
in
suit.
my application, my lord, it is explained how I prevented from filing those documents. Despite my repeated request, the bank, my lord, it is a voluminous document. They did not provide it. Therefore, my lord, at the time of filing the suit, it has not been filed. We are under the impression that the London Commercial Court, in order to meet the ends of justice and to have a full-fledged logical trial, my lord, this application came to be filed. That too, my lord, it is not at the belated stage.
Notice. And summons. Next.
Your lordship, kindly give me date, because 22nd is the next date of hearing. The commercial court may likely to proceed further.
It can't be. It's today. It's already 17. What date you expect the court? When will the notices go?
Otherwise, for a limited period, your lordship.
Thursday. I'm not convinced. Yes.
I represent the petitioner. This is plaintiff's petition. Plaintiff filed a suit for performance. Along with it, he filed application for injunction.
Along with that?
Injunction to restrain the defendants from alienating the property. The trial court issued emergent notice.
Where is that?
It is at exhibit. Exhibit Annexure C. Issued.
The petition is agreed by so and so, so and so. Same that 1 week. Yes, next.
No, your lordship may. I am seeking for a mandamus. Direct the trial court to.
That's what I have passed.
Till then, at least they are changing the character of the property.
No, till then 1 week they will. The court will hear it.
21st court hearing is there. Now I have produced photographs also to show that they are changing the. They will create third party rights. Till then.
Yes.
The suit for specific performance. The application IN number 1 was filed for 19 acres, which was A schedule property, where the agreement was for 5 acres. Trial court observes that you are seeking for an injunction for 19 acres instead of 5 acres. Therefore, I direct issuance of emergent notice. Then we said.
What is the agreement? For how much?
Agreement is only for 5 acres.
Then how can you seek 19
I just
acres?
mentioned, my lords. Schedule A is 19 acres. Schedule B is 5 acres. Relief sought for in the plaint is also for 5 acres. While drafting IA number 1, they said A and B schedule properties instead of B schedule property. So trial court observed and said, no, I will not issue. Then we got this application IA number 1 as not pressed and filed IA number 2 saying that let it be restricted only for 5 acres, which is the agreement schedule property. The trial court says issue emergent notice.
Where is that?
That is at page number 17. Order dated 4/8/26. No reasons are assigned, Lord, similar to the order which your Lord says.
Please come. Same order.
Lord says. Great.
My lord, sir.
Yes.
My lord, sir. Suit for mandatory injunction, my lords. I am seeking writ of mandamus to dispose of the matter as early as possible, my lords. The suit,
Which year is the suit?
2025, my lords. Because, my lords, both the plaintiff and the respondent are aged about one is aged about 68 and another one is aged about 80.
25 suit, you
My lords,
asked for
what
a
happened is
mandamus.
this, my lords. I have purchased the scheduled property through a court auction. Thereafter, my lords, the respondent here in my lords has taken he is staying there till 1963, my lords. it cannot, court has, my lords, 1 year, my lord, time may be.
No, no.
My
Writ
lord,
petition is filed so and so, seeking a mandamus. This court, in the light of the judgment of the Honorable Apex Court in so and so, in each and every case, there cannot be a mandamus, and that to a suit of 2025. This court finds no reason, and this is not
my
exceptional
lords,
case.
senior citizens,
where,
my lords, therefore I'm,
Where the order can be passed accordingly. This was next.
For the petitioner, my lord, plaintiff, my lord, has filed a summary suit under Order 37, Rule 1 and 2 of the CPC. The limited challenge is, my lord, suit summons has been issued, my lord. As per Order 37, Rule 2, Sub-Rule 2, it is Form 4, Appendix B, my lord. I was not heard, and this suit summons has been issued, my lord. This is a error, grave error, my lord, because under Order 37, Rule 2, please, my lord. The order is at page 13, my lord. I have filed the
Page 13.
1-3, my lord.
Hmm.
Kindly, the operative portion on page 14, my lord, issue summons to defendant by way of speed post as well as through court, call on so and so date. My lord, I have made a specific case for summary suit under Order 37, my lord. I have complied with all the
CPC.
Order 37. Order 37, Rule 2, my lord.
Hmm.
Sub-Rule 1 talks about what compliance I need to make in the plaint, my lord. I have made all this compliance, my lord. Order Sub-Rule 2, my lord. The summons of the suit shall be in the form number 4 in Appendix B or in such other form as may from time to time be prescribed. Now I have produced a form for Appendix B format also at page 45 to 47 of the plaint, my lord. This is a specific provision.
Order 35.
Order 37.
Order 37, Rule 1.
Rule 2, Sub-Rule 2. The summons of the suit shall be in Form 4 in Appendix B or in such other form as may from time to time be prescribed.
Hmm.
And page 14, my lord, your lordship, sir. Issue suit summons to defendant by way of speed post as well as through court, my lord. It should be specified that it should be under Form 4 Appendix B, otherwise it will not be issued by the office, my
Should
lord.
have brought it to the notice of the court.
My lord, I tried, my lord. Annexure C, advancement application also was filed, my lord, but it was not entertained, my lord. They said
Your advancement application.
at Annexure C, my lord.
We'll ask the court to hear it.
My lord, one citation, my lord, of the coordinate bench. It says, my lord, that in a, may I just read, my lord? From a reading of the scheme of Order 37 and the law laid down by the Apex Court.
We are not deciding any of
No,
it.
my lord, what I'm saying, kindly permit me.
Let the court do it, what it is supposed to do.
Please,
You
my lord.
filed an
Please, my
advancement
lord.
petition, I'll ask the court to do it within a week.
Please, my lord, date may be fixed, my lord, because it was not entertained.
The petitioner is before this court, saying the following prayer. Then comes for the petition submits that when a suit is filed under Order 7.
37.
Order 37 rule, Order 37. The court has failed to follow the procedure as contemplated under Order 37, Rule 2. Rule 2.
Sub-Rule 2.
So Rule 2. So proviso to Rule 2. Rule 37, that is Order 37, Rule 2, Proviso 2. It is submitted that the court has issued the suit summons. In fact, the summons should have been followed in form number 4 in Appendix B.
Please.
It is a submission of the council that the court cannot issue a suit summons in this manner. In fact, the petitioner had filed an advancement petition to rectify the said mistaken to bring it to the notice of the court. But the same was not taken up and the matter is coming up,
8th of September, my lord.
is coming up on 8th of September,
I may be permitted to.
September. Considering the submission of the accounts to the petitioner, this court is passing the following order. The writ petition is disposed of, directing the court to hear the IA that's filed, seeking advancement of the matter. Number two, the court shall look into as per the procedure contemplated under Order 7, Rule 2.
37, my lord. Order
Sorry,
37.
Order 37, Rule 2, court shall pass appropriate, court shall pass orders. And the
Grateful, my
petition
lord.
is at liberty to advance the matter within 1 week from the date of receipt of the copy of the order.
Grateful, my lord.
Yes.
On behalf of the advocate for the petitioner. Defendant's petition in a suit for their injunction, where the plaintiff, on an application by the plaintiff, the trial court had granted an order of status quo, considering that the plaintiff had made out a case, but the plaintiff has the survey boundaries don't match, the sketch is incorrect. The trial court applied its mind and expressed some doubt, saying complete injunction can't be granted, but status quo I will definitely grant, directing both of us to maintain the status quo. The plaintiff comes in appeal before the first appellate court. The first appellate court, instead of examining the trial court's order, re-examines the plaintiff's case and supplants its own opinion on the trial court's order. That, my lord, is hit by the principle laid down in Wander versus Antox. My lords have also seen that judgment. That is what we argued before the first appellate court, that if you, as an appellate court, you should examine the trial court's reasoning. If there is anything arbitrary about the discretion exercised by the trial court, certainly there merits intervention. But it can't be that your view is different from the trial court's view and therefore your view should prevail. But the trial court has granted, the appellate court has interfered and granted a complete injunction. Pursuant to that, my lord, the plaintiffs, as is usual now, they have come with JCBs, they have come with, they disturb the possession. We have filed police complaint also. That was the urgency. My lord, we'll see the trial court's order. May I just point out first to see what is the reasoning in the trial court's order and then how the appellate court intervened. Trial court's order, my lord, is at 110. The reasoning begins, the relevant portion is at 122, page 122, para 19, 2021. Para 19, this is the trial court's reasoning. The existence of the prima facie case alone does not entitle the applicant for an order of temporary injunction. The applicant must further satisfy the court by showing that he will suffer irreparable injury if the injunction as prayed is not granted, and that there is no other remedy open to him by which he could protect himself from the consequences of apprehended injury. In other words, the court must be satisfied the refusal to grant injunction would result in irreparable injury. Para 20. The contention of defendant number 2 to 4 is that the plaintiff has mentioned false boundaries to the suit property. On perusal of the survey sketch produced by the plaintiffs, it prima facie shows that the land in survey number 8 is situated at two places, and in between the two lands, there are lands in some other survey numbers. Even the documents produced by the defendant show that the land in survey number 8/5 belonging to them. But in survey sketch, it is shown that in some vacant land is situated towards the southern side. Thereafter, the land in survey number 8 and other lands are situated in suit schedule property. Plaintiff has not produced any document.
I'm not able to understand this observation.
Well, what has happened is
Survey
this.
number 8 and other lands are situated in suit schedule property. The plaintiff has not produced any document to show that the boundaries of the suit property mentioned in the schedule of the plaintiff are correct. What is this?
What has happened is, well, the entire survey number 8, in that the defendants are saying survey number 8/5 belongs to me. 8/8 is what the suit is all about. Suit schedule property is 8/8. We are saying 8/5. When the plaintiff is showing his survey sketch, 8/5, as per his own survey sketch, is coming in between his own lands. So the court is expressing doubt, saying that if this is a survey sketch for 8/8, but the defendant's land is coming here in between, and that means the boundaries are not matching. The survey sketch created some doubt in the trial court's mind.
Clearly because the defendants are not claiming any right, title or interest over the land.
In his land.
In survey number 8/8, injunction cannot be granted.
Correct, because his land is 8/8, my land is coming as 8/5. He cannot get an injunction on the entire land. I have no claim over his land, but my land is being shown in his schedule property.
Court observes that 8/8, you are not claiming any right.
Correct, but the
But
issue
injunction cannot be granted.
issue is where is the 8/8? Because as per the documents produced by him, 8/8 is shown falling in my land. That was the doubt that the trial court expressed.
Defendant has not produced any document.
Correct. We also contended that we are creating, we have formed a layout, etc. Defendant does not produce any. Para 22. The contention of the defendant number 2 is that the plaintiffs are in possession of 10 guntas of land only in survey number 8, and also contended that boundary mentioned by plaintiff in plaint is wrong. Even the defendant number 2 to 4 have contended that land in 8, survey number 8 is Gomala land, and there is no adbus, that is that 4D by demarcation by boundaries. Hence, if an order of temporary injunction is granted, more hardship will be caused to the defendants. Further, if IA is dismissed, there is possibility of trespassing into the suit property by the defendants and other persons. Photographs produced by the defendant show that there is some building adjacent to the land and stone pillars are also erected. Here in this case, both parties are claiming their possession over the land in survey number 8, and both parties have produced some documents to show that they are in possession of some portion of the land in survey number 8. Whether the boundaries mentioned by the plaintiff in the plaint in respect of suit property and the boundaries of the defendant mentioned in the counterclaim is correct or not is a matter of trial. But if IA number 1 is dismissed, more hardship will be caused to the plaintiffs and defendants may put up some construction. If IA number 1 is allowed, defendants will be put to more hardship as they have also produced some documents to prove their possession over the counterclaim scheduled property. Latest RTC produced by defendant number 2 to 4 show that 4D in survey number 8 was cancelled by revenue authority. New 4D is not given to the suit property. Hence, in this case where both parties are claiming possession over the land in survey number 8 and both parties have produced some documents in respect of land coming in the same survey number, hence if an order is passed by directing both parties to maintain status quo in respect of the suit property till dispose of the suit, it will meet the ends of justice. This my view is based on the decision of the Honorable High Court of Karnataka passed in so-and-so case. Accordingly, I answer point number 2 and 3 partly affirmative in favor of the plaintiff. And the order reads, both parties are directed to maintain status quo in respect of suit property. It is directed that both parties shall not do any activities, including any agricultural activities.
Senior counsel, appearing for the defendant submits that the trial court, considering the case of both the parties, have granted an order of injunction, and the appellate court has granted status quo, and the appellate court had granted injunction restraining the defendants from interfering with the position of the plaintiff. And senior counsel has taken this court to the findings of the appellate court as well as trial court. The appellate court, it is submitted that the appellate court ought not to have interfered with the findings of the trial court just because another view is possible and it is contrary to the settled principles. Considering the submission, there shall be stay of operation of the order passed by the appellate court in MA number. The party shall maintain status quo as ordered by the trial court.
Grateful. Great.
So, notice hand summons.
Great.
My lord, execution petition, my lord. Execution petition, my lord. The judgment debtor is a company, my lord. Kindly go to page 50, my lord. 50. My lord, it's authorization letter which is marked, my lord. And there's a board resolution also along with the letter, my lord. Kindly see in page 50. My lord.
Now come to the impugned order.
Yes, my lord. Kindly see the 50. That's very important. In page 50. R1 is the authorization letter, my lord. It's marked. And the next page is the board resolution authorizing certain person to represent the company, my lord. My lord. Impugned order, my lord. I tried to produce few documents through IA3, my lord. Impugned order is at ink page 58, my lord. My lord, kindly go to para 13, my lord. Ink page 64, my lord.
Yes.
A careful perusal of the records discloses that the application is supported by affidavit of a person claiming to represent the first judgment debtor company. However, no resolution of board or authorization. Factually incorrect, my lord. Based on that, he rejects the whole IA, my lord. I have
filed it before the court.
I have, my lord. It's marked, my lord.
Where is that?
My lord, ink page 50, my lord. 50.
When was it marked?
My lord. R1 is the authorization letter, my lord. 51 is the letter, my lord. Please mark, my lord.
Please come. The impugned order is passed on the premise that the applicant has not explained.
Has not produced, my lord.
That the application is supported by an affidavit of a person claiming to represent the first judgment debtor company. However, no resolution of the board of directors or any authorization empowering him to file the application or swear the affidavit on behalf of the company has been placed on record. What it says that resolution, let's see.
My lord, resolved that Sri R.M. Rajan, practicing cost accountant, having office so and so, is here be and is hereby authorized to represent, attend, submit, sign necessary documents, concerned department, competing, appearing, auditing, and appearing on court cases as may be necessary. Everything is there. Madam. He says that letter only is not there. That is factually incorrect, madam.
Empowering him to file the application or swear the affidavit on behalf of the company.
Yes, my lord, I am.
It says.
It says, my lord, appearing on the court
Documents
cases as may be expedient to give statement or any submissions on behalf of
authorized
the
to
company.
represent.
Yes, my lord,
attend,
everything is there.
submit and sign the
My
necessary
lord, he says that
documents,
such a this one is not at all there.
completing pending work of accounting, auditing, statutory dues, negotiating and settling of creditors and debtors.
My lord, everything is there, my lord. He says that resolution is itself is not there.
Or swear the affidavit on behalf of the company has been placed on record and accordingly dismiss the application. When counsel has placed before the court that authorization which is already placed before the trial court, considering the submission, it shall be stay of all further proceedings, notice and summons. Yes.
Much all. For the petitions in this case. But is a diver. I have filed a suit before the trial court and the plaintiff, my lords. Plaintiff and the petitioner and the respondent are neighbors, my lords. I have filed the application under order 39 rule 1 and 2, my lords. They were constructing next to adjacent land, my lords, without leaving the setback. So I filed a injunction and then it was granted again in my favor in trial court, my lords. Subsequently, MA was filed before the appellate court, my lords. The order was passed against my favor, my lords.
Who are the parties?
My lords, petitioner and the rest.
If the person is making without leaving any setback,
Please.
you can't approach the concerned local body.
My lords, we approached, my lords, but we did not get any response, my lords. That's the reason I filed.
Then you should make them a party. Municipality also.
Please, my lords.
Not here. In the
No, please, in the trial court, my lords. Please.
That's why it's not granted. Where is the order?
My lords, order is in page number. Annexure B4, my lords, page number 96, my lords. The operative portion says.
96, sir.
Please, my lords. Operative portion is page number 106, my lords. The operative portion, my lords, paragraph number 24. The plaintiff has filed the.
Who seeks equity must do equity.
Please, my lords. My lord, I have filed my plan sanction as page number 112, my lords. There, my lords, I have constructed as per sanction plan, my lords. My only grievance is if he is also permitted to construct the building with the same as per his floor plan, let him construct, my lord.
But it is completed.
Yes, my lord. He has, but no electricity or anything has been.
Whatever it is, if it is now it is completed, ultimately you have to succeed in your suit. Come. The petitioner, plaintiff is before this court. Agreed with the orders passed in MA number 10 of 2024. The petitioner has filed a suit seeking permanent as well as a mandatory injunction. It's a case of the plaintiff that the defendant has failed to maintain the setback and made the construction. The trial court has granted temporary injunction and the appellate court has set aside the same. The court has observed that according to the plaintiff, the defendant has not left the setback towards the northern side of the Schedule B property. Looking at the photographs, court has come to the conclusion that the setbacks are maintained. The plaintiff has constructed the garage on the side of the southern side of the Schedule A property without leaving any setback. This in turn goes to show that the plaintiff herself has violated the journal regulations and bylaws of the corporation. The court has observed that the plaintiff has no legal or moral right to challenge the construction undertaken by the defendants in his property. Injunction is an equitable relief. He who seeks equity must do equity. And the dispute with regard to the journal by violation of journal regulations and bylaws of the corporation, for which the more efficacious remedy is under the Karnataka Municipal Corporations Act. The court has come to the conclusion that the plaintiff has not made out a prima facie case, balance of convenience in a favor, and there is no question of irreparable injury, and dismiss the appeal. When counsel appearing for the plaintiff submits that the court has failed to consider the photographs and also the
Transaction balance.
and also the sanction plan, which clearly shows that there is violation of the zonal regulations, and all these aspects were not appreciated by the court. It is submitted that court has given findings which are contrary to the evidence on record, which are contrary to the material on record. Next para. Then counsel appearing for the capital submits that the court has rightly considered and passed orders and no interference is called for. Next, having heard the counsel on this side, so and so. The petitioner has filed a suit for injunction and mandatory injunction restraining the defendant from making any construction admittedly. The construction is completed, and ultimately, they know at this stage there is no question of granting an interim injunction. Ultimately, it has to be decided after a full-fledged trial. In that view of the matter, this court do not find any reasons to interfere with the order passed by the appellate court. Dismissed.
Please.
May I please?
Yes.
Appearing for the counsel. Petition. There are two writ petitions, my lord. First is
Will it take time?
it may for the little 15-20 minutes it will take. I feel I am ready and subject to what. No, on merits I am ready. I am also ready.
I'm ready. The question is, he
Yes.
wants to ask for a commissioner to be appointed. This court has said that the function of the court to determine who's in possession cannot be delegated to a commissioner, the position of law.
I'll take it up tomorrow because I have a meeting and I have some more 2:30 matters are there. Yes, tomorrow in the first list. Next.
Please, interim
No,
order till then to continue. Interim order is there. That may come.
Interim order is there.
Please.
Extend it till tomorrow.
Please.
No, call till 70 you call and then stop the list. Yes, 66. Is KB matter? Who appears to the respondent? Padma.
Annexure A, B, Lordship.
Any urgency?
Yes, Lordship, because they're using the generator now itself in the hall.
Tomorrow.
Okay.
No representation on behalf of the respondents. Yes, 67.
My lord, on record counsel is mother is hospitalized. Maybe listed tomorrow or next week Monday.
Monday. Yes.
For respondent, IA for extension of time. Defendant was on 120 days. All this fairly covered.
Lords, kindly, my lords, tomorrow, my lords. Senior is held up in division.
Next week. Next.
Great.
Petitioner, my lord.
Malad, dress on at 9, 10 and 11, Malad.
My lord, suit for specific performance, my lord. The suit for specific performance, I filed an application for comparison of city LTM found on exhibit, that is the sale agreement, on the receipts, my lord, because they admit the execution of sale agreement, but they dispute the execution of the receipts which was paid, amounts were paid subsequent to the sale agreements, my lord. So that application has been rejected, my lord. My lord, they kindly come to the reasoning, my lord. At annexure A, my lord, the sale agreement is for 32,01,000, my lord.
Come to the order in queue.
My lord, the order is found at in page number 13, annexure A. The reasoning starts, my lord, at para 6, but 6 and 7 are the contention, my lord. Kindly come to para.
Page number?
Page number 16, my lord. 16.
Read from the reasoning part.
Shall read? Okay. Point, the plaintiff has filed the present suit for specific performance of contract on the basis of agreement of sale should have dated 7/10/96. The matter is posted for arguments on met. The counsel for the plaintiff filed the present application seeking to refer LTM of Bhairappa to the fingerprint expert FSL for scientific comparison with admitted and disputed documents. The counsel for the plaintiff argued the defendants have admitted the agreement of sale dated 7/10/96, which has been marked as Exhibit P32, and also admitted the LTM of their father Bhairappa in Exhibit P32. But the defendants have disputed the LTM of Bhairappa in Exhibit P1, 4 to 10, P12 and 18 in the written statement as well as in the cross-examination. In view of the admission and denial of serious dispute as arise on with regard to identity and genuineness of LTM of Bhairappa on the receipts, and it is essential.
Why can't it be allowed? Yes, counsel for the caveator.
Malad, in fact, the transaction of the year 1996 and in the year 1997, that agreement has been terminated, Malad. That contention has been taken in the written statement also, Malad. Lordship, kindly peruse the page number 15 of the order, which is passed by the trial court.
No, why it can't be sent for expert opinion?
Malad, that signature has subsequently they have created, Malad. They have created, Malad, in fact, Malad, one submission, Malad, one submission. Malad, that agreement has been terminated, and that termination has been, they have given reply also. Now, only after the completion of the cross-examination, now the matter is posted for the argument. Now, at this stage, they have filed this application. Malad.
Then counsel for the petitioner submits that an application that's filed seeking to send the refer the LTM of Bhairappa on Exhibit P32, agreement of sale dated 7/10/1996 with LTM found on Exhibit P1.
There are several receipts.
Exhibit P4 to 10 and Exhibit P12 to 19 to the competent fingerprint expert of the FSL for scientific comparison is denied. It is submitted that the reasonings that are given by the court are not, there are no cogent reasons are given by the court. And even if this is allowed, no hardship would be caused to the defendant. And further, it would be easy for the court to decide the dispute between the parties concerning the subline. Counsel for the respondents has caveator has submitted that the court has rightly passed the order and no interference is called for. Considering the submission, the counsel stay of all further proceeding. Yes.
Number 70.
Is the only respondent?
No, my lord, there are several other respondents. I will take notice to all the respondents, my lord.
All are necessary?
All are necessary, all are contesting.
He is appearing for?
He is appearing for caveator respondent number 9 to 11.
R4, remaining all other respondents and submits. Yes, 71.
Number 70.
Even the appeal for the petitioner. Lords, order 39 rule 1 and 2, my lords, dismissed. Lords, MA also confirmed. Lords, there is one partition deed, my lords, which the entire crux of the case is. My lords, may have it Monday, it is in Kannada. Lords, I'll
List on Wednesday, next Wednesday.
Please.
Monday, my lord.
That can be Monday, my lords, because there is also this.
The 70, stop the list till 70.
History may be directed to reflect my name properly as stated in the Wakalat, my lord.
The counsel for the respondent submits that the name is wrongly printed and it should be as per the Wakalat. Yes.
That's Wednesday, my lords?
Wednesday.
There is one submission,
So-
my lords. Serial number 73, my lords. Because there is a arrest warrant that has been given to the JDR, my lords. It is pertaining to the said IA, I have just challenged before this honorable court, my lords. Because I have a Supreme Court judgment as well, my lords. I'll just take only 2 minutes, my lords.
It will come tomorrow.
Ahead of the list, my lords. Let it be listed ahead of the list, my lords, tomorrow.
No, it will start from here only.
Okay. Okay.
From tomorrow, let it be from 71. Yes, continue this list from 71. Where is that?
Much obliged.
100 and?
Much obliged.
108 notice, 109 notice. 109, there is no delay. Only 108 one notice. Yes, all other matters, let it come in the first list. After these matters, let the fresh matters add. Call the 230 matters.
30 mentioned.
My lord, may I make one submission, my lord? May I make
Please
one?
continuing, yes.
Till number 83.
Yes.
My lordship, appealing for the petitioner in this case, my lordship. Filing the matter. Sorry.
That I appeal for petitioner. That this is a revision arising out of a petition filed under section 6 of the specifically fact. My lord, the allegation is that, my lord, I have dispossessed her illegally. Now, my lord, if the plaint averment itself is read, it doesn't show that I have illegally dispossessed. 83.
Have you informed the caveator?
Well,
that
the
matter
other
will be
day he
taken?
was present, and
Oh, you have to
I
tell
tried
him.
to
How will
argue.
he
And
know?
What?
How will he know that this will be taken out of turn? Unless you inform him, he'll follow the list.
Yes.
This is matter tomorrow.
Well, not tomorrow, my lord, day after.
Day after
tomorrow, I'm
tomorrow.
out of station.
Yes, next.
Till number 104.
In the first list, day after
Lord, I
tomorrow.
appear for the petitioner in this case.
Huh?
Petitioner in this case.
This is
104.
104.
Lord, a common order was passed on for production of documents and recall and reopen of the defendant's case, my lord. Petitioner is the contestant defendant before the trial court. If he files a recall application, reopening of his case and production of the documents which are supposed to be marked on his behalf, the said application came to be rejected by way of common orders on 6/8/2026, my lord. The impugned order is at page number 61, my lord. There are 8 documents. Your lordship may kindly have page number 62. 8 documents by way of production of documents.
the order sheet demonstrate that argument for the plaintiff were concluded on 7/7/26.
Please, my lord.
Repeated adjournments are granted as a last chance to defendant number 2C to submit final arguments. Instead of addressing arguments, the applicant present so and so. The primary explanation tendered that talks of compromise.
Please, my lord, he is a contesting defendant. He filed a chief examination in the 2022. Subsequently, my lord, the matter was posted for cross-examination. Thereafterwards, my lord, plaintiff has filed the injunction application, and one more defendant has filed IA number 17 for amendment, my lord. The trial court took almost 4 years for deciding on said applications. Thereafterwards, when the matter was posted for arguments of the plaintiff, by noting the said defects, my lord, he has filed a recall application for production of 8 documents, my lord. The suit for declaration of title and permanent injunction of the plaintiffs, contending that defendant number 1 has executed a. Please, my lord.
However, with that kind of speed, you make them as submissions.
Please.
Nothing is going to work out here. I have to understand, isn't it?
Please.
So, what were you doing from 7/7 to why till 7/7/2026? Why this application is not filed?
But there were 4 applications pending, my lord, before the trial court. IA number 16 to 20.
When have you filed?
That was filed by the plaintiff when the matter was posted for arguments of the plaintiff before the trial court by taking the cross-examination of the present petitioner as nil, my lord. Then the matter was posted for arguments. Subsequently, my lord, plaintiff and defendant number 3 files 4 applications. That the trial court took almost 4 years for deciding on the said applications, my lord. Thereafterwards, in the year 2020, on the July 17th, my lord, the present petitioner, he is the contesting defendant. He is the only contesting defendant, my lord.
Oh, your matter is coming up for final arguments. That's what the court says. What you submit is contrary to what the court has observed.
Your lordship, kindly have the reasoning given by the trial court at page number 62.
I'm looking at it.
There are para number 3, my lord. There are 8 documents that has to be supported to be marked.
Come to para 7.
Please, my lord.
Read it.
The order sheet records demonstrate that arguments of the plaintiffs were concluded on 7/7/2026. Till 7/7/2026, prior to that, my lord, 4 applications were pending before the trial court. So that is the reason, my lord, the present defendant has not filed recall application. He filed a chief examination, my lord, but he has not produced a document as per the defense he has contented in the written statement. Lord, his scheduled property document has been obtained by the defendant number 1, said to be the GPA, my lord. Through GPA, my lord, defendant number 1 executes a sale deed in favor of the plaintiff. On the said sale deed, my lord, he files a suit for declaration of title and a permanent injunction. Prior to execution of sale deed, my lord, the present contesting petitioner, he had issued a registered notice to the defendant number 1, stating that I have not executed any GPA in favor of you. If at all such a created document is in existence, the same will get cancelled by receipt of this registered notice, my lord. Subsequently, defendant number 1 executes a sale deed in favor of the plaintiff. That document, my lord, postal receipts and the the intimation letter that was sent to the vendor of the plaintiff has to be marked. That has been produced at Annexure J series, my lord. And also 7 documents were supposed to be marked, my lord.
All that stage is over. That is what I'm
And the
saying.
matter was posted for final arguments, my lord. Prior to that, my lord, 4 applications were pending. So when we have noted that documents are
Order
not,
sheet. Where is the complete order sheet?
Annexure A, my lord.
Let's see. Come to those dates.
Lord, your worship may kindly have a page number 29, my lord. That is when the present petitioner has led his evidence. Page number 29, my lord. 16/6/2022 order sheet, my lord.
Oh.
Defendant number 2C, that is the petitioner, my lord, filed his affidavit.
Your DW1.
DW1, contesting defendant, my lord. There are nobody is contesting before the trial court. Subsequently, my lord,
DW1 absent, praise time for further. DW1 present.
prior to that, my lord, presiding
praise
officer was on
time.
leave, my lord.
DW1 absent. Counsel for so and so absent. DW1 absent. DW1 absent. DW1 absent. DW1 absent.
But since my lord, the GPA was forged by the defendant number 1, the plaintiff has come up.
Counsel for defendant praise time. Counsel for defendant praise time. Counsel for defendant praise time. Counsel for defendant praise time.
On 31st of 10/2022, one application came to be filed, my lord. Thereafter, I number 16, my lord, by the plaintiff.
Counsel for defendant everywhere. Counsel for defendant praise time. Defendant number 1 absent. Counsel for defense of so and so. He'll file memo.
My lord, your worship may kindly have page number 35, my lord, order sheet dated 31/10/2022. 31/10/2022, my lord. On the said day, my lord, the plaintiff files an application, IA number 16, my lord. Thereafterwards, my lord, the case went on deciding the application IA number 16, 17, 18, and 19 till, my lord,
Notice the
1/7/2026, my lord.
Yes.
Lord, matter is posted tomorrow for final arguments of the defendants, my lord.
Let it.
Lord, not even a single document has been marked on behalf of the petitioner. Lord, kindly have, Lord, tomorrow there is a final argument of the present petition. Defendant, my lord.
Let it go on.
Lord,
Yes.
Lord, you would be put to great prejudice, my lord.
Yes, next.
Lord, one opportunity may be given on the same day, my lord. You tender his evidence, and my lord, and I will.
Yes, next.
My lord, stay, my lord. But tomorrow, my lord, interim order may kindly be granted.
No.
But I'll take out a notice to the plaintiff contesting plaintiff.
Yes.
But one opportunity, my lord.
Yes,
Tomorrow
next.
it has been
Next.
posted for different final arguments, my lord.
Jagan Mohan MT for petitioner K. Bhavana.
I appear for the
For
respondent.
interim.
Yes.
Present application is filed to recall the order dated 3/3/2026, my lord.
Where is that?
IA number 102/126.
When was this filed? 29th August 2025. Why this matter is called? 25 matter, what is urgency at 2:30?
No, my lord, day after tomorrow it is posted for judgment, I think, I suppose.
When is
Filed
it
application.
When is it posted for judgment?
Day after tomorrow, 19th.
It is coming up tomorrow. When was it posted? When was the date earlier given for judgment tomorrow?
My lords, in fact, their application is under the section 92 miscellaneous petition. That miscellaneous petition has already been disposed of, because of which this honorable court had dismissed their petition as being infructuous. Now they have sought to recall that order. The judgment
Lord,
is in the actual section 92 petition where they not even filed any application.
Lord, they have filed the miscellaneous petition to just to obtain the permission to prosecute the OS number 136 of 2026. My application dismissed in the miscellaneous, but it can be continued in the OS because that miscellaneous is only for permission to prosecute the case.
That goes beyond the scope of the prayer
After
in this
taking the
petition.
publication, paper publication, we filed an implead application. The petitioners filed an implead application. That was rejected because of your not necessary party. That is here challenged here with. After that miscellaneous allowed permission granted, the OS is continuing. So we can also implement that also. But we moved matter many times, but it's not reached. Day after tomorrow is posted for judgment.
That's
Yes.
why I said posted for judgment. There is no question of any further order.
Lord, we seek. We prayed for interim order, that is not granted, only notice ordered. We moved many times matters not reached. We put up everything in memo, but it's not.
Memo is the land counsel for the petitioner submits that. The writ petition is posted, the miscellaneous petition number 1113 of 2024 is posted. When was it dismissed?
On 19 December 2025.
When did you file this IA to recall this order?
No, recall that this present writ petition dismissed on 3/3/2026 as infructuous. You have not made any submission that. But actually,
None appears for the petitioners and respondents.
because what happened, this case was originally posted
When
before.
did you file the IA? I'm asking. IA to recall this order. That is also not filed.
Yeah, record filed.
When is it?
On
My lords, I was served the copy on
9/3/2026 actually.
You that.
My lords, one submission. The miscellaneous petition having already been dismissed, the prayer in the present writ petition that they have sought is in respect of that miscellaneous petition. So now no prayer survives.
I'm not
for
granting any
consideration.
order now.
Please.
A coordinate bench of this court has dismissed this matter for non-prosecution. Now the present IA is filed to set aside that order. Considering the reasons stated, the order dated so and so is recalled and the writ petition is restored. Then counsel for the petitioner submits that now the miscellaneous petition is posted for judgment and he has argued on the merits of the matter in the light of the judgment of the division bench in so and so. Once a matter is posted for judgment, question of passing any other orders would not arise. Accordingly, the writ petition is dismissed.
114.
What is that? 100
I am for the respondent, my lord.
Vijay Kumar, Lakshmikant K.
My lord, this honorable court, while granting the stay, has directed the petitioner to deposit the arrears of rent before the trial court, my lord.
Have you informed him that the matter is going to be taken up? Petitioner.
No, my lord, I didn't.
I don't understand this. Out of the turn, you want the court to take up the matter and you just come and you will take the order. No notice to him is required.
My
Let
lord,
it be in the list tomorrow. What is that pass? Let it be tomorrow.
Serial number 104, notice to R2 to 11 may be kindly be discussed.
Tell me.
The lordship grant permission, serial number 95, my lord.
All are done?
The lordship grant permission.
Yes.
Serial number 95 may be called tomorrow, my lord. Some urgency is there.
All matters will come tomorrow in the list. It will start from 70.
Please, my lord.
So please don't make any mentions, none of you. Yes.
My lord, serial number 21 in list 2, my lords. Suit is of the year 2002, my lords. The petitioner has obtained interim order before this court, my lord.
Court officer, madam.
ನಾಳೆನೂ ಹಾಕೊಂಡು ಕುಂತಾರೆ.
The second list.
ಕೊಡ್ತಾರೆ ಇವಾಗ. ನಾಳೆ ಬರುತ್ತೆ ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಎಲ್ಲ.
ಹೇಳಿ ಸರ್. ನಾಳೆಗೆ ಎಂದು.
List number 2, madam.
ಹೇಳಿ ಸರ್. ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಎಲ್ಲ ಡೇಟ್ಸ್ ಹೋಗುತ್ತೆ ಸರ್.
What do you mean?
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸರ್ ನಂಬರ್ 97
ಹೇಳಿ ಸರ್ ಏನ್ ಬೇಕು? 97 ಏನ್ ಬೇಕು ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಅದೊಂದು ಹತ್ರ ಡೇಟೆ ಕೊಡಿ. ಅದು ಅಪೀಲು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಫೈಲ್ ಮಾಡಬೇಕು. ಲಿಬರ್ಟಿ ತಗೋಬೇಕು ಮೇಡಮ್ ಅದು.
ಅದೇ ಸರ್ ಈ ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ. ನಾಳೆಗೆ ಮೆಮೊ ಕೊಡಿ.
ಹಾ ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
ಅದೇನೆ ನೀವು ಆತರ ಮೇಂಟೈನಬಿಲಿಟಿ ಇರೋದೆಲ್ಲ ಕನ್ವರ್ಷನ್ ಆ ತರದೆಲ್ಲ ಇತ್ತು ಅಂದ್ರೆ ಮೆಮೊ ರೆಡಿ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ ಅದು ಆರ್ಡರ್ ಆಗ್ಬಿಡುತ್ತೆ. ಇಲ್ಲಾಂದ್ರೆ ಸುಮ್ನೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್.
ಆಗ್ಲಿ ಮೇಡಮ್ ಆಗ್ಲಿ.
ನಾಳೆಗೆ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಹಾ ಆಗ್ಲಿ ಮೇಡಮ್ ಥ್ಯಾಂಕ್ ಯು.
ಆಯ್ತು.
ಮೇಡಮ್ CRP 77 ನಾಳೆ ಬರುತ್ತಲ್ವಾ?
ಯಾವ ಲಿಸ್ಟ್?
ಫಸ್ಟ್ ಲಿಸ್ಟ್
ಒಂದ್ ನಿಮಿಷ.
70
ಅದೆಲ್ಲ ರಿಪೀಟ್ ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್.
ನಾಳೆ
ಆಲ್
ಬರುತ್ತೆ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹೌದೌದು, ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ ನಾಳೆಗೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Madam, just to
26 ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಎಲ್ಲಿದೆ ಅದು ಟುಡೇ ವರೆಗೂ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲ್ಲಿ ಇದ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ, ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ. ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ನಾಳೆ ಬೇಡ ಅನ್ನೋರು ಮಾತ್ರ ಹೇಳಿ. ನಾನು ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಇನ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1. ವೆಯ್ಟ್ ಮೇಡಮ್, ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಅಲ್ಲಿ
Madam, list number 1, CL-91.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಕಮಿಟಿ ರಘುನಾಥ್ ಸೋಮಶೇಖರ್ ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಇವ್ರೆ? CH ಮೆಮೋ ಮಾಡಿದೀರಾ ಯಾರೋ? ಅದನ್ನ ಕೊಡೋದಿಲ್ಲ ಡೇಟ್, ನಾಳೆ ರಿಪೀಟ್. ಅದೇ ನಾಳೆ ರಿಪೀಟ್ ಅದು. ಆಯ್ತಾಯ್ತಾಯ್ತು, ನೋಡ್ತೀವಿ ಇವ್ರೆ. ಅದಕ್ಕೆ ನೀವು ಕೇಳಿದ್ರು ಐ ವಿಲ್ ಗೋ ಟು ದಿ ಲಿಸ್ಟ್. ನಮಗೆ ಇಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತೆ. 89 ಏನ್ ಹೇಳಿ? 89 ಹೇಳಿ. ಆಮೇಲೆ ಮಾಡಿ.
Madam.
89
Madam, 91.
ಅಲ್ಲ ಇವ್ರೆ ಮೇಂಟೈನಬಿಲಿಟಿ ಇದೆ. ಇದು ನಾಳೆ ಬೇಡವಾ ನಿಮ್ಗೆ? ನೀವು ಪೆಟಿಷನರ್ಗೆ
106 first list.
25 ಆಯ್ತು. ಆಮೇಲೆ
106 first list. 106 Madam, first list. Madam, 91.
ಏನ್ ಬೇಕು?
25 ಕೊಟ್ಬಿಡಿ.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಇವ್ರೆ. ಆ ತರದ್ದೆಲ್ಲ ಅಂಕೆ ಕೊಡಕ್ ಆಗೋದಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಎಲ್ಲ ಪೆಂಡೆನ್ಸಿ ಇರೋದ್ನೆಲ್ಲ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಬೇರೆ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ಆರ್ ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಅದನ್ನ ಮಾತ್ರ ಹೇಳಿ. ಅದು ಶಾರ್ಟ್ ಡೇಟೇ ಕೊಡೋದು ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋದಿಲ್ಲ.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನೋಡಿ ಮೇಡಮ್.
78 ಏನ್ ಬೇಕು ಹೇಳಿ ಸರ್? ಅದೆಲ್ಲ ನಾಳೆ ಹೇಳಿ. ಆಮೇಲೆ
Madam, 86.
86 ಎಲ್ಲ ನಾಳೆ ಸರ್ ಹೇಳಿ. 86 ನಾಳೆ ಎಂಟ್ರಿ ಮಾಡಿ.
ಮೇಡಮ್, ಅದು ಅದರಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಸ್ವಲ್ಪ ಲಾಂಗ್ ಡೇಟ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
ಅಲ್ಲ ಸರ್, ಲಾಂಗ್ ಡೇಟ್ ಅಂತಲ್ಲ, ಅದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಾ?
ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿಲ್ಲ ಮೇಡಮ್ ಅದರಲ್ಲಿ.
ಅರುಣ್ ಪ್ರದೇಶ್.
ಹೌದು ಅರುಣ್ ಪ್ರದೇಶ್.
ಅಲ್ಲಿ ಅದರ್ ಸೈಡ್ ನೋಟಿಸ್ ಆಗಿ ರೆಪ್ರೆಸೆಂಟ್ ಆಗಿದ್ದಾರೆ BS ರಾಧಾನಂದನ್ ಅಂತ.
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಮೇಡಮ್, ಅವರೇ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅದು ಇದು ಇದರಲ್ಲಿ.
ಆ ತರದ್ದೆಲ್ಲ ನಾವು ಡೇಟ್ ಕೊಡಲ್ಲ. ನಾಳೆ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೇಳಿದಾರೆ, ರಿಪೀಟ್ ಮಾಡ್ತೀವಿ ನಾವು.
ಸರಿ ಮೇಡಮ್, ಆಯ್ತು. ಮೇಡಮ್, ಲಿಸ್ಟ್ 191. Hello.
Court officer, madam. Court officer. Court officer. Here's the name.
Court officer. Court officer.
Court officer.
Madam, Madam, serial number 91, list 1.
Court officer,
कोर्ट ऑफिसर लिस्ट नंबर 2 सीरियल नंबर 1 रीच आया था.
हाँ.
ये क्लाइंट कौन है आइडल वाला?
Naseem.
Can you send me his number?
Yeah.
कंस्ट्रक्शन चल रहा है। हाँ बस वही बिल्डिंग है, परफेक्ट परफेक्ट, और एक नीचे आ ठीक है ठीक।
बाय बाय।
जब टाइम लगे देख रही हूँ, अगर कुछ और भरना है तो मैंने सब भर दिए, सारे डॉक्यूमेंट्स हटा देते हैं, डायरेक्टली भेजा जाता है।
डेट ऑफ बर्थ
ठीक है भाई, वो एक चीज है, पूरा एक बार देख के एक बार ही में बता दियो सब।
हाँ ठीक है।
पेंसिल से मार्क कर दियो जो भी।
बाय बाय।
Court officer, sir.
ಅವರಿಗೆ ಆನ್ಸರ್ ಮಾಡಿ ಮೇಡಮ್, ಅವ್ರು ನಾವೆಲ್ಲಿ ಇದ್ದೀವ 2 ಊರಿಂದ ನಮಗೆ ಆನ್ಸರ್ ಮಾಡೋರು ಯಾರು ಕೇಳಿದವ್ರಿಗೆಲ್ಲ ಆನ್ಸರ್ ಮಾಡ್ತಾರೆ. ಲೀಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 14 and 22 ಒಂದು ಡೇಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದೆ. ಎಲ್ಲಿ ಕೊಟ್ರೆ? ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಅಂತ ಕರೀಲ್ಲ ನೀವು. ಹಾ ಯಾವತ್ತಿಗೆ ಯಾವತ್ತು ಕೊಡ್ತೀರಾ?
31/8 ಇನ್ನೊಂದು 1/9.
ಅಲ್ಲ 2/31/8 ಕೊಡಿ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಮೇಡಮ್, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
ಇದು 31/8 ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ ಮೇಡಮ್?
31/8 ಸರ್, ಪದೇ ಪದೇ ಅದನ್ನೇ ಹೇಳಿದ್ದು, ನಾನು ಡೇಟ್ ಅಸೈನ್ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇರ್ತೀನಿ. ನಾವು ಲಿಸ್ಟ್ ಅಪ್ಡೇಟ್
ಈಗ 14 ಯಾವ್ದು ಕೊಡ್ತೀರಾ?
31/8 ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ.
14 ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
31/8 ಮತ್ತೆ 15 and 16 ಎರಡನ್ನು 1/9.
Madam, list number 2 serial number 5 ಎಷ್ಟು? List number 2 serial number 5.
22 ಯಾವ್ದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಮೇಡಮ್?
ಸರ್ 22 1/9ಕ್ಕೆ.
1/9
5 serial number 5 ಎಷ್ಟು?
ಸೀರಿಯಲ್ ನಂಬರ್ 31 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
ಇದೆ ಹೌದು.
serial number 5 ಎಷ್ಟು?
ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಡೇಟ್ ಎಲ್ಲ ಅಪ್ಡೇಟ್ ಮಾಡ್ಕೋತೀವಿ, ನೋಡ್ಕೊಳ್ಳಿ ಮೇಡಮ್. ವಿ ವಿಲ್ ಗಿವ್ ದ ಡೇಟ್ ಅಂಡ್ ಯು ವಿಲ್ ಸಿ ದ ವೆಬೋಸ್ಟ್ ಆಗಿರೋ.
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೇಡಮ್, ಇದೊಂದು ಪ್ಲೀಸ್.
ನಾವ್ ಯಾವ ಅರ್ಜೆನ್ಸಿ ಡೇಟ್ ನಮ್ ರೆಸ್ಟ್ರಿಕ್ಷನ್ ಇದೆ
ಮೇಡಮ್. serial number 40. ಮೇಡಮ್, serial number 46 list 2 ನಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ, ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಅದನ್ನ ಹೇಳಿದ್ದೆ. 27
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
27 ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. No, it was listed before filling the justice last year. You ಹೇಳಿದ 22 ಅಲ್ವಾ? 27 ಸರ್.
ಚಂದ್ರ ಪ್ರಭಾತಿ ಎಸ್.
ಹೌದು, ನಾನು ಫಾರ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಇದೆ ನೋಡ್ತೀನಿ ಸರ್, ನಾನು ಬಿಟ್ಬಿಟ್ಟೆ. ಅದರ ಇದೆ ಇಂಟ್ರಿಮ್
18/9 ನೆಕ್ಸ್ಟ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, serial number 46 list 2 ನಲ್ಲಿ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇದೆ, ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಬೇಕು ಮೇಡಮ್.
ಹೇಳ್ತಾರೆ ಮೇಡಮ್, ಒಂದು ನಿಮಿಷ ಅಪ್ಡೇಟ್ ಮಾಡ್ತಿದ್ದೀನಿ. 5 ನಿಮಿಷ ಅಪ್ಡೇಟ್ ಆದ ಹಿಡ್ಕೊಂಡು ಹೇಳ್ತಾರೆ.
31 ಲೈವ್ ಇದೆಯಾ ನೋಡು.
31 ಯಾರು?
15 15/9 15/9
ನಿಮ್ದು 15/9.
ಅಯ್ಯೋ ಇಲ್ವಾ?
ಒಂದು ನಿಮಿಷ.
33
34 ಇದೆ.
16/9 ಎರಡೆರಡು ಎಲ್ಲಾನು ಒಟ್ಟಿಗೆ ಒಂದೇ ದಿನ ಕೊಡೋಕ್ಕೂ ಬರಲ್ಲ, ನಾವು ನೋಡ್ಬಿಟ್ಟು ಮಾಡ್ಬೇಕು. ಅದನ್ನ ಇನ್ನೊಂದು 35 ಅದೇ ನಾವು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮ್ಯಾಮ್, serial number 46 list 2 ನಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ, ಅದನ್ನ ದಯವಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ರಿ.
IO wherever IO is there and till existing today ಅಲ್ಲೆಲ್ಲ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
Okay, thank you so much ma'am. Thank you.
ಒಂದು ನಿಮಿಷ ಇರು, ಅದೇನ್ ಮಾಡ್ತೀರಾ? 15 16 17 9 ಇದು 17/9 ಐವ ಇದೆಯಾ ಅದನ್ನು 17/9 ಒಂದು 5 ಮ್ಯಾಟ್ರ್ ಕೊಡು ಆಮೇಲೆ 41 42 43 ಅದರಲ್ಲೂ ಐವ ಇದೆಯಾ 21/9 ಕೊಡ್ತಾರೆ ಇದು ನೆಕ್ಸ್ಟ್ 44ರಲ್ಲಿ ಇದೆಲ್ಲ 21/9 ಕೊಡು 48 3/9 ಕೊಡೋದು 48
Madam, list 1, serial 91.
ಐವ ಇದೆಯಾ
5 ನಿಮಿಷ ಇದೆ ಸರ್
49ರಲ್ಲಿ ಐವ ಇದೆಯಾ 7/9 ಕೊಡು ಫೈನಲ್ ಇಯರ್ ಇದು
50ರಲ್ಲಿ ಐವ ಇಲ್ಲ
50 51ರಲ್ಲಿ ಎರಡರಲ್ಲೂ ಐವ ಇಲ್ಲ 50ರಲ್ಲಿ
ನಂಬರ್ 50 ಶಾರ್ಟ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಕ್ಕಾಗುತ್ತಾ ಮೇಡಮ್
27 8
27 8
51 ಐವ ಇದೆಯಾ ಅದರಲ್ಲಿ ಐವ ಇದೆಯಾ ನೋಡ್ರಿ ಅವರೇನೋ ಸಬ್ಮಿಟ್
Here.
ರವಿ ನಂಬರ್ 13 ಹೇಳಪ್ಪ ಲಿಸ್ಟು ಸೀರಿಯಲ್ ನಂಬರ್ 5 3/9
Madam,
ಒಂದ್ ನಿಮಿಷ ಇದೆ ನೋಡ್ಬೇಕದ್ನ ಇಲ್ಲ
Officer madam.
ತಗೊಂಡು ಹೋಗಿಲ್ಲ ಯಾರು ನೀವು ರೆಸ್ಟೋರೆಂಟ್ ಅದು ರೀಚ್ ಆಗಲ್ಲ ಬಿಡಿ ನಾಳೆಗೆ ಮತ್ತೆ ಲೇಟ್ ಆಗೇ ಬರುತ್ತೆ ಅದು ಅಲ್ಲ ಡಿಲೇ ಇದೆ ಇವ್ರೆ ಡಿಲೇ ಕಂಡೋನ್ ಆಗ್ಬೇಕು ಮೇಡಮ್ ರಿಪೀಟ್ ಮಾಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ ಯಾವತ್ತಿಗೆ ಬೇಕು 25 ಅಂತ ಹಾಕಮ್ಮ ಇದು ನಂಬರ್ 106
ಮೇಡಮ್ ಇದು ನೋಡಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ಲಿದೆ ನೆಕ್ಸ್ಟ್
court officer madam.
ಅಲ್ಲ ಇಲ್ಲಿ ಏನಾಗಿದೆ
Madam.
ಇಂಟ್ರಿ ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಸರ್ ಬಟ್ ನಿಮ್ ಸಬ್ಮಿಷನ್ಸ್ ನ ನೋಟ್ ಮಾಡಿದ್ರು
Officer madam.
ಏನಾಗಿದೆ ಗೊತ್ತಾ ಅಲ್ಲಿ ಮೇಡಮ್ ಹೇಳಿದ್ದಾರೆ ಅಟೆಂಪ್ಟ್ ಟು ಫೈಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಟ್ ದಿ ಲೇಟೆಸ್ಟ್ ಸ್ಟೇಜ್ ಹ್ಯಾಸ್ ಬಿನ್ ರೈಟ್ಲಿ ರಿಜೆಕ್ಟೆಡ್ ಬೈ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಯಾರದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಟ್ ಈಸ್ ಮೇಡ್ ಕ್ಲಿಯರ್ ದಟ್ ನಿಮ್ದು ಇಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಈ ವೆಕೇಟ್ ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ ಮೇಡಮ್ ಪೆಟಿಷನರ್ಸ್ ರಿಮೈನ್ ಆಬ್ಸೆಂಟ್ ಆನ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹೋಗಿ ಬಿಡಿ ನಮ್ಗೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದರಲ್ಲಿ ನೋಡು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡು ಒಂದು ಫೈಲ್ ಯಾವ್ದದು ಸೀರಿಯಲ್ ನಂಬರ್ ಲಿಸ್ಟ್ ಟು ಲಿಸ್ಟ್
ಇದು ಚೇಂಬರ್ ಕಳಿಸಬೇಕು
ಇದು 27 ನಲ್ಲಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಒಂದ್ 3/9 ಹಾಕ್ಬಿಡೋದು ಅವ್ರೇನೋ ಬೇಗ ಮುಗಿಸ್ಕೊತಾರಲ್ಲ
Officer madam.
ಸರ್ ಹೇಳಿ ಸರ್ ಸರ್ ಅದು
Madam, list 1,
ಹೇಳಿ.
serial 91. The matter is coming on 27th August. Was listed today also.